Okay, military precision timing here. So good morning. Welcome to day 2 of SEC Speaks. What a day yesterday was. We heard from the chairman, the commissioners. We heard the rulemaking agenda from IM, Corp Fin, Trading and Markets, and the power of data from DIRA, which was really interesting. Today, we're going to now shift to the first panel, which is enforcement. Before I introduce the panel and the panel head and commentator, I have a couple of reminders for you all. One is that if the press has any follow-up questions for the staff, reach out to the Office of Public Affairs, and they'll get you the information you need. Apparently, the commentators are on their own, so you can hit them up directly. And also, the views that you're going to hear today, and you're going to hear the disclaimers, and they're much better articulated by the people making them than me, but that the views are their own. So the first panel is going to be led by Sam Walden, who's the acting director just recently of the Division of Enforcement. Before becoming the acting director, Sam held basically every position in enforcement you can hold, which I got to leave even a little confused kind of trying to articulate them. But acting director, acting deputy director, chief counsel, assistant chief counsel, and staff attorney, all in the Division of Enforcement in the last couple of years. He did spend time in private practice, including a partner at Proskauer and Baker Botts. Then the commentator, I'm going to welcome back Dan Gallagher, who is most favored commentator at this point. I don't know that he needs another introduction, but just to remind you, he is the Chief Legal Compliance and Corporate Affairs Officer of Robinhood Markets. This time I'm going to remember the CLE credit magic words, which is before starting this panel, I ask that you please consider the comments of this session's panelists. Okay, I'm really looking forward to this panel. I started my career in enforcement, and we were talking in the green room about how much fun it is to actually build your case and that aha moment when it all comes together. And I think things have probably changed since I was in enforcement, and as we heard yesterday, DIRA has a lot of new tools that really help add some more credibility maybe, and I'm sure accelerate the pace of these investigations. So enjoy.
Thank you, Commissioner Unger. Is it on?
Keep talking.
Okay. Thank you, and welcome everyone to day 2 of SEC Speaks. You were probably expecting someone with more hair to be speaking here, but here we are. I have one additional piece of housekeeping before we begin. The views of the panelists here today, for each of them, they are in their own official capacity as members of the SEC staff. They are not the views of the commission, commissioners, or the staff. And also, to the extent we talk about any cases, it should be understood that we're talking about the facts as alleged by the commission in the complaint or as found in the commission's order. With that out of the way, I will also introduce the remaining panelists who are joining me today. Got Mark Cave, the Chief Counsel, Nick Grippo, Chief Litigation Counsel, Ryan Wolf, Chief Accountant. There's a theme there. And we hope to cover a good overview of what we've done the past year, and also talk a little bit about our priorities right now, where we're devoting our resources, and where we see things going. But before I do, and I also want to thank Commissioner Gallagher again for joining us. And what we're going to try and do is, as we go through this, take some breaks. We'll see how this works, and let Commissioner Gallagher ask us some questions along the way, and then we'll also hopefully leave some time at the end for questions as well. But please go easy on us. So before getting to the meat of it, I do want to say Thank you to the chairman for giving me the opportunity to lead the division yet again as acting director. It has been an unusual, unique period of time of transition for the division. But I will say the one constant throughout has been the staff and their hard work, dedication, commitment, professionalism, resilience, all the adjectives you could put together. I am incredibly honored and very, very lucky to be able to work with them every day. And I'm also so thankful for them and for all they do. I'm also going to steal a line from something that the chairman said yesterday to staff, and that is that acting does not mean inactive. And we've accomplished a lot the last 7 months with Judge Ryan, and we've built a lot of good momentum. My instructions, my marching orders are clear. We are to keep doing what we've been doing, full steam ahead, and so that's what we're going to do. So with that, talk a little bit about our priorities. First, want to talk at a very high level about how I think this commission views an effective enforcement program. I know folks like to focus on the numbers, the number of cases we bring, the size of penalties, the total amount of disgorgement. I get it. I've never thought that those are particularly good ways of evaluating the effectiveness of an enforcement program. I know that Chairman Atkins does not. We have been directed to focus on quality over quantity, bringing cases against those who lie, cheat, and steal, and so that's what we're going to do. Getting a little bit more granular about priorities, what does that look like? I'll start with investor protection. Protecting investors, going after those who harm investors. To the extent we can get money back to harmed investors, that is job one, and that is our guiding principle. It also means focusing on the core types of cases we have brought in enforcement historically. Insider trading, accounting, financial disclosure cases, offering frauds, market manipulation cases, breaches of fiduciary duty by investment advisors. Those are the types of cases that are going to be a focus. We're also going to focus on continue the work of our cross-border task force. That is a group that has been working to address the rampant dumps, the pump and dumps we've seen from certain foreign-based U.S. issuers. We're going to continue that work. I do want to say when we talk about fraud, when we talk about investor harm, I think that my sense is that folks think that those are the only types of cases we will bring. And what I'll say to that is that those are cases that are going to be the highest priority, as they should be. But we will continue to bring non-fraud cases in the right circumstances. So if you are someone who makes an honest mistake, recognizes it's a mistake, fixes the mistake, takes steps to remediate, improves internal controls, reimburses harmed investors, that's not something that's likely to result in an enforcement action. On the other hand, if you're someone who engages in multiple mistakes, doesn't think it's a mistake, covers up the mistake, doesn't take steps to remediate, that's a different story. And I'll also say that not all non-fraud charges are the same. Some of our non-fraud regulations, rules are incredibly important in that they protect against having fraud or investor harm occur in the first place. The custody rule is a perfect example of that. We're going to continue to bring those types of cases. We're just going to be much more thoughtful about when we do that. So the last thing I'll say about priorities is that we will continue to focus on working with our counterparts, working in parallel. with criminal authorities at the federal level, at the state level. We'll work with regulatory agencies, continue to work in parallel, particularly with the CFTC, SROs like FINRA. When we make referrals, we're going to be mindful, is there a real benefit in referring the information we have to the other regulator? Is there some special skill that they have, some special remedy that they can bring to bear? But we're going to continue to work with them. I will also note with the CFTC, folks have probably noticed that the Commission recently entered into a revised, amended MOU between the SEC and the CFTC designed to improve our coordination. We've already seen the benefits of that in enforcement. I think that's going to be great for us. I hope it'll be great for the CFTC, and it'll be great for everyone. I think the better we are at working together, not stepping on each other's toes, having clear understanding of where our jurisdiction lies and theirs does as well, and working together with that understanding, it's better for everyone. So with that, I'll pause for a second and ask Commissioner Gallagher if he has any questions about the intro.
Well, I thought that was a great intro, and I've been someone who's got a very vested interest in the vibrancy of the SEC enforcement program, and who has felt the pain of the SEC enforcement program over the last couple of years. Really impressed over the last year with the clarity about priorities. I think that's been missing for quite a while, right? Where are you focused? Is it just big penalties? Is it just big splash? And so from the chairman to you and Judge Ryan, just the clarity of, we're back, the cop on the beat. We're going to do the stuff, the hard stuff that only SEC enforcement does, I think has been terrific. But one other thing I want to just call out, and then I'll get tough on you, is, even in what I'll call the dark days of the last administration, the professionalism of the staff was the one constant. And again, having been even on the receiving end of it and getting some tough love, just the respect and the professionalism is terrific. And so it's nice to know, political whims come and go, and, these fevers, come on and then break, but the SEC enforcement staff, and my personal experience, has been a constant, so kudos to you guys for that. One thing you touched on, which when we sat around before this, that I didn't think of, that is really a huge issue, and you already touched it, and I hope we can talk a little bit more about it, is the foreign issuer thing. Because in a world in which U.S. listed equities are basically pump and dump schemes, right? Where you'd be better off if they were on the bulletin board, because Cromwell Cawson has his skull and crossbones. It's actually more informative for investors. Stay the hell away from this thing. But they're on major exchanges. And if the exchanges can't control themselves and keep listing these things, it's unfortunate that it's going to come down to SEC enforcement. But really, truly, you guys are the last line of defense against innocent American investors thinking, my God, here's an NMS-listed equity. And this is a problem for us at Robinhood. We offer NMS-listed equities. You would think that that's an imprimatur of quality, that it's been through some process. And in fact, time and again, what we're seeing are these foreign, mostly Chinese pump and dump schemes. So kudos to you guys for turning to that initiative.
Thank you. And I, again, could not agree more about your statement about the staff. It's an incredibly impressive group of folks. So with that, one other guiding principle of this commission has been a renewed commitment to transparency and fairness. That was a motivating, informative factor behind a lot of the changes to the enforcement manual that we just recently issued. And a big piece of that was the work that was done revising the information on the Wells process. One part of that has attracted a fair amount of attention and gotten raised a number of questions, is what does it mean in the Wells process to say that staff will be encouraged to provide the recipient of the Wells notice the salient, probative evidence that staff has reason to believe the recipient does not have access to? So Mark, why don't you talk about that a little bit?
Yeah, of course. And thank you, Sam. As Sam mentioned, we did recently issue a revised enforcement manual that included some additional provisions related to how we think about sharing parts of the record during the Wells process. As Sam mentioned, kind of the core commitments reflected in those updates to the enforcement manual are really to conducting investigations fairly and efficiently with a meaningful degree of uniformity and transparency wherever possible under the circumstances. Now, speaking from my own experience on the staff and as someone who's managed a number of investigations, those are longstanding and deeply held commitments by the division, and they were very much front of mind as we went through the process of updating the manual, and they really did inform how we thought about the changes that we made. And I think when you look at the changes to the manual, a big part of adhering to those commitments is ensuring that as part of the Wells process, the staff and enforcement benefit from hearing from Wells recipients the best good faith arguments that are grounded in the factual record. And that carries through to the Commission's process as well. A better Wells process in the investigation means a better recommendation. In many cases, a recommendation that is more targeted, more focused, that allows us to get to a resolution more quickly and efficiently in a way that benefits everyone involved, including investors and those potentially harmed by misconduct. And it also potentially informs a closing decision. So really, Sam, I mean, I think when you look at kind of what we're trying to do with those aspects of the enforcement manual is ensure that, you know, we are thinking about and keeping those values and those commitments front of mind throughout that stage of the investigation.
So what does that look like in practice?
Yeah. So we are starting to now begin to see a lot of questions from practitioners, from the staff, about kind of what that's going to look like. And so I think you had mentioned earlier that the enforcement manual speaks in terms of salient and probative documents. And in terms of whether providing portions of the record will be productive for the staff and for the recipient of the Wells notice. So taking a step back, one of the goals of the updates is to ensure that requests for access to portions of the record, or the investigative file rather, are evaluated in a consistent manner. Outcomes may differ in terms of what you as a Wells recipient receive, but at a minimum, a Wells recipient should expect uniformity in how requests are considered. And so that means you should both expect uniformity in how the staff thinks initially about what portions of the record are appropriate to share, in how the staff responds to arguments or additional requests that you may raise, how your requests are considered up the supervisory chain. That it really is that with these principles-based approach in mind throughout that chain. To put some more detail around that, because I know that's probably what people are more interested in, I think it's personally helpful to think about a type of investigation that we see commonly, a fraud investigation. And in those types of cases, my expectation is that a general matter, if a Wells recipient has not obstructed the investigation or they're not seeking to obtain an unfair advantage through the process, for example, by getting a preview of the record before they've provided testimony, they should generally be able to expect to see and review key documents that evidence the relevant misrepresentations, omissions, deceptive acts, et cetera. So if the misrepresentation is in a PPM or an LPA, if it's it was on an investor call, right? A recipient of a Wells notice shouldn't have to guess where the misrepresentation or where the omission is. They should have access to that. They should They should see it, they should understand both what embodies the misrepresentation or omission and the staff's understanding of why it's misleading. They should also have access, as a general matter, to key documents that evidence falsity and scienter, right? If you think about that PPM or that LPA, the staff has made a preliminary determination that it's false or misleading, and that there is a scienter or negligence based reason for that. A Wells recipient should have access to those documents and that information that evidence the staff's preliminary determination that those misrepresentations or omissions were made with a particular state of mind. You should also expect to receive documents that provide relevant context for purposes of assessing materiality. That's a broad category of documents and one that's going to vary case by case. But the important thing to understand is that materiality is an element of the offense, or the violation rather, and you should, as a Wells recipient in general, see the documents that the staff considers particularly relevant in thinking about materiality. You should also expect to see testimony transcripts or exhibits where necessary in order for the staff to preserve the anonymity of a witness, excerpts from testimony, or other types of descriptions of the testimony that are sufficient to provide the relevant context of witnesses who may be providing evidence that's relevant to the staff's preliminary determination. I think it's important to note that while that type of information should be shared, and there can be a conversation with the staff about additional information that can be shared, we are not undertaking an effort to scour records for anything that might conceivably be exculpatory, for instance, or and so that said, if there are, I think, salient exculpatory documents or testimony that we've assessed in making our own preliminary determination, I think it's our expectation that those will be available to the Wells recipient. I know that I'm leaving a lot of things out, right? This isn't a prescriptive list. There may be cases where you get all of those. There may be cases where you don't, and there was a lot of discretion, and I think maybe later we'll touch on kind of how we think about the exercise of that discretion. And so the point here isn't to be prescriptive, but what's salient and probative is going to vary on a case-by-case basis, and that's often something that's going to need to be worked out in your conversations with the staff. But again, expectation is that these principles will kind of be front and center as part of those conversations.
Why don't you talk a little bit about the discretion that staff has? What sorts of considerations should staff be thinking about in making that kind of evaluation?
Yeah. So I think that we all, I think, would agree that it's paramount for the staff to preserve the integrity of the record. For instance, we have to be very mindful of the risks of witness tampering. We have to be careful about exposing witnesses to the risk of retaliation, and retaliation comes in many different forms. And of course, we want to avoid needlessly releasing personally identifying information, trade secrets, and other sensitive information as part of the Wells process. We also have to be efficient in our investigations. Voluminous records collected over the course of an investigation often do distill down into a few key issues and a handful of key documents and a handful of key transcripts. In those contexts, neither fairness nor efficiency flows from what you might call a reverse fishing expedition into the investigative record. So the staff really has twin responsibilities that they're balancing in these circumstances. They have to conduct efficient, effective investigations. They have to protect the integrity of the investigative record. They have to protect the identity of people who could be retaliated against or could be re-victimized. And they also need to provide the salient probative information in a way that provides for a meaningful Wells process. And they have to do all of this without losing control of the overall timeline of the investigation. And so they're balancing a lot in those circumstances, and which as a result means that the staff ultimately needs to retain a significant amount of discretion in this process. But going back, right, that discretion is grounded in these principles and these commitments to fairness and efficiency.
Thanks, Mark. Before we go to a litigation update, Commissioner Gallagher, any questions?
Yeah, I'm just curious. So I was there when the enforcement manual was put together. I was there for the debates about making it public. And first of all, kudos again, just process-wise, it's a good thing to look at your processes, your manual, and especially when it's all about transparency and, right, this feeling of, trust in the system. I think having a public enforcement manual, updating it when you see it needs to be improved, I think is a very good thing. What's the staff experience been? Because we had some rager debates on the commission about making the manual public. And as you might imagine, I thought it was a good thing to do. And obviously, a majority of the commission did at the time. But there were some folks on the other side of that, oh, this would be the worst thing ever. It should just be an internal document. Is it in some ways helped you? Or is it, I guess, conversely, has it hindered you at all?
My view, and I've worked at the commission now for 15 years, and for the entirety of that time, the enforcement manual has been a public document.
Right.
And in my personal experience, it's been very helpful for everyone to understand the parameters within which the staff is operating, right? And that if there's a protocol, right, you need to get supervisory approval for a thing, right? That's not a mystery. A Wells process, right? That people understand that the staff is ultimately guided by and constrained to some extent by these policies and procedures, I find to be helpful in giving that level of transparency. So I have not really seen that, I think, used against the staff in a way that I think is unproductive.
Good. So I was right, is what you're saying.
I think well, no, we didn't need a whole, you could have just asked that question.
I was leading you to this conclusion.
Okay.
Yeah.
No, and I agree. I think it also gives credibility to what the staff is saying when they're talking about what the process is, what needs to happen, or what won't happen. The fact that everyone has the same playbook is helpful.
Well, that's the thing, right? It was back then, it was this notion, if you hire the right lawyer, they're going to get favors from, I mean, it was not good for the staff, right, to have this notion of preferred access and everything else, right? And so you put it out there. This is the protocol. We play by the same rules regardless of who's coming in. It levels the playing field. It makes people feel on the outside that it's a more fair process, because it is.
So next, Nick will give us an update on litigation.
Thank you, Sam. So I will start by saying we are busy. We continue to be busy in our litigation work. We expect to have a robust and diverse litigation docket going forward. In terms of our focus points right now, it shouldn't be surprising to hear that we're focusing in our litigation work in a lot of the areas that Sam talked about earlier, core enforcement priority areas of the Commission, meaning you'll continue to see us bringing litigated actions and litigating existing actions in cases involving frauds that harm investors and our markets, including insider trading, market manipulation, misconduct by investment advisors and broker-dealers, among various other areas. I'm going to talk briefly about some successes we've had over the last several months at all phases of our matters. So that includes defeating motions to dismiss and related pleadings challenges, summary judgment, and of course, and importantly, jury trials and remedies proceedings. We've also had success seeking emergency relief, such as TROs and asset freezes where appropriate. And I will say, we do not go into federal court and ask a district judge to impose that kind of extraordinary relief unless we truly believe it's necessary for the protection of investors and that we have evidence sufficient to satisfy the standard that applies in that setting. As one example, last July, we filed charges in Atlanta federal court seeking an asset freeze and other emergency relief against Georgia-based First Liberty Building and Loan, LLC, and its founder and owner in connection with a Ponzi scheme that defrauded approximately 300 investors of at least $140 million. We sought emergency relief, including an order freezing assets, appointing a receiver over the entities, and granting an accounting and expedited discovery. The defendants and relief defendants consented to the SEC's requested emergency and permanent relief, with monetary remedies to be determined by the court at a later date. I want to talk about jury trials. We don't try a ton of cases, but we do try cases, and trials, as everybody knows, are a really labor-intensive, all-hands team effort, and we're extraordinarily proud of the work of our trial teams over the last month, over the last couple of months, and I'm going to talk about a few of those now. So in September, we prevailed at trial in SEC versus Gallagher, not Dan.
Oh.
Sorry, Dan.
Woo.
After a 9-day trial in the Southern District of New York, the jury found, I'll just refer to him as the defendant, the jury found the defendant liable for securities fraud and manipulative trading. As we demonstrated at trial, between December 2019 and October 2021, the defendant used his Twitter account to encourage his numerous followers, including many retail investors, to buy stocks in which the defendant had already amassed holdings. He then sold those stocks while continuing to recommend that others buy them, never disclosing that he was selling the stocks. The defendant repeated that pattern with more than 30 microcap stocks, making illicit trading profits in excess of $2.6 million. Our remedies requests are pending before the Southern District right now. More recently, we prevailed in jury trials in SEC versus Watson, a fraud case in the District of Colorado in Denver involving false and misleading statements related to commercial real estate investments. And after that, in SEC versus Sanchez, a fraud case we tried in the Southern District of Texas involving a large-scale Ponzi scheme that targeted approximately 40,000 investors by promising to trade investor funds in the crypto asset and foreign exchange markets. And both of those cases are pending remedies proceedings as well. So again, extraordinary work by the trial teams, the investigative staff who built the records that, or the record that we relied upon in those trials, and all involved in that work. Turning briefly to a few examples of successes we've had at the remedies phases in litigated matters, I want to highlight a case called SEC versus Worth, an action we filed in the Southern District of California in May 2023 against an investment advisor engaged in cherry picking. So in March of 2025, the court granted our summary judgment motion on liability, and just last month, the court granted our remedies motion across the board, ordering the defendant to pay over $500,000 in disgorgement and a civil monetary penalty in the same amount. The court also imposed important injunctive relief, enjoining future violations of the charged statutes, as well as precluding the defendant from participating in securities offerings other than trading for his own account. And then in SEC versus Govel, we prevailed in a litigated remedies proceeding in SDNY following remand from the Second Circuit. As a reminder, and I'm sure many of you are familiar with the Govel Second Circuit decision, but there in 2023, the court held that a district court at the remedial phase of a commission action abused its discretion when it ordered disgorgement without finding that the victim suffered pecuniary harm. That has since been the prevailing law in the Second Circuit, but of course, as many of you know, there's a circuit split on that question, and that question is currently pending before the Supreme Court in the Sripich case, and we're expecting a decision hopefully by the end of the term. But back in the district court, in the Govel case, on remand, the district court recently granted our request for disgorgement. The court agreed with the SEC that both Semtrex, Govel's former company, and the company's investors suffered pecuniary harm as a result of Govel's misappropriation of offering proceeds. The court found that Govel's misconduct caused the company to overstate its financial health in the public filings, which inflated its market value. That means investors who purchased the company's common stock during the relevant period paid an inflated share price as a result of the fraud. The court concluded that that standing alone established a requisite pecuniary harm. And notably, the court also found that putting aside investor harm, the company itself qualified as a victim and suffered pecuniary harm, reasoning that the corporate theft of the defendant eroded the company's value. So there are many more litigated successes we can discuss if we had time, but I will end there and just say that we continue to have a really busy, robust litigation docket. We have many cases in the pipeline and more to come, including more trials later this year. So, Sam or Dan?
I'm here for you.
Okay.
So you gave me a little flashback, by the way, because right when I started on the commission, there was a rogue broker case, Daniel J. Gallagher. It was my first closed meeting. It was Daniel J. Gallagher, and the staff was kind enough to add the middle initial, which is different than mine. It was a little bit of an awkward discussion. I think they were kind of feeling around. They didn't know if it was a relative or something, and it was not, as far as I know. I think we're all kind of, we all come from the
Before
same
my
place.
time.
Yeah. So it was a
Not
little
before
awkward.
my time. I remember that.
You remember that? It was my first closed meeting. It was awkward. Anyway, Nick, one quick question. Quick question, probably not a quick answer. Like, a lot's been written. I've seen a lot of ink spilled on dismissals. Whether it be crypto cases, other cases. I mean, and I think what folks are trying to discern, is this like a programmatic issue? Is this a decision that's been made, to walk away from certain things? What do you think about that? I mean, I'm sure it's more complicated than what you read in the paper, but I'm curious to hear your thoughts on that.
Yeah, thank you, Dan. I will say that, some of those decisions are policy-based, but some are based on the unique facts, circumstances, and evidence in cases. And so we are always evaluating the evidence in a case when we are recommending the case to the commission, and then after we bring the case. And sometimes in the course of discovery and in litigating a case, the case gets better. It often gets better for us. But sometimes challenges arise, unanticipated challenges in the litigation, in the record, and we reevaluate the litigation risk. And if, in our judgment, the litigation risk means that we likely would not meet our burden at trial, then we will reevaluate and sometimes, in appropriate circumstances, walk away. So some dismissals have been policy-based, some dismissals are just based on unique evidentiary issues, and we're always keeping an open mind and continuing to evaluate the record.
Got it. Makes sense. Thanks.
Yeah, and I think that's an important thing for us to be doing as litigants, but also as stewards of taxpayer money. I think it's our obligation to be doing that in every case. So thanks, Nick. Ryan, can you talk a little bit about issuer disclosure and accounting cases?
Sure. Thanks, Sam. Before I thrill you all with the accounting, I do have a favor to ask of you all to pull out your phones and cancel your reservation for that long Friday lunch, because at 1 p.m. there is the accounting panel, and there's lots more debits and credits to come. Skip the steak so that you can not be sleepy, and your cholesterol will thank me.
There is such a thing as a funny accountant. I love it.
I try. Let me keep up. You might have seen some press or read some things from the professional case counting set that says that accounting cases are dead. I assure you that is not true. And just to borrow something from the defense bar that we hear from time to time, it might have just been a timing issue, because we seem to be quite busy since January. And I really do want to emphasize what Sam said earlier. It's not just about the numbers. It's really not about the numbers at all. It's about the message that we send from cases and the importance of getting investors the accounting and financial reporting information that they need to make decisions. So in that vein, I do want to start with a recent case that the Commission authorized. I think it's a good jumping off point for all of the things that you're going to hear the division talk about today. Things like penalties, cooperation, remediation, the division's willingness to litigate cases. But I also think that the accounting case is an important story as well. And that case is Archer Daniels Midland. In true Speaks fashion, I'm going to double down and just once again say that what I'm going to say are the facts that were alleged in the Commission's order, and the company and the individual respondents neither admitted nor denied the facts as alleged. But this story is about a business that operated in agricultural commodities. It was growing its product offerings, and it wanted to focus on nutrition, which totally makes sense because, if you are dealing with a lot of things that go into human foods or animal feeds, why not take it straight to the horse's mouth? Oh, by the way, nutrition businesses tend to have more stable earnings, and they receive higher multiples of earnings.
Oh, it's so bad.
than from a valuation perspective. And so this fact was not lost on both the management of the company and the financial analysts that cover their companies. Now I have to talk about generally accepted accounting principles, because what does GAAP require? GAAP requires segment information to be reported in the notes to the financial statements of a public company. And why do they require that? It requires it to help users understand the company's performance in the different areas it chooses to focus, to assess future cash flows, and to make informed judgments about the entity as a whole. And so many businesses have segments that transact with each other back and forth, so there's additional information that's required about the measuring of that performance of the profit and loss. And so in this case, the company said, inter-segment sales have been recorded at amounts approximating market. But that was not always how it happened. In multiple years, when the nutrition business was failing to meet expectations, it made adjustments to those inter-segment transactions that did not approximate market, but were instead designed to improve the performance of the nutrition segments. And in certain years, those adjustments allowed the nutrition segment to meet those certain milestones when it had otherwise fallen short. So you can read the order, you can understand some of the remedies that the commission was able to obtain in this matter, and the cooperation that the company engaged in. And really closer to my heart, and something I'm always thinking about, is how this company remediated the things that gave rise to that violation that made it less likely that those types of things would recur in the future. But I think that this case is a good way to start off on kind of talking about, we talk a lot about what has changed in the division and its priorities, and it's a worthy topic, and I absolutely understand why people care about it. But this kind of reminds me of some of the themes for what hasn't changed, and I want to speak to those just quickly. And because everybody pays so much attention to when an accountant speaks, I hope that some of you might remember hearing me say some of these things before. And the first thing that hasn't changed is that in so many of our cases, what we see is a fundamental disconnect between how management views its results and the way that it's characterizing those results when it communicates with investors. In management, and I think this is true in this case, that they knew that they had a problem with a particular business and it was going to affect their financial results. But rather than being forthright about that problem to investors, it was hidden. And in other more extreme examples, it might be something like a fake journal entry, but sometimes it's more nuanced, like adjustments to contract terms that otherwise might make sense, but just were not in phase with the economic reality. So the second common theme I think is worth noting is when we see misstatements, it doesn't always affect just one area of the filing. For example, if there's a material misstatement in the financial statements, that's a GAAP problem, but that information isn't always only relevant to the GAAP. The misstatements might be carried over into other areas of the filing, like the results of an important segment when you're presenting that information in percentage terms of growth. And I think that this highlights something that I think about a lot, which is that investors are getting a total package of information. It's not just the information in a filing. There are also types of communications to investors, like things on earnings calls and investor days. And maybe to anticipate a question, you might say, that's enforcement saying these are all of the ways that we're going to get you. Big bad enforcement. But we're not looking at these things. I would like to push back against that because I do believe it's actually the opposite, which is in cases where there's a problem somewhere in the information package that's presented to investors, rather than being hyper-focused on any one particular area of an investor communication that might be outside the rules, I think we're thinking about violations in the context of that total package of information. So just to put a finer point on that, if you are, for example, telling your company's story in 4 places, and it's consistent in 3, and maybe that 4th place, it's gray or it's a little bit less clear, in my mind, that's a very different story from a situation where all 4 parts of that story paint a false picture of what's going on in the organization. So the third lesson, and I think that this is worth highlighting, is really the profound impact that leadership can have on a culture of compliance. effective leaders, particularly those in the C-suite, are really good at motivating their organizations. And my hope is that most often this is used to actually foster that culture of compliance that ensures investors are provided with the information that they require to make those investment decisions, rather than to pressure those in the financial reporting and disclosure organization to maybe soften results or advance narratives that executives know or should know are inconsistent with reality. Questions? Critiques of the comedy?
Hilarious. But like I said, there are some funny accountants, and GAAP is important. Have you seen trends, back again, my hair's gotten whiter, it's been a long time since I was on the commission, but non-GAAP was just like the hottest topic in the world forever. Does it remain a hot topic? Do you see trends, folks trying to push the bounds? I mean, it's been a long time since the WeWork community something adjustment to GAAP, but I assume that folks are still trying to push the bounds there.
Non-GAAP information is important information to investors, and I think that it is something we're always focused on. To what I said about the total package of information, another example where you might have a GAAP problem and it translates into other areas of the filing is when you're adjusting that GAAP number. If that's wrong and then you're making an adjustment to it, inherently you might have a non-GAAP problem as well. So I think it's something that we are always thinking about. But the thing I always remember about non-GAAP is this is information that management is choosing to tell investors because they think it's important. And when you have that type of information and management thinks it's important to have reasonable controls around how that information is getting to investors.
And then back to something, Sam teed up and I commented on these foreign issuer issues. I mean, a lot of it comes down to accounting, right? If the accounting was accurate, no one would invest in these things, or they probably shouldn't or couldn't have been listed qualitatively. What are you finding there? There are trends? I know there's always been the tension with access to books and records in certain jurisdictions, China in particular. Is that been, I know that there have been some agreements and PCAOB thinks, they have that more streamlined, but how are you finding it on the SEC side?
Certainly, I would say there's been tremendous progress if you think about things like holding foreign companies accountable and the ability for the PCAOB to do inspections. I would not discount any of the challenges of things like getting work papers or other types of books and records. That said, it's something absolutely that we're focused on. I think a lot about the gatekeepers that are helping facilitate this, and gatekeepers to me is it's a lot of things, but to me, I really always am thinking about the auditors. And we have indications of quality problems there, and we're very focused on that, among other things.
I assume it's kind of like what we always found in the brokerage industry, right? You kind of hammer one boiler room and all the cockroaches go to a new one, right?
I do rats from a sinking ship, but I like that too with the flashlight on the cockroaches.
Rats are sometimes cute. Cockroaches are pretty gross. And so I think more relevant here to this discussion. But is it the same? Is it the same on the accounting side, right? So like auditing firms, you have bad players, right? And the notion of an auditing firm overseen by the PCAOB, overseen by the SEC, rubber stamping some public company, U.S. listed companies' financials. I mean, to me, is like it's almost even worse than a boiler.
I mean, it's disgusting for the profession, and I think it's something we're focused on, and it really denigrates the work that is so meaningful and so important and done so well across the profession when you have these types of players that don't do it. So it's a big focus.
Yeah, because there's a whole ecosystem involved, right? You've got the underwriters, you've got the auditors, right? It's a cottage industry. And again, if it was in a market that everyone knows is super dangerous, that's one thing. There's a little bit of caveat emptor. It doesn't mean you shouldn't be doing your job there in the over-the-counter markets or elsewhere. But when it's on U.S. listed, or U.S. national securities exchanges, it takes it to a whole different level for me. And by the way, you'll remember, Sam, we had these discussions. I remember my first full year on the fights at the commission level. Every Thursday, how many Chinese issuers were ripping off. right? Aguilar and I were just like red in the face about this stuff, right? And the talking to trading and markets, write new listing rules, use 19C, write new listing rules for the exchanges if they're not going to do it themselves. And it just comes and goes, and it's amazing that we just haven't put this to bed. So anyway, good to hear that you guys are focused on that stuff.
Thanks, Ryan. We're going to switch gears a little bit right now and talk a little bit about corporate penalties and individual liability. Mark, can you talk about that?
Sure. And so I think it's, you know, kind of building on Ryan's discussion of the ADM matter, thinking about corporate penalties, thinking about individual liability in that matter. The commission, you know, for a very long time now has, in thinking about penalties against corporate issuers, weighed the impact that a corporate penalty will have on current shareholders, essentially asking whether a penalty will further victimize the very people that the commission should be seeking to protect. The commission, you know, commonly looks to a different set of consideration for registrants, often with the focus that centers on considerations like the need for deterrence in the regulated space, the extent of the misconduct, and the harm or risk posed to the functioning of the markets. But keeping the kind of focus on corporate issuers, penalty considerations have long been evaluated based on considerations set out in the Commission's 2006 penalty statement. Over time, different commissions with different compositions have weighed the considerations in the 2006 penalty guidance differently, but as a whole, those considerations really have been a mainstay in how we think about our recommendations for a very long time. And they embody, if you're familiar with them, the kind of foundational principles that predate the statement itself. The 2006 statement, we're at a panel in 2026, and I'm talking about the 2006 statement, but it is, you know, these are evergreen things, right? And so, and I think I look at this room and I see a lot of people are probably very familiar with the 2006 statement, but I do think it bears repeating that statement looks to things that a lot of us are familiar with, right? The degree of scienter involved in the misconduct, the need for deterrence in a particular situation, as well as other factors. But it obviously starts with threshold considerations, whether the penalty as designed will harm current shareholders or current investors, balanced against whether the penalty stands to recompense those investors harmed by the misconduct. So as a practical matter, what does that mean? It means that in making a recommendation, we're looking at whether the company benefited in some way from the misconduct, such that a penalty will not compound harm to investors. So for instance, did the issuer go public or conduct a secondary offering using material misrepresentations? Did it acquire another company? Did it acquire an asset with fraudulently inflated shares? Did it artificially maintain a credit rating, allowing it to issue debt at a discount? A lot of ways to look at this, and I think so. Those of you who were here yesterday and you heard Dira's panel, you appreciate that we prioritize an analytical approach that draws heavily on our agency's econometric resources or expertise in those considerations. The other leg of the analysis is whether the penalty would recompense harmed investors. There, one of the common considerations is whether a fair fund can effectively distribute the penalty to a group of investors harmed by the misconduct. So for you have many fraud situations where there's a category of investors, a group of investors who may have sold after the fraud was disclosed, and they're victims of the misconduct who would not be further harmed by a penalty. And there are some cases, and these are very much dependent on facts and circumstances, where that might weigh in favor of a penalty, even in the absence of a clearly calculable corporate benefit. But the 2006 penalty guidance gives you the framework for how we think about it, and therefore kind of how it is, I think, helpful and productive to engage with the staff in those conversations. The other thing I'll say is that obviously comes alongside the seaboard factors, which do remain constant. And so penalty considerations there obviously are considered in light of the factors set out in the seaboard report, which in the interest of time I will not go through. But that has been online now for over 20 years, and so I think people can find it. Yeah.
Commissioner Gallagher?
So, Mark, do you guys, as a matter of practice, I know this is sort of internal stuff, but when we used to get the action memos, there would be a section on the penalty statement, right? If there was a penalty involved, right? How, in the staff's view of whether or not the case met the requirements or satisfied the standards set out in the penalty statement. Do you guys do that as a matter of course still?
Practices evolve over time, kind of depending on different composition of the commission and their preferences for what they see in our recommendations. But those considerations set out in the 2006 penalty guidance, speaking for myself, have been reflected in the penalty recommendations in some way or another with varying degrees of specificity for a very long time. And I think I would expect that to continue to be the case. And I think kind of tying this back to the Wells process, right? If you are, we obviously don't want to get we don't want to get settlement offers as part of the Wells, but if you're in that stage of the investigation and you're having conversations with the staff about potential resolution, you should expect ultimately the recommendation that they're going to make to the commission to be framed in terms of the 2006 penalty guidance and seaboard, and therefore, to the extent that you're making arguments on behalf of your client, that's the relevant framework and ultimately the framework that the commission is going to see in the recommendation.
Got it. Yeah, that's another fun issue we debated on the commission. We had some on the commission who wanted it removed from the memos, which is, I saw a lot. One of them.
Yeah, it keeps me employed.
Yeah. Well, I know this one's near and dear to the chairman too, because I started as his counsel right when the penalty statement came out, and he was integrally involved, let's say, in the creation of that statement. So it's good to see it get new life or new attention. In my experience, and I adhered to it in all my votes as a commissioner, including some votes for some pretty significant corporate penalties. In my experience, it works. It's not handcuffing the staff. It's not, depriving the agency of the ability to actually inflict a penalty on a corporation. It's just controlling it and ensuring that you're not just allowing management of a company to take the shareholders' money just to move on to the next thing, right? And give it to the government and let's move on with it. So,
that point aligns with, I think something Sam asked that I didn't have time to touch on is obviously the priority of individual liability as a means of achieving kind of maximum deterrence. Look, as a practical matter, when a commission is focused on really on individual liability, to your point, it's we're not looking for a large corporate issuer to write a large check, settle for a large dollar number, and so that it can move on. We really are looking to have remedies that meaningfully deter future misconduct, which means you're going to be exploring individual liability, and that's I think for us that remains a very significant.
It's so funny, right? I read these articles. Oh, SEC enforcement is going softer. I would be horrified of Paul Atkins. I'm not on the inside, but I can imagine what the discussions are because individual liability is the most disciplining of anything. Again, it's not taking shareholders' money and saying, leave me alone and I'll keep doing what I do. And I know, Paul always used the Richard Breeden line about something about shoeless and homeless. Let's leave them shoeless home. I mean, he meant it. And that's how he voted as a commissioner. I assume it's the same now. That's a pretty intense posture to take, and when folks, see it playing out, I think it's going to have a much more disciplining effect than here's my $100 million of my shareholders' money. So, and I know those cases are harder. I mean, that's the other thing. It's a degree of difficulty for the staff well above and beyond just taking shareholder money. So, but I know you guys are up to the task.
They're certainly harder to settle.
Yeah, right?
Yeah. And back on the penalty statement, what I would add is, it's a policy decision about how it's applied, but to the extent it's applied in a clear and consistent way, from our perspective, that's tremendously helpful. Knowing what the ground rules are, what the client wants us to look for and to be able to show them is incredibly helpful.
And the only other thing I'll say on that is, it disciplines and bounds the settlement discussions that we're having, right? This isn't just about the staff staking out a large number, and sort of working to the middle, right? These settlement negotiations are principles-based, and that's ultimately what the client is going to expect to see in that memo. If there is a large corporate benefit, right? If there can be recompense to harmed investors, right? Those are factors that are going to bound the staff's analysis, and they bound the kind of the commission's expectations for what they're going to see in those recommendations from the staff. But to my mind, having those principles govern settlement negotiations are incredibly helpful, and can really save a lot of time and energy. But it's helpful if both sides to that negotiation share that understanding.
So we've got just a few minutes left. I don't know, Commissioner Gallagher, if you've got any broader questions.
Of course I do, Sam.
Any comments?
I actually have a list. My little Marriott card here. I'm curious about, and I asked this my now annual question on specialty groups. I was skeptical of them. I was actually on the staff in trading and markets, working with my friend Mike Macchiaroli and Eric Siri and crew when Kazami came and created them. And, borrowing from the U.S. Attorney's Office model. And, I always worried. I worried then, and, I worry now that, you get, Paul always says this, by the way, you get what you measure, right? And, is that the right thing to measure? Does it deprive enforcement attorneys of the ability to work on sort of varied matters, which is good for their professional development? What's the experience been? I saw you change the cyber one into like emerging technologies or whatever, which is great, because, if you're doing it, I assume you want it to be evergreen, and you want that, that expertise to continue to reside in a certain set of folks. But how's it working?
Yeah, and the point you raise is a fair one, but I do think the way you framed it, it is a management issue, right? It's what you measure is what you get, is sort of a management principle. And I think to the extent there is that issue, that challenge, I think it's something that can be addressed through management and making sure that we're measuring the right thing so that you don't have the nail hammer issue be a consequence of the units. I think that on the other side, which I think outweighs that, and I think, again, that could be managed or addressed, is the tremendous benefit we get from people within enforcement having this, incredible amount of knowledge about these special areas of the law and of the markets, of the industries. They have not only their own knowledge, but they have, I think, a better understanding of where other places in the building also have that knowledge. And so we're, I think, much more effective in keeping those lines of communication open. They're not the only ones that are doing those types of cases. C2, the Cyber and Emerging Technologies Unit, is not the only unit or only group of attorneys and staff that are going to be doing those types of cases. But we do want everyone who's outside of that unit that's doing that type of case to be coordinating with members of the unit, the leadership, so that we're all, at the end of the day, from our perspective, running an enforcement program, you want consistency, and I just think that they are so effective in helping us get that. So I get that there are issues, there are potential criticisms. I think that the benefits outweigh those.
And if I could add one benefit, Dan, before you weigh in. Also, and this dovetails with what Sam was saying. Creating incentives to build out deep, costly analytical capacities is something that you've seen with the specialized units that's harder to come by if those types of cases are dispersed throughout core. And so you see that across the units where they really have invested in programmatic approaches, in technology, and other types of solutions that really do facilitate the enforcement function and make it much more efficient. And it's hard to get that if you don't have that expertise concentrated.
On the flip side, and what I'm still scarred by, are the old asset management unit 20647 cases. And like, you know, you shouldn't be shooting fish in a barrel just because they're a fish in a barrel. And my only dissent, my only enforcement dissent, my whole tenure, public dissent, was on these CCO cases
CCO
with
cases,
20647. Like that to me was the worst of a specialty unit. Like, we are the hammer, we're the nails, right? And so be on guard for that. I know you are, but, and, you know, I don't dispute that they've worked. You know, I do think Sam, you nailed it. It requires constant management.
Yep.
Yeah.
Yep.
One other question I have for you guys. And you noted the CFTC, MOU. It just kind of brought to mind for me the potential for duplication when it comes to enforcement efforts. How are you guys thinking about that these days? Not just the CFTC, but just more broadly, because there's so many. You have the whole alphabet soup that you have to deal with when it comes to duplication.
And I touched on it a little bit. It is something that is incredibly important to this commission. It would be regardless of our resources, but it's no secret our resources are incredibly limited right now. We have to be laser focused on making sure that there is duplication does no one any good, but certainly doesn't benefit us right now. And so it's something that we're always mindful of. We are hyper mindful right now of making sure that if we're involved in a case that we are really adding something to it. If there is another regulator out there, another agency, criminal authorities that can do the job just as well or better, then we should be letting them do that.
It is, again, having now been living on the receiving end of it for a while, it's pretty brutal. And there's no government manual to invoke and say, you guys are out of bounds. Like, it's really discretion. So, and when you get in these hyper, like the last administration, these hyper enforcement environments, it's kind of irrational. So, and it, like, at the end of the day, if it served a policy goal, I'd say, fine. It doesn't. It really doesn't to have 5 matters or 2 matters brought on the same exact facts. It doesn't serve a policy goal for the government. So, good that you're watching out for it. Can I ask one more?
Sure. We're running a little bit late, but...
What do we have, Grace?
Oh.
She said
That didn't sound like a no.
She said yes.
I think she said yes.
Grace said yes. And this one's unfair because I didn't tell you I was going to ask you. AI, using AI, are you guys starting to dabble? I mean, because to me it's like TCR, all these things that enforcement has done over the years to use technology to get more efficient. And I'm not asking you if the answer is yes, how you're using, because you don't want to tell people. But like, is this something that you're thinking about programmatically?
Yes, it is.
Okay.
It's something we are definitely focused on, both internally and also looking out for bad actors that might be using it
Yeah.
to engage in misconduct as well.
It's coming.
Yep.
Yeah. Okay.
Yep.
Thanks, Grace.
Yep. Well, thanks, everyone.
Thank you.
Well, thank you. That was a great panel, very informative. A little bit of humor, and I will tell you, I'll comment from the podium while we make the transition, but when I joined enforcement, we got what was called the Red Book, which was the enforcement manual, day one, and it was very cloak and dagger. Okay. Ready? Okay. So the next panel, we will hear from the Office of the Investor Advocate, Adam Anasich, who is the Senior Advisor and Investor Engagement Manager for the Commission. In this role, he's responsible for a wide range of activities, including developing engagement initiatives and getting feedback from institutional and retail investors, providing guidance on strategic priorities, and is the Investor Advocate's front office advisor. He developed and leads a large joint task force called the Interagency Securities Council, which focuses on complex financial fraud and has more than 2,500 people in it. He's also chair of the SEC Veterans Committee and a member on several executive committees at the Department of Veteran Affairs. Welcome.
Hey, good morning, everyone. So thank you for welcoming me. It's great to be back this year at SEC Speaks. Before I get started, I wanted to thank Grace, because Grace O'Hanlon has really put this whole thing together. So if we could just take 1 second and give her a round of applause, because she's really making this happen. So no, great job, Grace. So my name's Adam Anasich. As Grace mentioned, I serve as the Senior Advisor and Investor Engagement Manager here at the Commission. I also lead the Interagency Securities Council, which is that large government-wide task force that's really focused on financial fraud. So I'm honored to speak with you about really the vital mission of the SEC's Office of the Investor Advocate, especially as we navigate an increasingly complex financial landscape. So before I begin, I would like to remind you that my remarks are provided in my official capacity, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. So when the Office of the Investor Advocate was established pursuant to Section 4G of the Exchange Act, Congress recognized that investors needed a dedicated and independent voice within the SEC. Someone whose sole purpose would be to protect their interests and help ensure that their concerns were heard at the highest levels of policy and practice. This past year, we reaffirmed our commitment to that mission that Congress envisioned for us. So when Congress did establish our office, as well as the Ombuds office, Lisa's over here in attendance. Welcome, Lisa. They gave us specific tasks to perform in service to investors and to promote investor interests inside the Commission. First is to assist retail investors with significant problems they may have with the Commission or with self-regulatory organizations. Two is to identify areas in which investors would benefit from regulatory changes. The third item is to identify problems that investors have with financial service providers and investment products. And the fourth is to analyze the impact on investors of proposed rules, regulations, and the litany of investor activities. So you've heard from some other panelists earlier today and yesterday. Our approach really is data-driven advocacy. What distinguishes our office is our commitment to providing unbiased, evidence-based support by conducting rigorous research, you'll hear from Alicia soon, performing legal analyses, and perhaps most importantly, consulting directly with investors and retail investors. We also meet with industry participants, academics, law enforcement, and consumer advocates to help ensure that our recommendations are well-founded. So to execute these strategies, we have a lean, efficient, multi-seasoned and multidisciplined team that really remains dedicated to the mission of our office. We seek to understand what investors want, what they need to make investment decisions, and what they do so that they may be even better served by the Commission. To support these goals, we communicate what we learn from investors frequently with divisions that you've been hearing from up here. And over the course of this conference, I think you'll find that our engagement with the chairman, the commissioners, and their staff hopefully leads to positive outcomes for investors. In addition, the investor advocate is required to transmit 2 reports to Congress each year that detail the office's objectives and activities. Of course, all of that's available on sec.gov. When we do our job successfully, everyone has more information about how the actions of the commissions and the SROs may impact investors, and in turn informs us of ways to improve investor experiences and opportunities. So we collaborate both inside and outside the commission. In the past year, we've expanded engagement opportunities with the SEC divisions and offices, federal departments, state agencies, state law enforcement, local law enforcement partners. And we do that by hosting or, contributing to about 120 engagements every year out there. And these are organized for the benefit of investor engagement with the division and office directors, with the commissioners, so that they can hear that investor commentary firsthand, including hosting public events and thematically focused events, such as Demystifying Capital Markets or the SEC's Investor Advocacy Law School Clinic Summit. Basically, we try to create opportunities to allow SEC leadership to meet investors where they are. OIAD is also the office that's assigned to support the SEC's Investor Advisory Committee, which is composed of investor advocates, academics, industry participants. It's bringing really those broad-ranging perspectives on investor issues to advise the SEC. Jen, a former member, is here, so thank you, Jen. The goal is really to protect investor interests and promote investor confidence in the integrity of the securities marketplace. In fact, they met here in DC just last week. So another issue that we're going to talk about is complex fraud. In this past year, investment fraud has unfortunately remained central to our efforts and remains the largest reported dollar loss to Americans. You may remember that we highlighted this alarming acceleration in fraud in our June 2024 annual report. The Federal Trade Commission estimated that year that the overall losses due to fraud, adjusted for underreporting, were over $158 billion that year. More recently, the FTC estimates that just the loss to older Americans alone can be as high as $81.5 billion. So investment fraud is increasingly a big, big part of fraud in America, surpassing business email compromise as the highest reported aggregate dollar loss to Americans. And that's according to the most recent, or one of the recent national money laundering risk assessments from the Treasury. So in 2024, the SEC launched the Interagency Securities Council, which is a joint task force that invites federal, state, and local regulatory and law enforcement professionals to meet quarterly to discuss the latest in scams, trends, frauds, as well as mitigation strategies. We also provide briefings on emerging and complex topics. The ISC is limited to law enforcement and government officials, and currently we have over 2,500 members from a little bit more than 350 departments and agencies, including federal financial regulators, law enforcement agencies, state offices, state securities regulators, local police departments, sheriff's offices. The council really provides a forum for law enforcement to share information, to learn from experts on emerging threats, and also hear from investigators on case studies, kind of explore examples of innovative approaches to fighting financial fraud. So, of course, participation by these agencies is entirely voluntary. The council is chaired by Sam, the director of the Division of Enforcement, as you just heard, and the ISC does not generate policy recommendations. So in 2025, the ISC conducted large meetings and hosted specialized briefings with experts, such as a briefing on digital evidence collection, extraction, and preservation with the SEC's Office of the Inspector General. We've consulted with regulators, law enforcement across the country for different expertise requests and things like that. And also, we presented at the public meeting of the SEC's Investor Advisory Committee on threats facing retail investors last year. With that presentation later being cited in others' congressional testimony and the congressional record. So as we move through the rest of 2026, I think we're really saying that we are committing to assisting investors. We're committing to helping ensure that investors' voices are heard at the highest levels and continue to serve the American public. Before I close, I'd be remiss if I didn't mention two things. So first, Christina Martin Fervita, the former investor advocate, recently concluded her tenure at the SEC in January, and I wanted to wish her well. And two, I want to personally invite each of you who's in the audience or even listening at home to meet with our office to discuss the issues that matter to you. So come find me at the break, shoot me an email. I'd love to connect with you. We definitely want to hear your voices so we can help make the SEC a better place. So thanks for your attention and your time today. I appreciate everything that you all do to make America's capital markets strongest, most competitive, the most trusted in the whole world. So now it's my pleasure to introduce Dr. Alicia Chin, Senior Financial Economist in our Office of Investor Research, who will talk a little bit about how our research impacts investors and investment decision-making.
All right, thank you, Adam. Hello, everyone, and thank you for having me today. As Adam mentioned, my name is Alicia Chin, and I work for the Investor Research Unit within the Office of the Investor Advocate. So before I continue, let me remind you that the views I express are provided in my official capacity as a senior financial economist in the Office of the Investor Advocate and do not necessarily represent the views of the Commission, commissioners, or other members of the staff. All right. So the Investor Research Unit employs a multidisciplinary group of researchers who work to provide the Commission and the public with insight into how investors think and behave. We provide research support to Commission offices and divisions seeking objective information about investors. And in some cases, we also respond to congressional mandates for investor testing, such as our research on registered index-linked annuities. Today, I would like to draw your attention to just one of our research initiatives, which is our nationally representative survey panel known as the Thrive panel. So in late 2023, we developed Thrive to contribute to the Commission's investor protection mission and to provide a cost-effective and efficient method for identifying and analyzing emerging investor issues. Thrive consists of quarterly longitudinal surveys, meaning surveys that invite the same people over time, and custom testing projects that represent the Commission's primary research tool for understanding retail investors. As part of our quarterly surveys, we invite 7,500 people to answer recurring questions on investment decisions and household events, as well as novel questions that we designed to capture current financial interests. Thrive is designed to be representative of the U.S. population as a whole. That means that it contains participants from every U.S. state, all different age groups, and all different walks of life. To date, we have used Thrive to explore many different issues. I'm just going to mention two examples for you. So first is our published report titled Perspectives on Investing. In that report, we examine retail investor asset ownership, frequency of purchases and sales, recent household financial experiences and how those influence investment decisions, and the overall financial well-being of both investor and non-investor populations in the United States. Because Thrive surveys the same people multiple times a year, as I mentioned, we are able to better understand trends and shifts in ownership over time. So for example, we find that over 15% of people who report owning cryptocurrency or NFTs in our April 2024 Thrive survey do not report owning cryptocurrency 3 months later in our July 2024 survey. Such statistics, we hope, highlight how our data can provide a more nuanced view of asset ownership in the retail investor population. My second example comes from our recently published research on accredited investors in the US. In that research, we explore questions including, first, how prevalent are accredited investors in the US population? Second, how do they qualify as accredited investors? And third, what assets do they hold? So based on a custom survey that we designed, we find that 12.6% of individuals in the US population qualify as accredited investors. They primarily qualify based on their reported net worth, which captures 9.7% of the population, followed by qualification based off of the personal and household income thresholds. Furthermore, we find that accredited investors are more likely to own various asset types than non-investors, as well as non-accredited investors, including 4.3% who report owning private market securities. Looking forward, we intend to continue to support the Commission and the Office of the Investor Advocate through high-quality research. We will continue to examine investors' decisions and behavior, their decision context, household factors influencing their investment decisions, and macroeconomic trends. I'd be happy to chat with you during the break if you have any further questions. Thank you for your time.
So just right quick, we're on a break until 10:35 when we'll resume with exams.
Are we ready? Yeah? Okay, great. Oh, not yet? So welcome back. Hope you enjoyed your break. It was brief. The next panel is the Division of Examinations. And the leader of the director of the Division of Examinations is Keith Cassidy. Before joining OCIE, is what we used to call it, he was the director of the SEC's Office of Leg and Intergovernmental Affairs. And before coming to the commission in 2010, he was Chief of Staff and Counsel at the Department of Justice Office of Legislative Affairs. Mr. Cassidy is also an infantry officer in the U.S. Marine Corps Reserve, where he serves as the commanding officer of 4th Reconnaissance Battalion. Not that that's intimidating at all to get a call from Keith that you're going to get an examination. So I'm sure he'll explain the priorities of the program. And welcome back, Dan. Have you ever left?
Which panel is this?
My co-chair. Okay, enjoy. Thanks.
Well, thank you, Commissioner, for the warm introduction, and thank you to Commissioner Gallagher for joining our panel this morning, and thank you to PLI for hosting this great event. I want to welcome everyone in the room and online to the joint panel of the SEC's Division of Examinations, the Office of Credit Ratings, and the Office of Municipal Securities. Before getting started, let me remind everyone that while our remarks are given in our official capacity, they do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. While much has changed since we appeared on the stage a little more than a year ago, the Division of Examination continues to execute on the priorities we published in November and engage with the industry as we're doing today to promote compliance and in turn protect investors and ensure fair and orderly markets. Like all of the divisions of the Commission, we've made necessary adjustments to account for the loss of staff, endured a 43-day lapse in appropriations that impact the examinations process and have been operating in a very dynamic geopolitical environment. And throughout it all, the division has delivered on its four-pillar mission to improve compliance, prevent fraud, monitor risk, and inform policy. As the eyes and ears of the Commission, our examiners serve as an important bridge between our registrants and the policymakers. I and the rest of the leadership team of exams are committed to ensuring that the division is accessible and integrated, engaged with the markets and market participants, and aligned with our colleagues in the other divisions. But without further ado, I'm pleased to introduce the panelists from the Division of Examinations. Alexis Hall, immediately to my left, is the National Associate Director of the Technology Controls Program. Vanessa Horton is the National Associate Director of the Investment Advisor and Investment Company Program. Hain Kim is the Chief Risk and Strategy Officer for the division and the head of our Office of Risk and Strategy. Mike Ruffino is the National Associate Director of the Broker-Dealer Exchange Program. And I'm also pleased to introduce Scott Davey, the Acting Director of the Office of Credit Ratings, which has oversight of credit rating agencies registered with the Commission as nationally recognized statistical rating organizations. And last but certainly not least, Adam Wendell is the Deputy Director of the SEC's Office of Municipal Securities, a team that coordinates the Commission's activities relating to the $4 trillion municipal securities market and administers the Commission's rules pertaining to municipal securities brokers and dealers, municipal advisors and investors in municipal securities, and municipal issuers. We have an informative discussion teed up, so let's go ahead and jump in. First off, Alexis, congratulations. I think I've heard of this Technologies Controls Program that you were just named the head of. Can you remind folks what TCP does, and then discuss a little bit about your strategic objectives now that you're in charge of the program?
Sure, and thank you. Well, with the adoption of Regulation SCI in 2014, the Automation Review Policy, known as ARP, transitioned from a voluntary program in the Division of Trading and Markets to a full examination program, the Technology Controls Program, in the Division of Examinations. The Technology Controls Program, or TCP, is made up of roughly 40 staff spread out among our regional offices, and the staff are primarily technologists of varied backgrounds, but include a number of former CISOs, system admins, auditors, and a handful of lawyers, including myself. Our functions fall within 3 categories. The first is to perform technology and technology controls-focused exams of entities subject to regulations SCI, SP, and SID. The second is our Cybersecurity Program Office, which we form to coordinate initiatives across the agency and external partners on matters related to cybersecurity. The CPO also houses TCP's CyberWatch program, which intakes and analyzes the reports and notifications required to be submitted to the Commission under Regulation SCI. And lastly, via TCP's Technical Assistance Service, we offer technical expertise to staff in other program areas and outside of the division. This is full spectrum and ranges from answering a question to sending a TCP examiner to work collaboratively on site with another exam team. As for my priorities for the program, this year my focus is on strengthening TCP's relationships with the other program areas and the policy divisions. I'm committed to increasing collaboration with other division program areas because technology doesn't exist in a vacuum. It's driven by business and regulatory requirements, the same requirements that the other division program areas focus on. By building bridges between teams, sharing knowledge, and further aligning our efforts, we can enhance the effectiveness of our exam program. I also aim to deepen our relationship with our colleagues in the policy divisions. This not only supports one of the division's 4 pillars to inform policy, but also helps to ensure that we remain aligned with the Commission's policy goals.
Thanks, Alexis. I suspect with everything going on in the world right now, your team is pretty busy. As I alluded to earlier, the division and the leadership of the division are regularly assessing how to deploy our resources, and since we were last here, we've made some organizational adjustments. Mike, can you kind of talk about what's going on in the BDX program?
Sure. Well, we made some changes in the structure of our broker-dealer and exchange program. And let me just give you the reason, really with twofold. First and foremost, the relocation of our registrants. Some of our registrants have relocated from one region to another, and also with regard to our resources. Our resources are across the entire program, so to maximize our resources, to make sure we have a national consistency across our respective programs, we made the following changes, which I'll walk you through. The territories that used to be covered by LA, San Francisco, Denver, Fort Worth, and Chicago is now under the responsibility for the hub in Chicago. Territory that used to be by Boston, Philadelphia, Atlanta, Miami, and DC is now under the territory of the DC hub. And New York and New Jersey remain the same. They still remain under the New York office, which is now the New York hub. There's really kind of 2 reasons why we did this primarily. One is to increase the continuity across the BDX program, as I mentioned earlier. And secondly is to facilitate the consistency, as I said, across the entire program. We feel that this will maximize, I said, our resources, also give opportunities to our staff members and leaders in terms of opportunities within the respective program. So I think it's really a win-win all around. With that being said, to give you some details about the new structure, each one of those respective 3 hubs will have a risk strategist, and that risk strategist plays a critical role. They're going to look down within their respective programs. They're going to look across their registrant population within those. But more importantly, they're going to work together across the entire program. We also have a national risk strategist that our 3 risk strategists will work with. I said that, again, we'll look at risk across the entire respective program. And we feel, I said, this will really position us to really look at risk nationally and give us an opportunity to really maximize our resources and our expertise.
Thanks, Mike. It seems like that'll provide additional flexibility as well, which is also wonderful. Hayne, I'll look to you next. What's going on in the Office of Risk and Strategy?
Yeah, so we made about 2 changes. The biggest change made to ORS was to integrate the unique functions of that had been performed by the event and emerging risk team. So, my office was already collaborating really closely with EERT. The unique work that they performed, their staff, that's been integrated now into the ORS team, and the teams that have similar capabilities and functions. Among other things, incorporating EERT into ORS has really allowed us to enhance our incident management response capabilities. And then also, it's enhanced our ability to focus on new and emerging technologies, AI being sort of an obvious one. In addition, one of ORS's functions, so the second change, is related to the risk analysis examination team, which has been moved as part of the BDX changes that Mike talked about. So this team conducts data-intensive examinations of some of the nation's largest broker-dealers, allowing for really cross-firm analyses. Given the already close ties that they had with the BDX program, it was really a natural fit to move with the other changes.
Thanks, Ann. So Vanessa, you run the largest program by far within the division. Any changes in IAIC?
Well, thanks, Keith, for the question. And compared to what Mike and Haynes just described, not much is happening on the IAIC side. We have had some minor changes, which are pretty small, but we continue to have quite a large experienced team out in the regions and in our home office, in our 10 regional offices. Despite the loss of staff that was mentioned earlier by Keith, there's a lot of expertise out there in the regions. Our international examinations continue to be performed by our DC-based staff here. And we also continue to have a dedicated unit within the IIC program that performs examinations of private fund advisor registrants. Like I said, the change is rather small, but given the changes Mike has mentioned, it's allowed us to be able to streamline the reporting structure for IIC, particularly in the regional offices, so that our leaders now are dedicated exclusively to the IIC program. So we view that as a win-win.
Thanks, Vanessa. Let's turn to our priorities that we publish each year. And can you talk a little bit about what we do with the priorities and how those are created?
Yeah, so you heard Keith discuss the accessibility at the start of today. The annual examinations priorities process has always been one of the key ways in which we seek to foster that. The division publishes its priorities to provide transparency to registrants, investors, about the topics that we plan to focus on in the new fiscal year, and to really encourage firms to direct their compliance efforts to those areas of potentially heightened risk and give compliance folks those tools. The priorities cover often a broad landscape of potential risks that firms should think about as they review and strengthen compliance programs. But, as we always like to point out, priority is not an exhaustive list, right? It doesn't cover all the areas we might be asking about during an exam and what we might focus on in the upcoming year.
Thanks, Ann. Can you talk a little bit more about how we determine which areas to focus on?
Yeah, so this is really an iterative process. Takes a lot of significant input from both stakeholders within and outside the commission. The staff of exams really analyzes, performs risk-based assessment of voluminous amounts of information from a number of sources. So this includes, really importantly, collaboration or consultation with the policy divisions within the SEC, info gathered from exams, communication with other regulators, investor groups, data review, and comments, commentary, tips received from regulated entities and investors as well, and also industry publications. That said, I think we're always seeking to continue to innovate our approach to make sure we're really enhancing how we identify risks and the examination focuses that we're going to have for the year. But ultimately the goal, right? We want to publish our priorities to increase transparency and really help firms strengthen compliance.
Thanks, Ann. Let's get Scott in on the game. I know your staff also conducts examinations. How do you develop your priorities?
Yeah, so in our program, each rating agency that's registered as an NRSRO, we're required by statute to do an annual examination on them. And then further, each exam is required to have, again, by statute, 8 mandatory areas within those exams. And some of the areas are quite broad in nature. So for example, conflicts of interest is an area that we're required to include in each exam, which is a good idea for this sector. But the way that actually the team executes on that, it could take a lot of different forms. So that's why it's important that our staff conduct a risk analysis each year to determine where they want to focus on for each particular exam. So for example, teams would look at possibly rating performance in a particular sector, or they might look at the issuance of certain types of ratings and look at trends there to see if there's something that they might want to focus on. And in past exams, this type of assessment has led us to focus on things like ratings associated with commercial real estate, or ratings, unpublished ratings associated with the private credit sector. So those are some things we've looked at in the past. The team may also want to look at changes that have happened at the NRSRO over the review period, so changes in policies or procedures or methodologies, anything that might impact the rating process. Now, changes to rating methodologies are interesting because we're actually prohibited by statute from regulating the actual substance of those methodologies. However, we do examine the internal controls around the creation of new methodologies and how they're modified too. And what we're looking for there is to ensure that there's no commercial influences on the methodologies that would in turn impact the quality of the credit ratings. So, and of course our teams are flexible, things that might come up during the exam that they didn't know about prior. They're flexible to kind of shift resources when needed. So that's basically how we do our risk assessment.
Thanks, Scott. We've kind of framed now how we think about priorities, but Vanessa, why don't you lead us through what IAIC is thinking about as far as 2026 priorities?
Yeah, 2026, and it's hard to believe we've already started on 2027. Time flies when you're having fun, I suppose. But this year, we're highlighting a focus on retail investors, including, I like to say, more seasoned investors, because if I say older investors, I think I include myself, and also retirement accounts and products. Areas of fiduciary principles include emphasis on recommendations of certain alternative and complex investments, as well as products with higher costs associated with investing. And we're also turning an eye towards private fund investors, where we have a focus on firms that are also advising mutual funds and separately managed accounts, as well as advisors who are new to advising private funds. We're also looking at advisors who utilize third-party access providers, and attention will be given to merged and consolidated entities in both the registered investment company space and the advisor space, and advisors with activist engagement practices, including those making late or inaccurate filings. So think about your 13D, 13G, File 13F, et cetera, and those types of filings. And lastly, we're going to turn an eye toward registered investment companies that participate in mergers and similar transactions, including any associated operational and compliance challenges, as well as RIC compliance and with the new names rule.
Thanks, Vanessa. Mike, what's going on in the BDX space?
Sure, thank you, Keith. There are certain items, as you look at our exam priorities year over year, that are just core to our respective program in the BDX. With regard to some of the core items that we'll look at, for instance, is financial responsibility rules. We will look at anti-money laundering. But when you look at the depth and breadth of the BDX program, we cover a wide swath of registrant types. So I'll go over some of the things that we're highlighting, which is kind of the newer items on our priorities for 2026. One is extended trading hours. As more and more exchanges make rule filings with the commission with regard to extending their trading hours to the 23/5, we're trying to be kind of a proactive regulator, and from a preparedness perspective. Working with our Division of Trading and Markets, we're actually reaching out to our registrants, speaking with our exchanges, and also trying to be ready and trying to get their perspective with regard to what are they going to do from a personnel perspective, what are they going to do from a systems perspective, from a surveillance perspective, so that when the time does come, when we do move to a extended trading hour on the national exchanges, we'll be ready. And we'll be examiner ready. So hope and expectation is to gather as much intelligence. These are not examinations kind of for rule violations. They're more for information gathering and intelligence gathering. Second is municipal securities. One of the responsibilities we have is looking at municipal advisors under BDX. So we will focus on the priority of orders as well as markups. Third, we're going to look at disclosures regarding order routing and execution. Prime brokerage is our fourth item, one of the newer items in our exam priorities. As prime brokerage continues to grow at some of our registrants, it's an area of focus for us. We're going to look at certain key areas within the prime brokerage area, such as concentration, such as liquidity, and counterparty risk, 3 important components with regard to prime brokerage. Regulation best interest. Now, you'll see this year over year if you look at the past years of our priorities, but what we tried to do this year was highlight some of the particular products that we're going to be focusing in on. As you're well aware, the regulation best interest is triggered off of a recommendation to a retail investor, but some of the items that we tried to highlight were the variable and index-linked annuities, private placements, ETFs that have illiquid type securities such as private credit or private equity, and also municipal securities is also from a 529 plan perspective. Also, another area that we look at is on the national exchanges and the alternative trading systems. So we're going to look at ATSN as to what's being disclosed to investors, making sure it aligns to what's actually being disclosed. Also, the written safeguard of information with regard to the confidential information by the subscribers. And last but certainly not least is Regulation SP. I'm sure Alexis will talk a little bit about more later, but we're going to just look at some of the ones that will come this summer, some of the smaller entities, particularly the transfer agents and funding portals. So with the transfer agents, it's definitely new to that registrant type, so we'll try to go in sooner than later to make sure that they're complying with what the expectations are with Regulation SP.
Thanks, Mike. We'll turn it over to Alexis when you're not staring into the void at all the cyber threats. What's TCB up to?
Yeah, so each year we focused on cybersecurity practices by registrants to help ensure the safeguarding of customer records and information as required by Reg SP. And as Mike mentioned, the Commission did adopt amendments to Reg SP in 2024. These amendments require certain registrants to adopt written policies and procedures for incident response programs, which include providing timely notification to individuals affected by an incident involving sensitive customer information. As noted in our priorities, we will continue to assess compliance with Regulation SP, and while the purpose of these examinations is not to solely focus on the new amendments, exam staff may evaluate firms' compliance with the new provisions where applicable. I'll also note that in the Regulation SCI space, we're focusing on incident response policies and procedures, as well as SCI entities' management of third-party vendor risk.
Thanks, Alexis. And I think, Scott, you talked about this a little bit, but what are your priorities for NRS exams this year?
Yeah, so a lot of our exam work each year focuses on management of conflicts of interest. So I described when I was talking about how we set our priorities, that can really be very firm specific depending on what's going on in a particular firm. So this year, we're continuing that work to ensure that potential conflicts are being managed appropriately and credit ratings are being issued free of commercial influences.
Thanks, Scott. And I can barely see Adam all the way down there, but what are your priorities for municipal advisor exams this year?
So I think to sort of continue what we've talked about in the past couple of years is that as the municipal advisor regime, regulatory regime matures, exams are focusing a little bit more on substantive conduct duties of municipal advisors, particularly the fiduciary duty, and how whether the advisors are complying with those duties when making recommendations, for example, regarding pricing or method of sale. And that not only includes SEC rules, that includes MSRB Rule G42, which has core conduct standards for municipal advisors in there, including disclosures and conflicts of interest and how to document relationships. And of course, there's always still the continuing focus on registration requirements. Are advisors keeping up with their filings? Are they making proper annual updates and amendments and things like that?
Thanks, Adam. Let's shift gears a little bit. We're going to stick with you. Obviously, exams is one of 6 divisions at the SEC, and there's a number of specialized offices like OMS and OCR. How does OMS work with other SEC divisions and offices?
Sure. So generally, because we're a subject matter office, people in the other divisions and offices ask us all the time, does this thing that we're doing or does this thing that happened in the news, impact the municipal market, and how does it? And sometimes we have to, walk through the ways in which the regulation of the municipal market is different than most of the other securities sectors. So that's sort of an ongoing thing. Specifically with exams, we work very closely, and one of the things we do work with exam staff on, particularly BDX staff, is what we call the exam kits. so that, we can lend our subject matter expertise and, help the examiners know, in this particular subject area, these are some kinds of documents that the, advisors are likely to have, or the dealers in some cases. These are the kinds of questions you might want to ask to really drill down on compliance. So we try to develop those so that there's consistency, like Mike was talking about earlier. We do consult on individual exams when there may be a particularly thorny municipal securities issue. Exam staff will meet with us and we'll work with them on that. We have regular meetings, at least quarterly, with BDX staff. And then lastly, we also coordinate very closely with the Physio Office of Exams on and their examinations of the MSRB, setting those priorities, and again, sort of, what are the kinds of questions and documents they might want to ask about.
Thanks, Adam, and we certainly appreciate the partnership. You mentioned Mike, so I'm going to toss it over to Mike.
Well, thank you, Keith, and Adam, thank you so much. I think that's spot on. So much time is spent working with our policy divisions. I will tell you that sometimes when you look at our examinations and the examiners are in the field, there's a lot of behind the scenes working with our policy divisions. An example I just gave before is just on the extended trading hours. When you look at our Division of Trading and Markets and exams working together side by side to gather intelligence, making sure that, as we said earlier, one of our 4 core pillars is informing policy. Also, when we conduct our examinations, as Adam said, we work with Office of Municipal Securities, Division of Trading and Markets, Corp Fin. So, for example, if there is a novel issue or an issue that requires interpretation, the examiners will work with our policy divisions, get their insights and thoughts. So before we even think it's a deficiency, we'll get their insights and get their read as to whether we think there's an issue or not. Also, they help us inform, as we said earlier, our exam priorities. So we reach out to those policy divisions to get our exam priorities and also emerging issues. They do help to, as Adam said, we meet with OMS quarterly, we meet with our Division of Trading and Markets, and as we get intelligence from them, it does help to shape our examination program, what areas of focus we want to focus in on a given examination. So when you look at overall the coordination and collaboration, so it goes a long way of working together side by side. And I said one example before was emerging issues, even in the past, T+1. So it's not something new, it's something we've always done and something we'll continue to do, Keith.
Thanks, Mike. Vanessa, what about IAC?
Yeah, we're no different. I mean, I think one of the strengths of the SEC is the collaboration that we have within the building. There's a lot of coordination and collaboration that we have that's similar to the broker-dealer collaboration. We also coordinate with other divisions, particularly the investment management. And we do so for the same reasons, though we look primarily through the lens of impact to investment advisors and investment companies. And there's a vast amount of knowledge and data within the agency which we review. And we also look to that when we're determining our priorities as well. And so we are well served in any division, in any component program to not act within a silo and take advantage of the data and the information we have within the agency. As Hayne mentioned earlier, one way we coordinate with other divisions is developing our priorities, which is a very robust process that is happening actually right now. And we are currently undertaking that process to, again, hopefully be able to publish priorities at the end of our fiscal year to better align with when you're actually thinking about planning for your next year's. So we reach out to many other divisions to see what we're seeing in terms of risks, both now and potentially around the corner. And throughout the examination process, staff may consult or coordinate with other commission staff regarding any issues that we identify in terms of interpretation or application of the securities laws and rules that we follow.
Thanks, Vanessa. And obviously at the commission, we've got this tripartite mission and recognize that our exams, there's a cost associated with it. And I think Commissioner Gower would probably agree. In the financial services sector, it's a pretty busy space with a lot of regulators that have very important things to do, but there's a cost potentially associated with that. So I want to talk a little bit about collaboration. Maybe we start with Adam, how you collaborate with other regulators in the space.
Sure. I mean, I think for us, the main agencies that outside of the SEC that we coordinate with are the MSRB and FINRA. And one of the most public ways we do that is we do Usually annually, we host a joint, what we call the JCOP, Joint Compliance Outreach Program. It's an annual conference jointly hosted by the 3 agencies where we'll have various panels on compliance and hoping to both inform regulated entities about what's going on in the compliance space, but also to hear from regulated entities in the public about what we might be able to do better in terms of providing regulatory clarity and consistency and efficient markets. So we have those conferences. We have regular coordination meetings, which exam staff also participates in with the MSRB and FINRA, sometimes just with one agency and sometimes all 3 of us. We try to do at least once a month, all 3 of us. And then, also, as I mentioned before, the oversight of the MSRB rulemaking process is, within our office's, responsibilities, sorry. And, but we also work very closely with Physio in terms of their examinations of the MSRB. So we really do coordinate both within and without in terms of oversight of the MSRB.
Thanks, Adam. And Mike, how does your team collaborate and coordinate with other regulators?
Sure. We collaborate both domestically and internationally with the regulators, with the goal being to avoid, as much as we can, regulatory duplication and overlap. So what we'll do is we work closely with FINRA, especially with regard to the broker-dealers and funding portals. We work closely, as Adam said, with MSRB as well, NFA and the National Futures Association and the CFTC, our international regulators as well, and also the banking regulators, with regard to our transfer agents, also with regard to our government securities dealers, and also with regard to our transfer agents. Since many of them are also part of the bank holding company, they have responsibilities. So to avoid that overlap and duplication, we work closely with them. We have ongoing meeting with them as well to make sure that we're sharing our exam schedules, also sharing what areas of review we want to focus in on, and also on emerging issues, making sure that we're, informing each other of what we plan to focus in on. We understand the finite amount of resources that you have at the registrants as well as we have at the agency. So the more that we can work together, avoid the duplication, and minimize any overlap, I think goes a long way for both the registrants and the regulators.
Thanks, Mike. And Alexis, I'm going to turn to you. We have a narrow but very important oversight of critical infrastructure in the financial markets. How are you and your team tied in with the interagency?
Sure. So similar to what Mike noted on the examination front, TCP staff also coordinates with other regulators such as the Fed and the CFTC on both a routine and ad hoc basis. First, I'll highlight that the Fed participates in certain exams of the SIF moves for which the Commission serves as the primary regulator for Title VIII of the Dodd-Frank Act. And similarly to what Mike noted, TCP staff also coordinate with the CFTC with respect to entities that are jointly registered with both agencies. And lastly, in that front, I will point out that we routinely engage with the Fed and the CFTC trilaterally, and these meetings serve as a forum to build stronger relationships among the agency staff, as well as to share information regarding a variety of technology topics. I also want to note that TCP's Cybersecurity Program Office supports the Commission's participation in the FIBIC. And that's an organization charged with improving coordination and communication among financial regulators, promoting public and private partnerships in the financial sector, and enhancing the resiliency of the financial sector overall.
Thanks, Alexis. And I think several folks mentioned the CFTC. We certainly have a robust relationship there, but very excited about the new MOU that the chair announced, I think it was a week or two ago, that will help us to deepen that relationship as well. Maybe briefly we'll go outside the U.S. What kind of coordination, if any, are we doing on the international space? And I think Haynes got a touch, and then maybe we'll go over to Scott as well.
Yeah, so we contribute to international work streams, FSB, which is the Financial Standards Board, or IOSCO, International Organization of Securities Commissioners, on topics that are relevant to the registrants we examine. And, part of that is some of the themes you're hearing here, right, to try to promote some convergence towards high-quality standards and practices and sort of reduce some of the burdens if we can. And then separately, in close collaboration with our Office of International Affairs, as Vanessa mentioned, right, we do some of these international exams, so we cooperate with foreign regulators in the examination of SEC registrants located abroad, again, seeking to minimize that sort of burden. And then we provide technical assistance to international regulators, helping them, as they're developing their programs and thinking about some of the same issues that we all think about.
It's similar with the NRSO space. Many of the NRSOs have a global footprint. So, for example, the larger rating agencies have offices around the world, and even some of the smaller ones have offices abroad. We actually have 2 registrants that are based solely outside the U.S. We have one in Japan and a new registrant that just registered recently in Peru. And so due to the international nature of their businesses, many of the NRSOs are not only regulated by the SEC, but also regulated by local authorities in various jurisdictions. So because of this, we find it helpful to collaborate with those foreign regulators, and the way we do this is by participating in regularly scheduled meetings with them. And this includes something we call the supervisory colleges, and that's just like I said, it's a regularly scheduled meeting, usually quarterly. We have a call with them, and we talk about various things that affect the industry, like results from exams, emerging risks, and things like that. And it's interesting to me to kind of hear their perspectives, because they're kind of sometimes thinking about things differently than we are, and kind of understanding what they're seeing and why they're thinking about things the way they are is an interesting thing to kind of inform our program, and we think about that too. So that's how we collaborate internationally.
Scott, and we'll come back to Alexis. I know you have a number of international engagements as well.
Sure. So we also work closely with the Office of International Affairs on international matters related to cybersecurity, and I'll spare you feeding you all the alphabet soup of acronyms for the groups that we work with, so I'm just going to go ahead and read them out. So some examples of the groups we work with are the G7 Cyber Experts Group, the Financial Stability Board Standing Committee work streams related to cybersecurity and operational resiliency, the Bank for International Settlements Committee on Payments and Market Infrastructures, and lastly, the International Organization of Security Commissions.
Yeah, I think the number of acronyms is directly related to your performance review. So as many acronyms as you can get. And what don't we stay with you? I know that TCP has made a significant effort and investment on outreach for Regulation SP and had 3 events. Can you kind of talk through that a little bit?
Yeah, sure. So we recently held Regulation SP compliance events. There were 3 events, each dedicated to a registrant type. So we had events for large firms, small firms, and then also transfer agents. We had staff from the divisions of investment management and trading and markets join us to provide an overview of the core aspects of the regulatory framework. And our exam staff walked the audience through what to expect on an examination. At our small firm event, we even engaged in an incident response tabletop, reviewed a sample document request, and demonstrated a mock examination session. Over the course of the 3 events, we were able to help more than 6,600 people better understand their compliance obligations under the rule. Recordings of all 3 events are available on sec.gov, and our SP outreach team will host a similar event today at our 4:30 workshop.
Thanks, Alexis. And Vanessa, I know your team hosts every other year a large outreach event for investment advisors and investment companies. Can you talk a little bit about that?
Sure. Sorry, I was trying to come up with some acronyms so I could get a performance review. But most definitely, we love to engage with the industry, and so we do host an annual national seminar, and we've been doing so most recently in a hybrid approach, and actually streaming it through sec.gov, our public-facing website, and we've had over 15,000 folks who logged in to watch and really, like I said, love to engage with the industry. We also hold regional events throughout the country, but our national seminar we typically hold in the fall, and we are currently planning for it right now. I don't have an exact date to give you as of right now, but we will be announcing a date at a later time, hopefully pretty soon, and we'll have a way you can register for that event. CCOs or other senior officers should contact compliance outreach at sec.gov if you're interested in speaking at the event. We do engage folks from both inside and outside the building, so we would love to have you reach out to us if you would like to share suggestions or certain panel discussions. Again, I'll repeat that, compliance outreach at sec.gov. So our investor and industry outreach is a key cornerstone of our program, and so additionally, several regional offices are planning in the planning stages for regional outreach events. For example, a little plug for our Atlanta regional office. They're holding a regional event on May 12th, and check the sec.gov for up-to-date information on that.
Thanks, Vanessa. Let's transition maybe to a more specific topic. Obviously, several years ago, the Commission modernized rules governing IA advertisements and compensation. Pretty significant adjustment because it had been largely the same for several decades. Are there any updates for the marketing rule examinations?
Sure. So obviously, as probably many of you know, with the marketing rules, soon after the compliance date, which was back in November of 2022, it's hard to believe that so much time has gone by since then, as it was quite the sea change for our program, and we realized quite the sea change for the industry as well. But since then, we've issued 4 risk alerts that have been highlighting the staff's focus on the compliance with the marketing review, and conducted both national initiatives and broader reviews through our examination process. Just a little bit about the 4 risk alerts, which are all available on our website, sec.gov. The first one was in September of 2022, closer to the release date, which focused on policies and procedures, substantiation requirement, and performance advertising. The second risk alert examination focused on additional areas of the advisor marketing rule. We're really clever with the titles of the risk alerts, apologies. That was in June of 2023, and that one focused on the review of advisors' marketing practices that we further identified through our examination process with regards to testimonials and endorsements primarily. There was a third risk alert in April 2024, initial observations regarding Advisors Act marketing rule compliance. And that one focused on the books and records rule as well as general prohibitions. And the fourth and most recent one was in December of 2025. And again, that was on the testimonial and endorsement provisions within the marketing rule. Again, these are all found on our website.
Thanks, Vanessa. And Hayne had mentioned that our priorities are a mix of new and perennial issues. Mike, over to you. Any heightened focus areas for BDX?
Sure, Keith. 2 areas come top of mind. One is private placements, and with regard to private placements, we're looking at it from different perspectives. First and foremost is how you're identifying your investors, meaning are you using general solicitation. As you're well aware, 506C allows general solicitation, 506B does not, so making sure that firms are complying with the requirements are under those regulations. Also, communications with the public in terms of sales literature. Is it fair? Is it balanced? Is it not misleading? Also, we are looking at regulation best interest. If you are making recommendations to retail investors, is it in the best interest of that retail investor? And last but certainly not least is the due diligence with regard to the issuer itself. So before considering making recommendations, has the firm done adequate due diligence with regard to the issuer? With regard, second area, Keith, is in regard, as I said before, a cornerstone rule for us, or reviews, is our financial responsibility rules. So looking at net capital and the accuracy of net capital. Also, books and records and the financial records that need to be maintained is something that we will focus in on. Also, your financial reporting. There's many schedules and supplemental reports that need to be filed with the agency that we will look at for accuracy and completeness. And lastly is funding and liquidity, and making sure that firms have risk management controls in place for those stress events, making sure that if there is a stress event, that customers have access to their funds and securities. So 2 key areas is private placements and the financial responsibility rules.
Thanks, Mike. Let's turn to issues of information security. Alexis, what significant threats are you seeing firms face these days?
Yeah, I would say that ransomware remains a top operational threat, and extortion tactics have evolved beyond encryption. Threat actors increasingly steal information first and threaten disclosure and follow with disruption, creating simultaneous legal, reputational, and operational pressure. Initial access often stems from preventable weaknesses, with a sharp rise in social engineering-driven compromises tied to weak access controls and human error. In addition, cloud and third-party ecosystems expand the attack surface, and stolen credentials enable cloud movement, third-party ecosystem abuse, ransomware stages, and in many cases, fraud. And lastly, I'll note that AI is a force multiplier for attackers who weaponize it for phishing and deepfake impersonation.
Now, when you're integrating with the registrants or what your staff is seeing, are you seeing more sophisticated attacks utilizing 0 days, or are these sort of lower-end attacks?
Yeah, I would say that most successful attacks rely on basic scalable techniques, The bulk of successful compromises still come from exploits, stolen credentials, and phishing or pretexting, and not exotic zero-day operations. Advanced techniques, true zero-day exploitation, custom malware, or complex multi-stage intrusions are typically reserved for targeted high-value environments, such as major financial institutions or key vendors, and these actually represent a small share of overall attack volume. And so the bottom line is that most attacks that succeed do so because basic controls fail, not because adversaries deploy cutting-edge zero-day exploits.
So you don't necessarily need to be faster than the bear, but you probably don't want to be the laggard.
Right.
And so when something happens, what role does TCP have in cyber events?
Sure. So TCP's Cybersecurity Program Office is the designated lead of our agency's Cyber Incident Assessment Team. It coordinates outreach to registrants to review potential impacts related to significant cybersecurity events, and it also coordinates external support activities in accordance with the national and financial sector cyber incident response plans. For significant cybersecurity events, the CPO focuses on key cyber assessment areas, which includes, for example, assessments of the operational impact of the event, the containment status, and the incident type, attack method, and threat actor if known.
Maybe we'll stay with the theme of technology, artificial intelligence. Vanessa, what are you seeing registrants doing with AI, and what issues do you think that raises?
Yeah, that's the buzzword of probably the century. I was about to say the year, but I'm sure as advancements come, there's a lot happening in the AI space. But just taking a step back, we as an exam program, we're technology neutral. So our registrants range from the largest asset managers to one-person shops. So there's a broad range of technology uptake by some of our firms. And while AI has been around for many, many years, it's fair to acknowledge that artificial intelligence landscape in financial services is quite dynamic. And so we know firms are experimenting with it and developing new uses, particularly in the generative AI space. In fact, just yesterday I was speaking with someone who just said there are more questions than answers in the AI space, and I quite agree. With advancements in technologies comes significant benefits, but obviously there's also a lot of risks. There are some foundational principles around that ground our program's focus and how we approach artificial intelligence, and our job is to just understand the uses of AI and the attendant risks and assess whether the registrants and firms are meeting their regulatory obligations when using these technologies.
That's great. Let's pull that string a little bit. What should the firms consider when they're deciding whether or not to utilize AI?
Yeah, so one of the things you probably always hear is keep a human in the loop. And I think that it's important to note that these tools do not eliminate, on the advisor side, the duty of care and duty of loyalty to their clients. And firms should really consider whether they have adequate policies and procedures in place to monitor and supervise the use of AI, and that their disclosures are accurate. And what does governance look like to ensure compliance when you're utilizing AI? On the disclosure side in particular, which is important to the advisor side in our regime, we're disclosure-based. So as you might imagine, with many of our examinations, an important aspect when we ask and dig into the use of AI, it's the old adage of do what you say and say what you do. So registrants' claims about the use of artificial intelligence should be properly substantiated and not mislead investors as to the extent of which registrant use of AI is actually being utilized in real life.
Keith,
Mike,
can I jump in on that one?
Please, yeah, absolutely.
I've been quiet. I've been lurking in the background, just soaking all this up. That's really interesting, Vanessa, on the AI thing. And just one thing, not even asking for an answer, but to call out to you is that as you conduct these exams of registrants, and that's on the broker-dealer side too, do know that, right, that you're right, you have to have policies and procedures, you have to use AI appropriately, but the ability of registrants to compete with unregulated AI-based systems that they're doing whatever they want, right? There's a lot of unregulated, unregistered activity that looks a lot like advisor activity, broker-dealer activity going on. And we're in this sort of middle ground of no national legislation on AI. From a policy perspective, is it okay for an AI system to do registered things in an unregistered way? And it's building, I would say, and we feel it too, tension in the regulated community because you feel a little handcuffed, right? Like I can't do the things that some unregulated third party. It doesn't mean you should say, okay, it's fine, go do whatever you want. But there is this tension building, and you're going to see more and more of it. And it's probably something to talk about with TM and IM as you see, because it really is a pretty important policy issue. You don't want your registrants to be disadvantaged because we're, so strict about the requirements. And then I'm just curious, again, sorry, Vanessa, I always ask you questions every year. But as you're talking about AI, how about, because you are really on the front lines, you have so many registrants. Last year, I think you told me it was 16,000. Is that about right? I think when I left the commission, it was closer to 11 or something like that. It's a huge increase. Are you guys thinking about using AI to kind of force multiply? Because you only have so many resources. And, I was there way back when we made the decision to take the broker-dealer folks and send them over to you and do the best we can. But, I mean, you're still outnumbered pretty dramatically.
Yeah, I'm going to take that one.
Yeah, sorry, Heen, I didn't know it was for you. It's a jump ball.
I think, yeah, cover just a little bit. I think the SEC has announced a chief AI officer. We have an AI task force that's been, public and part of the sort of the executive orders and OMB memos, et cetera. And so that's online. And within that, they have released on sec.gov a list of the ways in which the required disclosure that we have about how we're using AI within the agency, and so that's available for folks to look at publicly. And it's absolutely, I think we think of those technologies as a force multiplier. We have staff within exams who are, quants, who are highly technologists.
Yeah.
And so we're looking for ways in which, we have limited resources, absolutely. We have a growing population of firms, and so I can say that, while we don't necessarily go into specifics beyond sort of what's in that list, we are looking for ways in which to increase the efficiency for sure.
That's
using
awesome.
Technology.
Yeah, and I think this is the first year where this just becomes clear. I mean, there's been such a radical development in AI over the last 12 months, even from the last time we sat on this panel. And I think about the struggles we had with how are we going to do this with our limited resources, and hopefully AI is part of the answer. So good luck with it.
And I'll make my team very nervous now. That's the problem of having someone in my position that has a technology background. I think there are a lot of opportunities here, and I think it's not just the technology, it's also to conceptualize the cultural aspects of doing things in a different way to be more efficient.
Yeah, and there's this theory, right, that, there's nervousness, like, oh gosh, is my role going to be, there's no way, given the numbers, and that you're going to get replaced by it, but making each member of the exam team smarter, smarter, more efficient. They talk about this in the legal profession too, right? Lawyers aren't going away. It's just who's using this technology to make themselves a super lawyer. And I think it's going to apply across, professional services generally. But this is like a unique, just given the construct, given the lack of an SRO for advisors, right? Like, how do you do this? And hopefully, I know there's no magic bullet. I know you still have to do good old-fashioned gumshoeing, but this definitely, I think, can go a long way.
Absolutely.
I have a question for Alexis, too, if I'm allowed.
Please.
You mentioned, so Reg SCI, I voted on that, which tells you how old it is. How's it aging? I know I'm not aging well. How's Reg SCI aging?
Yeah, well, of course, my opinion is probably biased, but I would say that it's aging quite well. We have seen entities mature in the technology space as far as our entities that represent the critical market infrastructure. I think that we've had a few examples. It's kind of hard to quantify it because, we're looking at the things that did not happen, right? So when we look back through maybe periods of high volume or, having during COVID time and the market halted, nobody really, or the public, we worried, but the public wasn't really all that concerned or aware that the technology behind the plumbing could be an issue. And what we've seen is that during these times of high volume that require a lot of capacity, things have held up. And we've also seen the SCI entities, thank goodness, hold up against all the threats that are out there as far as, intrusions and those kind of things are concerned. So, of course, in my opinion, I think it's aging quite well, so I'll thank you again for voting on it.
And I voted for it, to be clear, which was rare for me in my tenure. And we struggled back then with how do we write this rule, or how do we make this rule so that it's not about today's technology, that it can be, right? Which, I give the staff tons of credit because, so many other things, like even CAT, which is, hotly debated, we had no idea, and it was written for that technology in 2012 or whenever, that final vote was. But Reg SCI we took a step back and said, hopefully this rule can be technology agnostic and work in any setting, so.
Yeah, and I think that actually has gone a long way in its success, in that it really is about reasonable design, and it also is technology neutral. So it provides an opportunity for it to grow along with the technology. And then I'll also note that although it's not a requirement to follow industry standards, the fact that it references them and the industry standards continue to evolve, I think that provides a nice anchor for people to kind of look at to see, at this point in time, what are we talking about as far as reasonable design is concerned?
That's awesome. Thank you.
Mike, I did want you to come in on AI, what you're seeing in the BD space.
Oh, absolutely, Keith. Thank you. Just picking up where Vanessa left off on AI and the importance of what we see many of our registrants doing and what we think is, and we want to share with you today, is governance, and kind of looking at it from different prongs and kind of looking at it across the, what is it being used for? Where is it being utilized? How is it being utilized? And pretty much for all intents and purposes, kind of getting your arms around those aspects of it. Governance is critical, especially on the use cases, and knowing what individuals have access to what information is being put into specific models. One thing we're not here is to chill any effect on AI. We understand the importance of it for the registrants, as Dan has mentioned, and others, the importance to the regulators as well. But we also want to make sure that compliance plays a role. And we think it's important that compliance plays a role. They have making sure that complying with the regulatory responsibilities that go along with the use of AI and the supervisor responsibilities. So those are some of the takeaways we just wanted to highlight today, but I'll turn it back to you, Keith.
Thanks, Mike, and I know we're kind of turning on to short final here, so maybe we'll shift to what the future holds. Vanessa, any insights on current focuses or future focuses?
Sure. It's for our space, I would say, what's old is new again. Fiduciary duty, duty of care, duty of loyalty, disclosures, appropriateness of account selection, making sure that, for example, you're disclosing the conflicts if you're dual-hatted in the brokerage space and the advisory space. How to mitigate and fairly disclose any of those conflicts of interest. Non-standard fee arrangements, those continue to be a consideration in our space. And looking at some of what you've probably seen in the media, the volatility, valuation, those issues continue to be of concern for our space.
Thanks, Mr. Mike, over to you.
Sure. As I said before, the financial responsibility rules are kind of our two prongs. I talked about the capital computations and the accuracy of that. Along with that is the customer protection side, with regard to the reserve formula, possession or control, are cornerstone areas of review that we do in the BDX program. As I said before, private placements is an area of focus, and along with that, regulation best interest continues to be something we look at on many of our examinations.
Thanks, Mike. Alexis.
Yeah, so I mentioned a few things that we were looking at specifically in the SCI and SP space, but we're also going to continue to focus on cybersecurity practices more generally, including security controls that registrants are employing to identify and mitigate risk associated with artificial intelligence, and also how registrants are using information from threat intelligence sources.
Adam, what about OMS?
So we're looking at continuing to look at ways in which we can provide regulatory clarity to the market. We receive requests for guidance or exemptive relief or things like that. So we're continuing to look at that and try to provide clarity. Another substantive area is we continue to look at unregistered municipal advisory activity. Obviously, those unregistered firms aren't getting examined, so that's something that we're continuing to, look at, and, how can we bring in the firms that are doing this work and aren't registered? How can we reach out to those types of entities, particularly in the charter school and P3 space, but also others, and bring them in to the compliance world. And then we will have another compliance conference, like I mentioned earlier. The last one was this past January, so I would guess we haven't had a date for it yet, but hopefully late 26, early 27, another compliance conference where we can talk about all of the new things that we talked about today.
Thanks, Adam. Scott, what about OCR?
So with OCR, we're currently in the middle of our 2026 exam cycle, so a lot of our teams have either just finished up their on-site visits or they're preparing to go on-site shortly. One thing we have coming up is we're going to be meeting with the boards of directors for a lot of the NRSROs, so that's probably the next couple of weeks that we have scheduled. And then we're also working on, by statute, we're required to publish a report each year, so we're actually working on finalizing that report. And that report contains a lot of the, it summarizes the exam findings from last year's exam, plus a lot of other information that we include in there. So if anyone's interested in seeing our previous reports, they're on the OCR page on the SEC website. That's it for us.
Thanks, Scott. And Hayne, I don't know if you have anything you want to add?
Just in terms of upcoming year, yeah, I think we continue to focus on those emerging risk technology and trying to feed that really into the programs and working closely both within the division, but certainly with our colleagues in IM, TM, and the other policy divisions, just ensuring that we're incorporating their thinking as we're identifying various risk areas for examination, for consideration, for exam planning and candidate selection.
Thanks, and Commissioner, I don't know if you had any last thoughts or questions for us?
Always, but it's really good stuff. I mean, it's amazing how comprehensive the presentation was, and I think the call out on unregistered activity, I think it's more than I've ever seen. And it's not all, maybe not even majority nefarious. I think it's with the advent of a lot of new technologies and folks who just aren't aware of the regulatory environment, you're going to just see more and more of that. And I think even though you don't examine them because they're not registered, having an awareness of the environment, which I think you can get through the regulated entities, understanding from them what they're seeing competitively and the like, I think is just going to be very important for you programmatically. Because again, you don't want a world at the end of the day where the properly registered and regulated entities are at a disadvantage. And if that forces a policy call, not necessarily an enforcement referral, but a policy call, then I think all the important, you guys are on the ground getting this information. It's, policy needs to be informed somewhere. And, the folks who are unregistered aren't exactly going to, ask for a meeting with trading and markets to talk about their unregistered activity.
So well said, and I think thematically, as we've been talking about the importance of that integration with the other divisions or offices that may have tools that we frankly just don't have in order to be able to deal with these things, and I think information sharing and some of the other themes that we've talked through here are really of critical importance.
And congratulations to you, Mr. Division Director. It was not a division when I left, it's a division now, but I did work with Keith in different capacities, and great leader and terrific public servant.
Much appreciated. It's my privilege. And I think we're pretty close to time. So first, I want to thank Commissioner Gallagher for his questions and valuable insight. Glad you were able to join us again. Maybe next time we won't make you go on 4 or 5 panels. But we definitely appreciate it. So it's great to see you. I also want to thank our panelists for their participation. It's interesting to hear all the things that are going on. And for those that are available, we'll have a workshop at 4:30 this afternoon, and the focus of that workshop is going to be on Regulation SP, and we certainly hope to see folks there and appreciate the time and the attention this morning.
Okay, last panel before lunch. So this is a focus on small business, which during my time on the Hill, every member of Congress used to love to say how small business is the engine of economic growth. Small business occupies kind of a special status at the SEC in that there is an Office of the Advocate for Small Business Capital Formation devoted to looking at companies that are looking to raise capital through exempt or smaller registered offerings and participating and reviewing SEC rulemaking and other actions that could affect small business. So this is a great role that you both play, and joining me or us now is Amy Reischauer and Jenny Riegel from the Office of the Advocate for Small Business Capital Formation. Amy is the Deputy Director of Outreach and Education, and Jenny is the Deputy Director of Policy. Welcome. Thank you.
Is this on? Yes, okay. Good morning, everyone. I'm Jenny Riegel, and I'm joined by my colleague, Amy Reischauer, and we want to thank you for the opportunity to join you today to speak about something profoundly practical: how small businesses raise capital. And we'd like your help in simplifying and improving that journey. But before we do that, let me note that we are providing our remarks today in our capacities as Deputy Directors of the Office of the Advocate for Small Business Capital Formation, and they do not necessarily reflect the reviews of the Securities and Exchange Commission, the commissioners, or other members of the commission staff. Now, turning back to small businesses, every business starts with a great idea. Maybe it's at a kitchen table, scribbles on a napkin, or a phone call to a friend who may become a first investor, or a community seeking to tackle a common problem. Our job in the Office of the Advocate for Small Business Capital Formation is to make that journey from the proverbial kitchen table to the cap table understandable and navigable. We like to frame our work with a simple loop: listen, learn, improve. We listen to founders, their investors, and their advisors and ecosystem builders that support them. We learn what's happening in the market and how different companies, investors, and geographic areas are affected by our rules. We work to improve things for capital raising work to improve things for small businesses by sharing that feedback with policymakers to enhance the capital raising pathways, and by incorporating those insights into education and further outreach. Our office was established by Congress to advance the interests of small businesses, from early stage companies all the way to smaller public companies. They're investors at the SEC and in the capital markets. That charge includes engaging with the public to share educational resources and identify and understand the capital raising challenges. That essential feedback informs everything that we do, including 1, analyzing the potential impact of rules on small business capital formation. 2, working with small businesses and their investors to help problem solve. 3, supporting the Small Business Capital Formation Advisory Committee. 4, organizing the SEC's annual Small Business Forum. And 5, preparing an annual report to the Commission and Congress on the state of capital formation.
So why is this work that our office does so important? Well, because small businesses are critical to the U.S. economy, to job creation, and to innovation. Entrepreneurship, as we've heard already, is a formidable engine of growth across the U.S., and access to capital is a national priority. Our office mission is to help small businesses and their investors navigate our regulatory landscape in order to raise capital to fuel that engine. So from North Carolina to California, from Montana to Arkansas, the feedback that we gather helps inform policy. It allows us to bring market perspectives to the discussions with the Commission and the rule writing divisions. We listen in places where capital is scarce, but ambition is abundant, because rules should fit the folks that are using them. This ongoing loop that Jenny mentioned, the listen, learn, improve, it really anchors our mission. A question for the crowd. Who here has struggled to identify that just right pathway for a client looking to raise capital? or has struggled to help them understand the many steps they may have to take to comply with it. Well, that's exactly why we've developed a suite of sort of small business-friendly resources to help exactly with that. Picture, if you will, a military veteran building a manufacturing startup in rural America, a community member considering investing in a local emerging fund, or an angel investor mentoring in perhaps a historically underserved neighborhood. These are just a few examples of the small businesses and investors that our office is engaged with and who make up a part of the 36.2 million small businesses. Businesses that are essential to that job creation and that innovation across the country that I talked about. We're proud to be part of an ecosystem that fuels this formidable engine of growth. And that's why access to capital is a national issue. It's not a niche concern. When entrepreneurs face capital raising questions, they shouldn't need to be experts in the securities laws to find their next steps. They should have access to resources and to advisors to help them answer their questions and to get them from that complexity to clarity. Our office is here to help educate and to guide them to appropriate resources, resources that even some of their advisors may find useful in helping them to prepare to raise capital.
So think of the capital raising journey as a trail. And the trailhead is our resources on small business. It's a central portal that organizes the resources across the phases of the journey. Encourage your clients and communities to bookmark it. Here's a quick tour. The funding roadmap is a printable overview mapping financing choices from personal savings to grants and loans to raising capital from investors and explaining where the securities laws enter the picture. The Navigate Your Options is an interactive choose-your-own-adventure tool that identifies potentially relevant regulatory pathways based on basic questions about the business. This tool is great for first-time founders and advisors triaging options. Our glossary includes plain English definitions for many of the terms that founders and investors encounter, including foundational terminology and specific investing and fund-related terminology, along with shortcuts to additional resources for those, like lawyers, looking to dig a little bit deeper. Building blocks are one-page explainers on the fundamentals, like accredited investors, general solicitation, private funds, exits and liquidity, consequences of non-compliance, and more, with new topics added and in printable versions to share widely. For those looking for a deeper dive, check out exempt offerings and going public pages, which provide additional information for teams preparing for a specific exempt offering or considering an IPO or wanting to learn more about public company obligations. Finally, check out our educational videos. Our Let's Talk Small Business series includes short interviews with entrepreneurs, investors, and ecosystem builders who provide tips and share insights on a variety of small business topics. Our rulemaking videos summarize new and proposed rules that may affect small businesses and explain how to comment and to share your perspective. Our tools seek to meet audiences where they are. They help small businesses navigate and help their advisors guide them from complexity to clarity. These tools exist to make the language and logistics of capital raising more accessible to founders and investors and the advisors who support them.
So at this point, you may be asking yourself how our office's mission and resources relate to you and your work. So where do you, who actually are knowledgeable in the securities laws, where do you fit into our Listen, Learn, Improve plan? Well, advisors and counsel are the closest to what's working and to where friction lives. You play a critical role for the countless businesses, investors, and ecosystem builders. We hope our resources help you to empower your clients and communities to make the best use of the valuable advice and time that you give them. So we hope that they provide a way for them to research, to reference, and to reinforce the guidance that you give. And we apologize if it might mean a few fewer billable hours for you. We also welcome your feedback, your comment letters, and your recommendations to help the Commission better understand the issues that you see and to think creatively to arrive at innovative and market-driven solutions to those issues. The Commission considers, values, and appreciates public feedback and perspectives in all of its policy initiatives. Your voice and your clients' voices belong in that discussion. Let us end where Jenny kind of kicked us off, and that's with that journey from the kitchen table to the cap table. Every founder's path along that journey should be understandable, navigable, and shaped by real-world feedback. With that in mind, here are 3 things that you can do for us. First, help companies, investors, and other advisors find our small business resources that Jenny talked about, so that more of them can reach the right guidance and ask the right questions earlier in their journey. Second, identify areas where more resources or tools are needed to support those businesses and their investors. Are there common misconceptions out there? Are there areas where the rules are confusing for clients? Let us know how we can help you, your clients, and your communities. And finally, participate in the discussion and encourage clients to share their perspectives. Whether it's at the SEC's annual Small Business Forum, or a meeting of the Small Business Capital Formation Advisory Committee, a policy roundtable discussion, or an open comment file. We've certainly heard about a few of those in the last 24 hours. Help us improve by sharing your experiences, highlighting what's working, and identifying where changes are needed. Your work and expertise in across the market is a really valuable data set. When you share that data set by offering feedback and submitting comments that are grounded in client experience, you help us see where compliance maybe bites harder than it's intended, or where clarity could unlock responsible capital. As you advise and counsel your clients, don't just interpret the rules, help improve them. Tell us what you're seeing and be part of improving the market and the regulatory landscape. Together, we can make capital formation marketplace work better for everyone. Thank you for partnering with us as we listen, learn, and improve.
So we are on a break until 1 o'clock, when we'll resume with the accounting panel. Thanks.
So good afternoon, everybody. Thanks for still being here. As those from this morning might remember, during the enforcement panel, we got a pretty hard pitch by Ryan to cancel your lunch and to come for the funny auditors and or accountants panel. So here we are. I don't know how many of you canceled your plans, however, thank you. And as I said in the green room, Ryan has set a high bar for Kurt and the team. So I'm happy to introduce the next panel, which will be moderated by Kurt Hole, who became the SEC's chief accountant in July of did I say July? January? Wait, July 2025, sorry. We've had very tight time frames. Before that, he was the founder of CLE Advisors, which helps businesses navigate the complexities of auditing, regulatory compliance, risk management, and IPOs, which was enough to drive you back to the SEC. But before that, he was a partner at Ernst & Young in a variety of roles, culminating in Global Deputy Vice Chair of EY's Global Assurance Professional Practice. During his prior SEC service from '89 to '97, he authored what became the Financial Reporting Manual, a primary guide for the SEC accounting staff and practitioners. I'm going to remember this admonition. Before starting this panel, I ask that you please consider the comments of the session's panelists. So thank you very much and look forward to laughing a lot.
Judging by the audience, my powers of persuasion to get you to cancel your lunch plans didn't go over so well. But they're the losers in that situation because you all are going to really enjoy this because I'm joined with my distinguished colleagues here, Kurt and Heather Rosenberger, the Chief Accountant of the Division of Corporation Finance. You got to hear it again. I'm sorry, but before we get started, I have to say that the views we're going to express today are our own in our official capacities and don't represent the views of the commission, commissioners, or other members of the staff. I also get to say, to the extent that we talk about any enforcement matters, we would remind you that we're only referencing the facts that were alleged in the commission's order or complaint. I want to start with operational updates for each of you to have an opportunity to share about what's up with your respective offices. Kurt, you have been busy adding to the OCA team. You got to send some annoying interlopers back to the divisions from whence they came. But tell us a little bit about OCA and how it's changed since you arrived in July.
Yep, so thanks, Ryan. My wife told me never to try to be funny because I'm not. So I'm not going to be funny today, but we do have some interesting things that we want to cover with you. As it relates to operational, yes, we had Duck Dang, who was the acting chief counsel of the Office of the Chief Accountant. He has gone back to be the deputy director of the Corporation Finance. He's a great lawyer. He knows something about accounting, and he's got a good temperament. So he'll be okay in Corp Fin. But that leaves a hole for us to fill in the Office of the Chief Accountant. And it's actually a really exciting time to be in the Office of the Chief Accountant because we're doing a lot of things. We have a very ambitious agenda of things that we want to accomplish here over the next couple of years, starting with working with all the divisions in the building on rulemaking as they relate to accounting or disclosure aspects related to financial statements, financial presentation, the markets and market regulations. We also have our responsibility for the oversight of the Public Company Accounting Oversight Board, PCOB. Lots going to happen in that particular area as well. And then we're also working on a fairly bold initiative relative to international standard setting reform. So it's a really exciting time. There's a lot of things going on. So if you know anybody who's got some securities background, who knows something about accounting, who knows something about how the SEC works, and wants to be chief counsel, let me know. Send me an email or give me a phone call. When I came to the office in July, I remember sitting with the chairman upstairs in his office, and he said, "I'm not quite sure what the state of things are down there, but I'm sure you'll figure it out and fix it." So when I got there, we were down about 40% of our usual complement of people. We have a small office. I say we're small in size but large in stature within the building because we're the Commission's primary advisor on all accounting and auditing and financial statement reporting matters. The government shutdown for 43 days didn't help the effort to try to hire people, but once the shutdown ended, thankfully I was able to hire 3 new deputies who were all vacant positions, one for accounting, that's Mihao Duja. We had one for accounting, Sherry York, and then one dedicated for all our international activities, Emily Fitz. So all 3 of those got in place in January, so I'm feeling a lot better and sleeping a lot better at night. We were also able to reconstitute our professional accounting fellow program, which normally has about 14 PAFs in it. When I got to the office, we had 5. So we were able to hire for 9 new PAFs. They're all in place, and they're all working. So we're almost back to a full complement of people. This summer, obviously, we'll lose 4 PAFs who will rotate back, and we'll go ahead and post that here within the next few days. And then from another operational perspective, I wanted to do a shout out for Nicolina McCarthy, who's the new chief accountant for the Division of Investment Management. I think that was named this week or last week. We're anxious to get work with her. We're doing a lot of things with the Division of Investment Management, particularly around some of the valuation issues relative to some of the private markets. So we'll be working closely with the Division of Investment Management.
Great. Heather, you want to give us some updates for things in Corp Fin OCA?
Yeah, I get a short and sweet update, I guess, from me in terms of resource-wise from our office. I think we've been, we still have some declines that Kurt mentioned, but, the biggest change we've had recently is we had an acting deputy that we were able to make permanent. So Melissa Ramanpour is now one of our permanent 2 deputies. So from that perspective, our leadership team is in full force right now.
Great news for the office. Yesterday on the Corp Fin panel, Duck was talking a little bit about the backlog coming out of the shutdown. I guess I should take this opportunity to personally apologize for my role in that because Duck was sitting on floor 6 with us during the shutdown, and I would walk down and bother him anytime I had a question. But don't call the government inefficient because they did move him down to 4 so he can be closer to the DRP. But how's the backlog going? A little bit more from the Corp Fin OCA perspective.
I would say there's probably still a small handful of matters that we're resolving from consultations from the DRP related to sort of that shutdown period. But I think we've pretty much stopped talking about the backlog, at least in our office. We're on to all the additional activity that's occurred since then in terms of the waiver and the interpretive request volume that we'll talk about a little bit later today. The other thing I wanted to mention, though, in that respect, and you may have heard Duck say this yesterday, but I think it's important enough to reiterate. With respect to that backlog, I think Duck had mentioned that, and you guys probably saw this too, some of the turnaround times on comments that was coming out of the disclosure review program were longer than they had historically been. And I think Duck mentioned, and I wanted to reiterate, that we're sort of back at that average 30 days. That's sort of getting back to sort of normal operation times. You're always going to see some that are going to be longer, some that will be shorter, but moving in that direction. And then there was also a delay in posting comment letters. I know a lot of folks look at that data to just try to evaluate it, and so just really to understand that that's not currently representative of the work that's been done. There's about a 5-month backlog from that perspective. So I do just want to highlight those 2 points. And Ryan, we should give you, as the moderator, the opportunity to share your updates as well.
I do have some news to share from Enforcement OCA because we've been given the opportunity to hire for the first time in a long time. And specifically what we're looking for is talented attorneys and accountants who will augment our existing expertise with respect to auditing and financial reporting roles. So posting for supervisors in that group are currently up on USA Jobs, and more will follow for the line investigators, and that's attorney and accountant positions. So I would just take this opportunity to say that the hiring process has recently changed. I'd recommend reading the postings very closely and getting to a tight 2-page resume But we are anxious to have talented people who are interested in our mission come and apply. Speaking of auditing, Kurt, I know that Chair Atkins has mentioned the PCOB matters, and OCA has the broad oversight responsibility with respect to advising the Commission on its oversight. But some new board members, can you tell us about them and some of your priorities?
Certainly. So look, the PCOB is an essential element of the U.S. capital and really global capital markets ecosystem. They play a critical role in terms of oversight of the auditing profession in ensuring auditor integrity and compliance with rules and making sure that we have a good ecosystem around auditing. They're also instrumental and key in terms of advising other global regulators. They're a key element and part of IFER, which is the International Federation of Audit Regulators. So they play a big role in that in terms of the size of our market, the things that we do here. So the PCOB plays a really important role, and it takes up a lot of my office's time in terms of our oversight, since we have oversight responsibility for that organization. Last month, the Commission announced the appointment of 4 new board members, 3 of which were installed last month, and then one was George Bodick, remained on the board to serve the remaining portion of his time. That allows us to have some level of continuity on the board, which I think is an important element. I'm really excited about having this board. It's a very different board than we've had traditionally. This is, I think, is the first time that we've really had an audit practitioner serve as the chairman of the PCOB. Jim Logothetis is a longtime audit partner and leader in a fairly large accounting firm, served multinational audits and served as an audit committee chairman. He brings a much different perspective to this job that we're really looking forward to working with him. One other thing about Jim that I'll note, just because I know Jim, he's very dedicated to public service. His mission and mandate is to try to make the PCOB the best organization that it can, making sure that role within our capital markets is as strong as it can be. So he didn't really need to do this. He's retired. He's got a nice family, but he wants to do this because he cares about the profession. He cares about the U.S. capital markets. So I'm really looking forward to working with him in the next couple of years. We also have a very wide, a different perspective from other members. Steve Lawton was the counsel to Commissioner Ho, so he provides some level of carryover basis. He spent a lot of time at the Treasury Department. And then we have Mark Calabria, has a long role in government and can help us on various aspects. So we're looking forward to working with all the board members. I always look as change as an opportunity, right, for us to do things differently. One of the things that I do when I come into my office every day is to think about, okay, are the things that we're doing, do they still remain kind of fit for purpose? Are we really, is the way that we've been doing things still the right way to do it? Because the environment changes every day, and in this current environment, things are changing at breakneck speed. So what I've done is I've challenged the PCOB board to think about how some of these changes might change or necessitate change in the way the PCOB operates. So what do I mean by that? So one of the most obvious is most of the large accounting firms, all the accounting firms that practice with public companies have been required to adopt some level of quality control standard. So this requires them to evaluate the effectiveness of their system of quality control. So think internal control over financial reporting for auditors, right? So that's a big change. And that puts a big spotlight on the firms being able to document their system of quality management and evaluate its effectiveness. And it puts a lot more accountability on the leadership of the firm to make sure that their system of quality management's operating to ensure that the audits they do will be of high quality. So now presents a very interesting opportunity as to whether the PCOB might focus more on their system of quality management and how they do their inspections. I think if they make a change, I think it'll also give us an opportunity to engage with stakeholders, different stakeholders, about the inspection reports that are in the public domain. I don't know how many of you in this room or listening online have looked at a PCOB inspection report. I've engaged with and made it a priority to engage with audit committees, who are one of the primary users of inspection reports, to try to get some understanding about how useful they are to audit committees in their exercise of their oversight roles for auditors on public companies, and what type of changes and improvements we can make. We've also been engaging with various international audit regulators on the same topic, because again, all accounting firms globally have to comply with this international standard for quality control evaluation. So that's an opportunity, a change that presents opportunity for the PCOB to maybe change things up on the way they've been doing things. You know, as Laura mentioned, I spent time at the SEC in the late 80s, early 90s, and I've come back and then taken over the responsibility for an office that does a lot of consultations with registrants on accounting issues, very complex accounting issues. So when I think about how we interface with the companies that we regulate as an SEC, we're open, we want them to come in, we want them to consult with us. We try to help them as best we can to get it right before they report to investors. So, you know, that the thought of having the PCOB kind of operate the same way and say auditors having challenges implementing a particular standard or wanting to address particular issues, it would be great for the PCOB to operate and act a little bit like the SEC's Office of the Chief Accountant in being able to help registrars through consultation processes, providing out guidance when necessary, when there's not clarity in the standards or emerging issues. So another opportunity for them to make some changes there as well, particularly as it relates to their standard setting agenda. You know, if you think about how other standard setters in this world work relative to financial reporting, most of them issue like you know, an agenda consultation. What should we be talking? What should we be addressing? When should we be addressing it? And what are the most significant issues of the day? So, you know, look for some changes possibly in that area as well. The broker-dealer inspection program was formed about what, like something like with Dodd-Frank, something like 13, 14 years ago. It's still interim, so it's still an interim program. So one of the things that we've asked the PCOB to do is finalize their broker-dealer inspection program, so it's no longer an interim program, it's a finalized program. And then obviously things of change in terms of how they run their operations. Most of their people work remotely. I would say there's a little bit of a challenge in terms of using technology to improve how they operate. I mean, I know all our offices at the SEC are really focused on how we can use technology to improve efficiency and effectiveness of what we do. We'd like to see the PCOB do some of that as well. And then the last thing, Ryan kind of touches on a topic in your area, and that is the overlapping enforcement responsibility between the commission and the PCOB. You know, the PCOB has a very different process because of the statutory requirements. Much of the information doesn't get disclosed until the matter's been settled. And what we've seen historically is firms have a tendency to want to slow roll that to as long as they can, and that's why you see some of these enforcement cases coming out, you know, many years after they've after the bad behavior has taken place. So, you know, I think this is an area again that we'll probably want to investigate and work between the two organizations and figure out how we're going to address that.
Great. So lots of great updates, important stuff. You mentioned consultations. I want to pivot to consultations that are coming to both Commissions OCA and CFOCA. The consultation process is one that's very near and dear to me because I did spend 10 years in Commission's OCA, and it shows how important that process is to the quality of financial reporting. I'm not just a fan, I'm also a client now currently because we as the division are a big beneficiary of consulting with the Commission's Office of the Chief Accountant. We also get tremendous help from CorpFin OCA on issues, but we're an internal customer. Another big part of the portfolio in both OCA and CorpFin OCA is the questions and the consultations that arise from either the disclosure review program or write-ins with questions. So these would include pre-filing consultation requests on specific accounting interpretive issues, other pre-clearance waiver or interpretive requests related to SX rules. I think we can start with Heather. Maybe you can talk about some of the interesting questions that you've answered recently or otherwise highlight things that you just want folks to know.
Sure, absolutely. So our office does continue to stay pretty busy with the waiver and interpretive requests, along with some of the consultations we work on. Just as a reminder, our office in CorpFin really works on the form and the content of the financial statements. So we're talking about like the 305, 309 rules and the like. The accounting consultations, the pre-clearances related to the gap and what's in the financial statements is really owned by OCA. Kurt's office. Not to say that our offices aren't working together. We are constantly working together and working through a lot of the issues that get presented before the agency. But again, it's always important to make sure when you're sending something in, to be thinking about which office that information goes to. Never fear if it gets to the wrong place. It will eventually get to the right place. So maybe slow it down a little bit. But we've got our eye out for that. But where we definitely see an increase in volume, and I think OCA would probably agree too, but one of the specific places where we're seeing a lot of additional activity, particularly because I think the market activity and transactions is up, is on the waiver requests that we get, or the interpretive requests or questions that we're getting related to 1101D of Reg SX in terms of determining whether or not an acquisition that you have is a business. And so that's actually the topic that I want to spend a little bit of time on today. We often refer to that guidance that's in 1101D as the definition of a business, but what I wanted to do is maybe a little bit in the spirit of what the chair talked about yesterday. I want to provide some clarifications in terms of how we should be thinking about that. So I want to start with and remind everyone that the guidance that's in 1101D is not meant to be applied as an inflexible definition with a required checklist. Rather, the purpose of that rule is really to provide guidelines on the meaning of the term business to assist registrants when they're determining whether financial statements are necessary related to an acquisition, whether that's under 305 or 314. We also use that guidance as part of the assessment when registrants are evaluating the need for predecessor financial statements related to an acquisition. Recognizing, however, in predecessor fact patterns, the accounting for a transaction would first need to be considered. You might be in a situation where, for example, in a reverse acquisition, that legal acquiree would become the predecessor. But when 1101D was adopted back in 1982, the Commission really stressed that registrants were going to need to still exercise judgment in this space when they're making that determination. And they included two guiding principles in that adopting release and in the rule itself. The first being that the acquisition, which can be something lesser than an entity or a lesser component of an entity, needs to be evaluated in its specific context of the facts and circumstances that are involved. The second guiding principle is that the evaluation needs to be focused on whether there's sufficient continuity of the acquired operations prior to and after the transaction, so that the disclosure of that prior financial information is relevant and material to the understanding of the future business operations. So when you think about, and I mentioned sufficient continuity, so when you think about and consider continuity, it's important to do that in each individual set of facts and circumstances, with the end result being that the disclosure of the financial information is material to understanding of the operations acquired. So, for example, it might be more appropriate to consider continuity of acquired operations in a broader context in certain scenarios, whereas in others it might be better to review it more narrowly. Or maybe said another way, there can be different degrees of continuity. We'll get into an example in a little bit. So now that we're sort of regrounded a little bit in the general meaning of 1101D, what I want to do is talk about some more specific application points that will help to provide some further clarification. So we've seen some fact patterns where an acquisition would involve operations that are expected to be continued by the registrant, but those operations have been dormant for some time. So for example, we've seen this in the life sciences space where maybe it's not uncommon for a seller or a licensor to maybe have cash issues or cash flow problems where they've needed to stop clinical development or continue in its clinical development. So we believe that the length, the nature, and the extent of that dormancy is a relevant factor in assessing the continuity of acquired operations. So in that regard, if you had a fact pattern where the acquiree's entire operations were discontinued during the period for which they would otherwise be required to provide financial statements, that fact pattern would be evaluated differently than if the acquiree's operations were only on hold for a short time prior to the acquisition. Similarly, we've observed diversity in how registrants think about the acquired operations that will only be continued by the registrant for a limited period of time after the acquisition. So again, want to remind folks to think about that continuity in the context of whether the disclosure of the prior financial information would be material to understanding the future operation of the acquiree. And that could vary, right, depending on the length, the nature, and the extent of the continuation of the post-acquisition activities. So more specifically, we've seen some questions about acquiring an entity that holds a license arrangement or agreement or entering into a license arrangement that could or may represent the acquisition of a business for reporting purposes to the extent there's the existence of operating rights or production techniques and the continuity of those related operations. So this is not to say that all license agreements are the acquisition of a business for reporting purposes. Many are not, do not meet that standard. But in these transactions, which we've seen a lot in the life science space recently, the focus is on those licenses where there's sufficient continuity of the acquired operations before and after the transaction. So that disclosure of that relevant financial information in those financial statements would be material to the understanding of future operations. And we've talked a little bit before about this, but some of the considerations that we think about when we're looking at that continuity relates to the stage of the drug development process, that, the terms of the license and how the licensee is, what the licensee is permitted to do with the IP that they're acquiring, how that compares to how the licensor was using that information, the nature of the activity that are being undertaken, and the significance of the expenses. I will also add that if the license arrangement is viewed to ultimately be a business, and then maybe you're going through your analysis and you got predecessor or 305 financial statements that might be required, we often don't require full financial statements. Now you're getting into waiver territory where you'd have to come talk to the staff, but there are certainly places where we've waived those financial statements or otherwise provided substitutions. If I can go back to 1101D and talk about one more area that sometimes folks find difficult to apply, and that's the presumption that's included in 1101D that talks about an entity or subsidiary division presumed to be a business. So we do continue to believe that there's limited circumstances where that presumption would be overcome, but it is possible. And I wanted to, again, share an example. So we know that sometimes it might be advantageous from, say, a tax perspective for an acquisition to involve on the seller side, like a legal entity that gets put in place as a holding company. And we don't expect that the existence of a legal entity when the acquisition could otherwise have been completed without that legal entity to ultimately be a determinative factor in the 1101D analysis. So this does not override the need to go through the 1101D analysis and overcome that presumption, but it should not in and of itself represent a barrier. To be clear, though, we often hear arguments when folks are evaluating whether or not something's a business that, there are changes in carrying value of assets, or the management team is different, or that we want to put some different financing into place. This position currently exists in our FRM, but we don't, typically look at those that type of analysis as being persuasive to get out of the set of operations or what you're acquiring to be in a business, because we're looking at that in totality in terms of understanding the investor, being able to understand those future operations. And if I can share one last thing on the process that we go through from a waiver and interpretive request process. We have previously said that when you're writing in an interpretive request, whether that's 1101D or otherwise, and you're concerned that the staff might not agree with what that initial position is, we've said, hey, maybe you can tack on a component of a waiver request on that. And what I want to be clear and stress is that we are not suggesting that registrants should be skipping that analysis and jumping straight to the waiver process. It's an administrative step that you can or cannot choose to take at that point. What I would like to do is encourage registrants to write in about their business determination analysis or whatever other analysis they're looking at. I strongly believe us having the ability to work through these analyses with you only makes us smarter and get more information about the current transactions that are out there.
Thanks, Heather. Kurt, let's shift to Commission's Office of the Chief Accountant and the consultation volume. Any perspectives to share?
Yeah, so again, we encourage companies to come in and talk to us on emerging accounting issues for a number of reasons. One, help companies get it right so they can prepare their financial statements correctly. And the second thing is so that we can get a handle on emerging issues and we can deal with that through whatever means are necessary in the circumstances. So later today, there's a separate working group on accounting. They'll go into some of these issues in a lot more depth, but I wanted to highlight a few of them. One topic, obviously digital assets. I think Ryan, you saved all the digital asset issues for me when I came. So we're trying to address that, provide clarity in terms of our views on the accounting, and identify those issues, work with the FASB in terms of developing accounting standards where necessary to address those. Issues like staking and validating services, whether stable coins and other digital assets can be cash equivalents, things of that nature. We work very closely with the crypto task force on all the issues that we deal with in the digital asset space. We'll talk a little bit about some of those issues in the working group if you're interested in attending that session. AI is something that we talk about every day in the building. Obviously, there's a lot of accounting issues relative to what's happening in the AI environment, whether it be build-to-suit leases, purchase power agreements, embedded leases, lots of really techie accounting geek stuff on whether an entity has to consolidate a multi-billion-dollar data center or the power agreements that go with it. Very complex accounting issues, but very significant to a company's financial statements and this financial statement presentation. We team closely with the Division of Corporation Finance on this just to make sure that, the accounting might be that, a mega data center somewhere in the United States doesn't get consolidated. There's no liability or asset on the balance sheet of a particular company. We work with CorpFin to make sure the disclosures are clear so that investors understand the arrangement and the transaction that companies have entered into so that they can make sense of the transaction or reach conclusions about the company's financial statement presentation. I said earlier, we work very closely with other divisions in the building, particularly trading and markets and investment management I mentioned as it relates to private credit and a lot of the issues that we're dealing with right now on private credit, primarily valuation issues. So, I work closely with Brian Daly and his team. Brian did an excellent workshop a couple weeks ago on this particular topic, and this is an area that we continue to collaborate on in the building just to make sure that we are staying on top of some of these emerging issues and how to make sure that the disclosures and accounting display are what investors need, reasonable investor needs. The last thing is I like to learn. Every day I wake up and say, I'm going to try to learn something today, and I always invite people to try to come in and talk to us about what or some of the significant issues they're seeing. We've had a lot of people take me up on that and come in and talk about some recent accounting standards that were adopted, particularly the income tax disclosures and the disaggregated income statement information, otherwise known as DICE. On the income tax disclosure issues, one of the things I try to convey to people is, while the standard has a monetary threshold, 5% of your income tax disclosure requires some type of financial statement disclosures, you only have to do that if it's material, right? So a lot of people are coming in and saying, wow, I have all this disclosure that looks like it's required by the standard, but it's really, I think, immaterial. Why do I have to disclose this? And we point people to the standard itself, which has an overriding premise of materiality, as well as the federal securities laws have some level of materiality that you only need to disclose information that's material. So one of the challenges, of course, is companies like, well, I reached the conclusion it wasn't material. My auditor says it's 5% of the income tax number, so I have to disclose it because the standard says so. Or the lawyers come in and say, wow, you know, and to keep from getting second guessed by the SEC or the PCOB sometimes, let's just disclose it. So those are the kind of things that add to unnecessary disclosures. If a company believes something's not material, make your argument and go with that. So, you know, again, this commission I know is focused on material disclosures, and this is just a point of emphasis on how just a raw application of a standard might not necessarily generate information that's material to a reasonable investor. So be focused on that.
Great. A lot of interesting issues, and I know people are working really hard to make sure we understand and get the best financial reporting. Let's go a little bit wider and start thinking about some of the current market considerations that are going on that maybe registrants or advisors want to be thinking about as they get ready for their next filing. I do see a lot of headlines about tariffs, but just the headlines, though, I don't actually read the articles. So I guess my first question for you all is, what is a tariff? And are there any accounting or financial reporting considerations that need to be considered? And also feel free to get maybe broader if there's other macroeconomic things you're thinking of. Maybe we'll start with Kurt.
So tariffs. So I have 4 sons. My 4 sons have a lot of different interests. And, you know, every year I say, okay, go put a Christmas list together and let's think about something interesting you want. My kids are very creative. And I realize how creative they are when UPS comes to the door and they says, we have a package for you, but we can't give it to you unless you pay the tariff on it, plus the admin fee associated with it, right? So I learned about tariffs really over the holiday season. No, but joking aside, tariffs, this is a big issue for companies because no one knows the answer on if they're going to get their money back, how it's going to come, what form it's going to come, who do they owe if they get the refund. So there's a lot of accountants scurrying around to try to come up with some models to figure out when you recognize tariffs, and that's broadly speaking, on the financial statements, because you might have paid the tariffs and you might be entitled to, or you think you might be entitled to a refund. You might have collected the tariffs on behalf of somebody else, and that somebody else might ask for a refund. You might have actually collected tariffs from somebody, and the person hasn't asked for a refund, and you're going to have to ask yourself, does that really come under the S-cheat laws? Or do I have to give that to the state, or can I keep it? Right, so there's all kinds of issues surrounding tariffs, but not many people are recognizing their tariff refunds on the financial statements because there's really not much clarity from the government in terms of how that's all going to work. So again, this is another thing where I kind of trundle downstairs to the 4th floor, sit down with Jim Maloney and say, while the accounting is really not clear in the financial statements itself, this is a big disclosure issue. So if companies have exposure either as a liability or an asset, or they've sold inventory that included some level of tariffs, and that might require adjustments to the financial statements kind of going forward, make sure that it's disclosed in the financial statements if it's material.
Yeah, I would just add on to that, right? Regardless of the conclusion that you're going to get for the purposes of the financial statements, CorpFin always makes reminders all the time about thinking about the macroeconomic factors that you need to consider for your filings. Right now, tariffs being one of them. We've got global conflicts. We've got supply chain disruptions. There's a whole host of things that folks should be thinking about right now. But again, with tariffs just being one of them, and right, Kurt was talking a lot about the recent Supreme Court ruling in terms of what that does. Again, that's just another factor that you sort of need to tack on that might dictate additional or updated disclosure that's necessary. And we do know that, excuse me, that companies are increasing their disclosures around tariffs. I think the majority of the companies really are mentioning tariffs and tariff-related trade restrictions in their filings, whether that's an MD&A or in their risk factors. And we've seen those disclosures over time. If you look at sort of the past year, the specificity has increased. Excuse me. Maybe this is going to shift again now that we have this uncertainty that Kurt was just talking about. And so, maybe uncertainty is still the name of the game when it comes to some of these disclosures. But, either way, folks need to have the right disclosure controls and procedures in place so that they're identifying these known uncertainties and following through with what the MD&A rules require in terms of disclosure. So again, uncertainty might still be relevant. The other thing I'll just mention when we're talking about tariffs is just maybe a quick reminder. If you were to have a non-GAAP adjustment to remove the impact of tariffs themselves, that would be likely not be appropriate because you'd be in the position of excluding a normal recurring operating expense. And so those are places where we typically see companies, rather than making type of adjustment, that they're going to use some type of explanatory disclosure, or maybe they're going to quantify that information with respect to how the impact of the tariffs themselves had on the business at the end of the day. So I just wanted to throw that one in there quickly.
Great. So let's pivot to something that Commissioner Gallagher raised both this morning on the enforcement panel and I think again on the exams panel, which is AI. Usually when I think of AI, I think about an app on my phone that talks to me when I'm lonely. But I do, people woke up from lunch. I do understand all of the many ways that it affects auditing, accounting, financial reporting. So Kurt, what can you tell me about artificial intelligence and how you're all thinking about that?
Yeah. So I think back on the first time I was at the commission in the late 1980s, there was this new thing called the internet, right? I thought it was the greatest thing in the world because I didn't have to go to a library anymore. I could just use my computer. And I think that, AI presents some fascinating opportunities for businesses and everybody, right, in terms of how they use it. Most of the time, somebody comes in and talks to us, we'll ask them about AI. So I try to get preparers to come in, and we ask them how they're using AI in financial statement presentation. We get auditors to come in. We ask them a whole lot of questions on the AI side. So, we meet with groups like the FEI CCR group who's taken this issue up. And people are using this and experimenting and with this in some pretty fascinating ways, right? Some people are experimenting, well, if I have a gazillion, say warranty claims, for example, can I use AI to do it better than a person or a tool is? Can I do, my Monte Carlo simulations that used to take forever and I used to have to hire somebody to do that. I can do that now with kind of AI. I've asked people, I said, do you see a day where, AI can prepare your whole 10K? And the lawyer sitting next to him goes, no. And the person says, yes, right? So, we're not there yet, right? We're in the early stages. Companies are in varying forms of where they are in terms of using AI. A lot of them are using it for internal accounting systems like expense reports, make sure that people's expense reports are properly reported. But this is an area that's changing very fast, and we have an interest in this to make sure we understand the controls that companies are going to have in place if they're going to use AI for preparing financial statements themselves. And we're looking at, the guidance we have on disclosure controls and procedures to see, is there anything that we need to tweak here? So this is something that's very, we're proceeding to try to gather information, but proceeding cautiously because what we don't want to do is put out all these onerous requirements and stifle innovation. So we want to see what companies are doing, see how beneficial it can be to investors in that particular area. As it relates to auditors, this is a really kind of very interesting area for them from a couple perspectives. One is this is very disruptive to their whole business model because the tasks that you'd normally assign to a brand new staff person, anybody that's been an accountant in a firm knows kind of the tasks that were done, mostly can be done by AI or will be able to be done with AI. And the use of artificial intelligence can do some pretty marvelous things in terms of detecting anomalies in the financial information that a company provides because, back in the day, you used to, get things in paper copies, and you used to have to make sample selections, and you get a paper copy of the sample selections. We're now in an environment where the entire general ledger is available to the auditor, and they can use automation tools to scan through there to look for anomalies in terms of what was the controller posting something at 3 a.m. in the morning for, right? And so there's fascinating ways how AI can really improve the quality of how an audit's done. And in that particular area, we're also working closely with the PCOB to make sure that we understand how the PCOB views this in terms of, do they need to develop standards on it, or their actions through the inspection program discouraging firms from using this, right? So a lot of times people might say, I don't know that I want to use this new fancy tool the firm has created for me, because I don't want to risk having the PCOB come and inspect me and tell me that I did it wrong, and then, that kind of ruining my career for at least a period of time. So working with the audit regulators around the globe to understand how innovation is improving audit quality, and whether the standards are kind of fit for purpose in terms of whether auditors have sufficient guidance in terms of compliance with the auditing rules and standards. The other thing that this presents a really fascinating opportunity for auditors is how they monitor their system of quality management. So people that work with me know that I mention system of quality management, system of quality control multiple times a day, because I think it's a really important area for them to focus on. So how do you use AI to go into an audit file that's in process and determine whether the team did its sufficient work, they did the sufficient work at the right time? How do you monitor whether someone's coming in at the last minute and doing a lot of audit work at the end? How do you prevent somebody or identify teams that, have done a lot of work after the audit report is issued? So, using AI and a lot of these tools out there present a lot of opportunity for audit firms to enhance their system of quality management and make for better audit quality at the end of the day. So that's the kind of the things that we're looking for. So we invite companies to come in and talk to us. We want to learn more and more about this. Every time an audit firm comes in, I ask them about what their clients are doing, what they're doing from the audit perspective, and then what they're doing from their system of quality management, because we want to learn and we want to make sure that we're being responsive to those developments and how they affect a financial statement presentation.
Great, thanks, Kurt. Heather, how are you in CorpFin thinking about AI?
Sure. So, Kurt was really focused on how, companies are using AI in their financial reporting, but they're using it across their entire operations, how it influences their business. And so we're starting, clearly disclosures with respect to that have increased over the past, call it 2 to 3 years, about how companies are using AI, at the end of the day. These aren't CorpFin stats, but I've seen a lot of published statistics that basically say, the vast majority, if not all, of S&P 500 companies are talking about AI in their annual filings. As far as the risk factor goes, I think that's upwards of 70% in terms of folks that are having that. But, I don't think there's anything maybe entirely, surprising or unique, but from a disclosure perspective, just as a reminder, really be thinking about the evaluation of AI in a similar context of how it governs and discloses. You should be doing that in the same context of maybe any material business matter that you have at the end of the day, right? So you'd be thinking about disclosures of the material impacts of AI, particularly maybe at this time as those disclosures are evolving with respect to any material developments in AI, thinking about how AI can be a material risk factor, how AI might be a material part of your business model, and ultimately with the goal at the end of the day, with our disclosures of providing that meaningful transparency to investors. So in that context, maybe some reminders, and I think we've shared these before, making sure that you have a basis for claims with respect to any AI claims you're making about how AI is going to improve your results of operations or the company's financial position. Avoiding generic disclosures. We always want to make sure that you're favoring the more specific, tailored disclosure, again, with respect to your material AI risks. And then again, at the end of the day, to the extent that those risks are material, thinking about whether or not there's AI risk management or corporate governance policies that would be helpful for investors to understand.
Great. So despite my jokes, I do actually spend quite a bit of time thinking about AI and how it applies to accounting and financial reporting in our enforcement program. So I think we're focused on it, and we really are focused on it from every angle. And that first angle is, how are people, like market participants, those that the commission regulates, using the various applications. So how they're incorporating the technology into financial reporting, how auditors are using the technology to improve audit quality. These are really exciting developments. We're learning too. In that respect, I want to thank our colleagues across the division, including in OCA and CorpFin, for giving us a seat at the table. And I guess I just would use this opportunity to say, if you see enforcement there sitting there trying to learn, we're trying to learn too. Please talk to us. Let us know how you're using this, because we are supportive of it making our capital markets stronger. That said, like any tool or emerging area, there will always be those who unfortunately will abuse or leverage the excitement of an innovation and use it in the wrong way. So they might end up overpromising things to investors, or in the worst case, outright lying to them. And I just want to say, we will be there and we'll be watching and responding. And at the risk of sacrilege in pumping anything other than the accounting workshop this afternoon, there will be the enforcement workshop this afternoon. We're going to talk about a few cases or instances where those types of bad behaviors happened and we brought a case. So always thinking about ways that we can leverage that knowledge. So I guess switching or getting a little bit more of a finer point on some of the things we've been thinking about in the context of AI. Auditor independence, obviously an important area, an area that's evergreen to the Division of Enforcement. But I'm curious what you're hearing in the Office of the Chief Accountant about auditor independence as it relates to artificial intelligence.
Yep. So AI brings up some very interesting issues that require us to evaluate, how our rules are structured, whether they continue to be fit for purpose. And I guess one of the concerns, a few concerns that I have in this area, Ryan, are, there's, most of the larger firms are multidisciplinary firms. They do audit, they do consulting services, they do tax services, and there's very small players at the top of the AR market. There's only a certain limited amount of cloud providers. There's the big companies that are the large language model companies. And I think companies today expect that AI is going to be embedded in something that they get, right? So if someone's implementing an ERP system, they want some level of AI in there. That's the expectation. And where you have contracts where you're providing say an ERP implementation, and they're using an audit client software, and there's specific terms and conditions associated with the use of that product, that presents challenges from an independence perspective that auditors need to deal with and be focused on. Other things are, there's a lot of acquisitions going on in this space, right? Some company buys this, they get, they agree to buy products, they get equity in return. So auditors need to be focused on making sure that their audit client doesn't acquire, substantial influence through acquisitions or through any kind of incentive participation in one of these transactions to violate the independence rules, because it's also a Channel 2 client or a consulting client. So those are some challenges. And then you have issues like some of these providers might not be able to find an auditor, right? Because they want to use it for another part of their business, and no one wants to audit that company. And, one of the concerns that we have is there going to be sufficient auditors that are going to want to use the technology, but also want to have it as an audit client? And then you have more complex issues like where, audit firms are developing agentic AI tools that they provide to their clients that actually make decisions, right? So how do you deal with that if you delivered that service and you get rid of them as a consulting client, now you want to take them as an audit client, and they're still using that tool internally? We have prescriptive rules in terms of acting as management, whether those kind of cross the lines there. So there's a lot of things that we need to be focused on, because our independence rules are very, very important. We take them very seriously, but we want to see how innovation is changing how people interpret some of our rules that have been around for quite some time, but are very, very important. So again, this is changing kind of like on a daily basis almost, so we just need to be mindful that we stay on top of the developments and then make sure that firms are complying with our independence rules. So big challenges ahead there.
Great, really interesting stuff. So stay tuned. I think we should pivot to rulemaking and specifically talk about rulemaking about the pace of reporting for public companies. This is something that the chairman has spoken about often. We heard a little bit about it from CorpFin, but I think the people demand more. So Heather, can you expand a little bit on that particular project?
Well, again, we're always limited, as you know, Ryan, in what we can say there. But you did hear a little bit yesterday, and it's certainly something that we're hearing a lot on the accounting side as we engage with our stakeholders and folks are coming in and talking to us. This is something that is always on the agenda that folks want to engage, that they want to engage on and have a discussion on. And in those discussions, I would say we're hearing a lot about the concept of optionality of periodic reporting cadence, if that were something that the rulemaking would offer, and then considerations about comparability, and then maybe how that translates into some practical impacts for issuers. On the former, we've heard both our chair and the director of CorpFin, express their views that companies should be able to decide what works for them and what works for their investors in terms of a cadence. And so, quarterly reporting might make sense for some companies, while others might, have a need or a want to report semi-annually. Maybe that's driven by the size of a company. Maybe that's driven by where they are in their life cycle. Maybe that's driven by, what's going on in their particular industry and what their competitors are doing. Could certainly see different practices, developing if we had a rule that provided for optionality. On the comparability question, it's a great question. It's a good question, and we've had a lot of dialogue about it, and it's certainly one that we'd be seeking public comment on as a proposal if were to go out. But again, I think, I can see practices developing as companies are looking to, see what their competitors are doing and, identifying a frequency that's going to work so that, investors are able to make those comparisons of financial information between them and their competitors at the end of the day. And then we could maybe see practices, develop not just around, SEC filings, but maybe how companies are, considering or leveraging the earnings release process that folks are familiar with today. So again, I know folks are anxious to digest this when we get to the point of a release.
Great. So we're kind of coming up on time, and I know this is something that, Kurt, you feel very passionate about, is international issues, how we are contributing into global financial reporting and international auditing. So you want to hum a few bars about that?
Yeah, so this is a fairly large and ambitious project that we're working on in the Office of the Chief Accountant for a lot of good reasons. One, if you think about the SEC issued a concept release last year where they raised questions about, reorganizing some of the foreign private issuer disclosure requirements. If you think about the U.S. capital markets, I think we have somewhere between $10 and $14 trillion worth of market cap of companies that use international financial reporting standards in lieu of U.S. GAAP, right? So they use that unreconciled to U.S. GAAP, and that was permitted. Chairman Atkins voted for that when he was a commissioner in the aughts, as he says. And that the question is, are we still comfortable with that, right? So the chairman gave a speech at the OECD in September of last year where he raised concerns about whether there's an adequate governance structure for the IASB, the International Accounting Standards Board, and whether there's stability in fundings, which were two of the criteria that were important to him when he voted in the affirmative when the commission adopted allowing the use of IFRS in the U.S. So that's a particular issue because the IFRS Foundation, as you know, added the Sustainability Standards Board a couple years back. And if you look at the funding for those two organizations, the Sustainability Standards Board gets most of the money, right? Which is a concern about, is that really the highest priority? The sustainability standards are not used in all the capital markets. IFRS are used in almost every single capital markets. When he made that speech, or when I helped him prepare for his remarks, I said that we had a bigger problem that we need to deal with, and that is the international standards of auditing are used in every single jurisdiction, including the United States, because all the large international firms use the ICE's, International Standards of Auditing, as the baseline for their global audit methodology. And why do they do this? If you think about a large conglomerate, pick a company, Coca-Cola operates in 199 countries, right? So they have to file a 10K in the United States that has to comply with U.S. auditing standards that are dictated by the PCAOB, but they're also filing statutory reports in all those 199 countries, sometimes multiple, where they're using the International Standards of Auditing. So all the firms develop their audit methodology because it's simpler. Everybody just uses the same methodology, and what they do is they add a layer for the PCAOB on top of it for the U.S. Okay, so all the firms are using International Standards of Auditing. The AICPA, which sets auditing standards for private companies, they use the International Standards of Auditing as the baseline for developing their own standards as well. So that the governance and the funding for the IAASB, which is the International Accounting Audit and Assurance Standards Board, is in dire need, right? So their governing body, the Public Interest Oversight Board, is having significant financial challenges. Most of the funding for the IAASB comes from the accounting profession itself, which raises questions and concerns by stakeholders in terms of independence and objectivity. So evaluating how we solve both of these problems is a significant initiative that we want to try to tackle, working with global securities regulators and audit regulators from around the globe. A significant undertaking, but one that I think is well worth it, because if we don't have clarity, good international accounting standards, and they're used in our capital markets, that's going to undermine investors' confidence in the financial statements that are presented, undermine confidence in auditors' abilities to attest to or provide assurance on financial statements, which are the key underpinnings of our global capital markets. So a significant area of focus. If you're interested in learning more about this, come to the workshop later today. We'll talk about it in a little bit more detail.
So we're coming up on time, and I very much want to make Grace happy. So I will ask my co-panelists to just put on a brief final thought. Start with Heather.
Sure. So I guess I would just say, you know, we as the accountants, I probably speak for, you know, Kurt and Ryan too, right? The role that we play in terms of protecting investors and facilitating capital formation is a very serious role, and we take that very seriously. And in CorpFin, we definitely recognize that to do that, we need to make sure that, you know, registrants and investors alike, you know, can understand and navigate our rules and guidance. And so I guess I would leave you with, you know, keep talking to us. I think you've heard that message from all of us today. It really helps us know where we need to focus our time, you know, what guidance and rules we need to provide clarification on. And so as far as the financial reporting space goes, we are here to help.
Kurt?
Yeah, I would kind of echo that. I would say we're listening, right? So we want to hear what you have to say. We encourage companies to come in, tell us what the challenges are and what they're dealing with. We want to see whether you know, our rules are continue to be fit for purpose, whether they need to be changed or revised in any particular way. We want to make sure we get ahead of the issues that are developing, and we're not looking at things in hindsight. So we want to learn. We want to hear from preparers. We want to hear from auditors. We want to hear from attorneys. What are the challenges that you're facing in accessing the capital markets? Because we want to make our capital markets the greatest in the world. We think they are, and we want to make sure that they continue to be so. So help us do that by sharing the information that you think's where we're not performing appropriately.
Thanks. And I guess just from my perspective, I'll once again say, like, despite my jokes, I do too take my job incredibly seriously, and I'm very grateful for all the people that work so hard in the profession and elsewhere to keep our capital markets so strong. I do believe enforcement's an important part of that process, and we will be vigilant to make sure that those who would, you know, besmirch the importance of our capital markets are held accountable. But again, tremendous gratitude, and appreciate the panelists today. So thank you.
So we're on a break until 2:20 when we'll resume with the last two panels before the workshops.
Okay, welcome back. This is actually my last time welcoming you back, but it's with great pleasure that I introduce this panel because it is the panel that I know the least about and the most about. So I always find it incredibly informative. And so we will now hear from the Office of General Counsel about judicial and legislative developments. The panel will be led by Russell Rusty McGranahan, who became the SEC's General Counsel in January, just a couple of months ago. As the SEC's Chief Legal Officer, he oversees the legal advice to the Office of the Chairman, the Commissioners, and the agency staff. Prior to joining the SEC, he was the General Counsel of the GSA, setting the course for a number of key initiatives during the first almost a year of this new administration. Before that, he was General Counsel of Focus Financial Partners, a wealth management firm, where he led the legal function, took the firm through an IPO, and then later, within several years, went private. So I'm sure that was quite an interesting time. Before Focus Financial, Mr. Granahan spent 9 years with BlackRock as Managing Director, M&A Counsel, and Corporate Secretary. So before I turn it over to Rusty, I just want to steal a couple of moments and sort of give a closing comment, which is, in all my years of attending SEC Speaks, this year I attended each and every panel for the entirety, and I have to thank and compliment the staff. It is quite an amazing organization. It will always be my agency, my SEC, even though I left a very long time ago. I still feel that way. And this was fun and informative. I learned a lot. And I hope you all appreciate the rate and pace of change in the capital markets. It is daunting. There's new leadership who's on that sprint. There's a lot of rulemaking coming up and in the works. And I think they are openly asking for your comments. So to the extent you have time to participate in that, I think it would be greatly beneficial. And it's basically an overview of what it takes to fulfill our three-part mission of capital formation, fair and orderly markets, and investor protection. And it is quite a task. So thank you to this panel. Thank you to the SEC staff. Thank you to everyone who's attended the conference. And it has been a pleasure to be your co-host, co-chair. Thank you.
Thank you, Commissioner Unger, and good afternoon, everyone. I'm incredibly excited to be here at SEC Speaks and present to you the first time as General Counsel. After 30 years as a public company general counsel, in-house counsel, and in private practice, I'm fascinated to be on the SEC side of SEC Speaks. But of course, I don't speak for the commissioner of the SEC, or neither do my panelists. We're all speaking just for ourselves, and that's the first time I've gotten to say that, so that's very exciting as well. I feel very lucky to have this job. I think it's probably one of the most fascinating jobs, certainly in industry, if not in all of legal practice. So in that vein, I want to take the opportunity before I turn it over to this panel to really tout what we do, because despite my 30 years as a securities lawyer, I don't think really I understood or appreciated where the Office of General Counsel fit within the SEC and all the important work it does. We work through 4 principal groups. The first I'll discuss, an administrative law and legal review group led by Brian Morris. As the name described, it reviews all our legal rulemaking principally. And as I'm sure you've heard from all the other panelists and commissioners, we have a very active rulemaking agenda right now, and they're extremely busy. Our public reg flex agenda lists at least 45 items. Some of these are rolled out already, and this group provides a very important function, as Commissioner Peirce said in her speech, in making sure everything we do is under our authority and will hold up to the court review and the others which will naturally come. The second group I'll discuss is our general law group, headed up by Elizabeth McFadden. I always thought this group needed a much jazzier name than General Law Group. That name doesn't give justice the important things it does. They deal with employment law, labor law, federal appropriations, internally discipline matters, which we'll hear about in a moment in the next panel. They review congressional responses. They work on MOUs, including the one with CFTC, which was titled earlier. Really everything that's key to running an agency, a lot like you'd actually see in a corporate GC type office. The next group I'll mention is the adjudications group, ran by Stephen Robinson. They assist in preparing orders and opinions in litigated administrative proceedings, SRO appeals, 12JD registration issue, follow-on proceedings. They deal with over 150 matters a year. Very, very important group, very, very active as well. And now we turn to the subject of this panel, the Enforcement and Appellate Litigation Group, headed up by Jeff Fennell to my left. We'll talk about appellate in a moment, but they do play an important role on enforcement matters. They vet all the matters, and they speak and act directly for the commission and provide a different viewpoint than the enforcement group who are, actively pushing those matters, and an important role, as you've heard from the commissioners, to make sure we stay within the guardrails, again, of our authority. The appellate group, I think most of you know, deal with appeals from district enforcement actions, challenges to adjudication orders, are involved in drafting our amicus brief, and work with the Solicitor General on Supreme Court matters. People often ask me, what's one of the biggest surprises that I've had since taking on this job? And I think one is just the level of work that the appellate group handles. We have over 100 open matters currently at various stages, from briefing to awaiting argument to awaiting decision. We have multiple filings on many a week at Court of Appeals across the country. I think really in terms of just volume, we must be in the top 10 agencies in terms of the practice of an appellate group after DOJ and a couple of others. We're right up there, and if you're in securities law field and into appellate work, I mean, there couldn't be a better place, I don't think, to see this. And they're also actively involved in our rulemaking efforts, as I saw, to help, and this commission's particularly interested in making sure our rulemakings stand up in court. So before I turn it over to the panel, and they're going to go through a curated list of, just some of the samples of the interesting things we do, I just want to say I look forward to working with many of you. I look forward to meeting many of you in my new job as general counsel, and feel free to come up and introduce yourself. I look forward to that. So with that, I will introduce Jeff Fennell. Many of you know our deputy general counsel. Heading down the line, we have Dan Staroselsky and Emily Pierce, both assistant general counsels. People are in different orders, but I think we've got Rachel McKenzie, Dan Metro, and David Lasitzi, senior appellate counsel, and then Zeke Hill and Steve Sillerman, appellate counsels. Very talented group, doing great things for the agency investors, and hope you appreciate their talk. Take it away, Jeff.
Sure. Okay, thanks. I was making sure the light came on. One person that couldn't be here today, Tracy Harden, our solicitor, wishes she could be, but appreciate her leadership of the team as well. And what we're going to start with today is by providing an overview of Striprich versus the SEC, a case currently before the Supreme Court. Striprich raises an important question about district court's authority to award disgorgement of ill-gotten gains in commission enforcement actions. And with David Lasitza's help, we'll break down the question presented, how the case got here, petitioner's arguments, and the government's response. So let's get started, David. With that, what exactly is the question presented to the Supreme Court in Striprich?
Sure, Jeff. The question presented in Striprich is whether the SEC must show that investors suffered pecuniary harm before a court may award disgorgement. Just as a bit of background, disgorgement is a remedy that courts have been ordering in commission actions since the 1970s. It requires a defendant to give up the ill-gotten gains that were obtained in violation of the securities laws. In 2016, the Supreme Court decided a case called Kokesh versus SEC. That case held that district courts had been ordering disgorgement in a way that made it a penalty for statute of limitations purposes. naturally questions then arose whether district courts had the authority to order disgorgement at all, and the source of that authority. In 2020, in a case called Liu versus SEC, the Supreme Court considered that very question and whether disgorgement was authorized under Section 21D5 of the Exchange Act, a provision which grants authority for courts to award equitable relief in commission actions. The court in Liu said that disgorgement that does not exceed a wrongdoer's net profits and is awarded for victims is permissible under that provision.
Thank you, David. Now, after Liu, Congress enacted a statute that's relevant here, right?
Yeah, exactly right. After Liu was decided in 2020, Congress in 2021 enacted amendments to the Exchange Act, and they added Section 21D7, which expressly authorizes the Commission to seek and a court to award disgorgement. Congress also added another provision to that section, Section 21D3, stating that a court can require disgorgement of any unjust enrichment by the person who receives such unjust enrichment as a result of the violation. So the question now before the Supreme Court in Sripich is whether a showing that investors suffered pecuniary harm is a prerequisite to an award of disgorgement in a civil action brought by the SEC.
So how did this issue make its way to the Supreme Court, and why did the court decide to take the case?
Circuit courts issued conflicting decisions on the issue of whether pecuniary harm must be demonstrated. So recall that under Liu, the Supreme Court said that disgorgement under Section 21D5 is permissible relief when it does not exceed a wrongdoer's net profits and is awarded for victims. Well, the Second Circuit picked up then on that language in a case called SEC versus Govel and said, well, that awarded for victims language means that courts cannot award disgorgement without first finding that victims suffered pecuniary harm. Then in Sripich, the Ninth Circuit declined to follow Govel and held there is no pecuniary harm requirement and that such a requirement does not appear either in Liu or in Section 21 of the Exchange Act, including those provisions that were added in 2021. So now we have a square conflict over whether a finding of pecuniary harm is a prerequisite to a disgorgement award. The Second Circuit in Govel says you must show pecuniary harm, versus the Ninth Circuit in Sripich saying you do not have to show pecuniary harm. Sripich filed a cert petition, and the Supreme Court has decided to resolve that conflict.
Thanks. Can you give us some background on Sripich, what led to this case, and how did it reach the Supreme Court?
So the facts of the case, the case involves a penny stock fraud. The SEC alleged that Sripich and his associates engaged in fraud involving at least 20 penny stock companies. They secretly accumulated shares, published promotions to lift or pump the price of the issuer's stock, and then they sold or dumped their shares on the investing public at inflated prices. This generated over $6 million in illicit proceeds. Sripich was criminally charged, including for fraud, and ultimately pleaded guilty to selling unregistered securities. In the SEC's suit, Sripich entered into a bifurcated settlement. He agreed to be permanently enjoined from further violations of the securities laws that he had violated and from participating in any penny stock offering. Particularly relevant for us today, Sripich also agreed that the district court could order disgorgement, that the complaint's allegations would be treated as true for purposes of awarding disgorgement, and that the court would determine the amount of disgorgement after further briefing. The district court then ultimately ordered Sripich to disgorge $2.25 million in net profits that he received from his violations. The district court did not address whether a showing of pecuniary harm was legally required. Instead, it found that the SEC demonstrated that investors have been harmed by Sripich's fraudulent schemes. The district court also noted that the SEC had represented that it would make good faith efforts to ensure that any disgorgement award will go to the harmed investors, and that the SEC had already conducted a preliminary assessment for a distribution to defrauded investors. Sripich appealed, arguing only that disgorgement was improper because the SEC had not shown that any investors suffered pecuniary loss.
How did the Ninth Circuit resolve the pecuniary harm issue?
Well, the Ninth Circuit held that disgorgement does not require a showing of pecuniary harm under either Section 21D5 or D7. Accordingly, the Court of Appeals affirmed the district court's judgment without deciding whether the SEC had shown that Sripich's victims had suffered pecuniary harm. The court provided a few reasons for its conclusion. First, the Ninth Circuit held that a pecuniary harm requirement is contrary to historical precedents. The court read these precedents as confirming that a claimant seeking disgorgement need not show any loss whatsoever, let alone a pecuniary loss. Second, the Ninth Circuit reasoned that the Second Circuit in Govil had overlooked a fundamental distinction between compensatory damages, which compensate the victim for losses, and disgorgement, which deprives the wrongdoer of ill-gotten gains. Third, the Ninth Circuit rejected the Second Circuit's reliance on limits that apply to private securities lawsuits. The Ninth Circuit explained that Congress added those limits to curb abusive private litigation, but Congress did not add such limits to restrict the SEC's enforcement authority. And finally, the Ninth Circuit said there was no reason to suppose that disgorgement authorized by the new Section 21D7 is narrower than the one available under Section 21D5. The court therefore reasoned that its holding that subsection D5 does not require pecuniary harm also means that disgorgement under D7 does not require pecuniary harm.
What arguments, I mean, obviously the petitioner disagrees, or we wouldn't be talking about this at this panel. What arguments have they made to the Supreme Court about why the Ninth Circuit got it wrong?
So the petitioner makes several arguments. He argues that lieu requires that disgorgement be awarded for victims, and a victim must be someone who suffered pecuniary harm. He also argues that disgorgement that is ordered where victims lost nothing constitutes an unauthorized penalty. He further argues that Congress's 2021 amendments did not change the meaning of disgorgement, and that a victim cannot be restored if they did not lose money in the first place. And finally, petitioner argues that the Ninth Circuit's reliance on historical precedents is misplaced.
And what position has the government taken on this pecuniary harm issue?
So the Solicitor General represents the Commission in the Supreme Court, and as Rusty mentioned earlier, our appellate group works with the SG's office on such cases. The SG's office has not yet filed the government's merits brief in Srippich, but the SG did file a response to Srippich's cert petition, in which the SG said that the Ninth Circuit's judgment was correct, but that the Supreme Court should take the case to address that circuit split. Now, a cert stage filing typically does not fully explain a party's merits position, but at a high level, the SG argued that disgorgement is a profit-focused remedy that rests on the principle that a wrongdoer should not make a profit out of his own wrong. While damages compensate the victim for a loss, disgorgement deprives a wrongdoer of ill-gotten profits. The availability of disgorgement therefore turns on whether the violator has made a profit, not on whether the victim has suffered a loss. And a court may order the disgorgement of wrongful profits even the transaction produces no ascertainable injury to the claimant. There's obviously a lot more to the argument, and the SG's merits brief will be filed in just a few days on next Wednesday, March 25th.
Thank you, David, for that overview. Do you know when it's likely the court will resolve this question?
Srippich is set to be argued in the Supreme Court on April 20th, and we anticipate a decision before the end of the term by late June or early July. The case number, if you want to write it down, is 25-466.
Great, thank you. Now we're going to turn to Zeke Hill, who will be discussing FS Credit versus Saba Capital, another case pending in the Supreme Court. Zeke?
Thanks, Jeff. On December 10th of last year, the Supreme Court heard argument in FS Credit, and the question presented is whether Section 47B of the Investment Company Act of 1940 creates a private right of action.
So what's the background of the parties' dispute?
So FS Credit and the other petitioners in the case are investment funds that are organized under Maryland law. Saba Capital is a self-described activist investor, and it acquired substantial stakes in those funds. The funds then adopted resolutions that opted into a provision of Maryland law that limits the voting rights of shareholders who hold at least 10% of the voting power. In response, Saba sued the funds in the Southern District of New York, and in that lawsuit, Saba argued that the limit on its voting rights violated Section 18I of the Investment Company Act. That provision provides that shares of investment funds like FS Credit will have equal voting rights. And Saba argued that because the voting rights limitation violated the ICA, then Section 47B of the ICA provided Saba with a private right of action to seek rescission of those resolutions that opted into Maryland law.
What did the lower courts decide?
So the district court granted summary judgment for Saba. The court held that pursuant to a 2019 Second Circuit decision called Oxford University Bank v. La Supa Feeder, Section 47B of the ICA created a private right of action that allows a party to a contract that violates the ICA to seek rescission. And then on the merits, the district court agreed with Saba that the resolutions at issue violated Section 18I of the ICA. FS Credit then appealed, and the Second Circuit affirmed.
And FS Credit petitioned for cert, asking the court to decide whether Section 47B creates a private right of action. What does Section 47B say?
So Section 47B has two principal parts, subsection 1 and subsection 2. Subsection 1 provides that a contract that violates the ICA is unenforceable by either party, subject to an exception that permits enforcement when equitable and consistent with the ICA's purposes. And then subsection 2 provides that to the extent a contract that violates the ICA has been performed, a court cannot deny rescission at the instance of any party, and that's also subject to an exception that permits rescission to be denied when that would be equitable and consistent with the ICA's purposes.
The Solicitor General and the Commission participated as amicus in this case. What did the government's brief say?
So at the cert stage, the Supreme Court called for the views of the government, which urged the court to grant cert. The government's cert stage brief argued that the Second Circuit was wrong in holding that Section 47B created a private right of action, that the Second Circuit's approach conflicted with that of the Third Circuit and the Ninth Circuit, and that the question presented had significant practical implications and therefore warranted review by the Supreme Court. The Supreme Court then granted cert, and the government again participated at the merits stage. On the merits, the government argued that Section 47B's text and structure did not satisfy the demanding test that the court has employed now for more than 2 decades to determine if a private right of action exists. Section 47B lacks the rights-creating language that's necessary to infer a private right of action. Rather, Section 47B is a mandate that is directed to courts that establishes substantive rules of decision and presupposes that an existing state law backdrop of contract rights and remedies exists. And aside from the text of 47B itself, the ICA's structure confirms that Section 47B does not include a private right of action. Congress expressly created private rights of action in other ICA provisions, and it did so using language that doesn't appear in Section 47B. And then as a general matter, Congress tasked the Commission, not private parties, with enforcement of the ICA.
Can you tell us what happened at argument?
So the argument suggested that many justices were considering how 2 facts should impact the interpretation of Section 47B. First, the court's 1979 decision in Transamerica Mortgage Advisors, or TAMA, v. Lewis, found a private right of action in Section 215 of the ICA's sister statute, the Investment Advisors Act. At argument, some justices suggested that it might be anomalous to interpret those ICA and IAA provisions differently, even though key language in the 2 provisions has diverged, as we'll discuss in a moment, and even though the court's view of private rights of action has evolved since TAMA was decided in 1979. The second fact is the year after TAMA, Congress amended Section 47 of the ICA to its current form, and in doing so, Congress altered the statutory language that was critical to TAMA finding a private right of action in the parallel IAA provision. Justice Gorsuch, for example, asked whether that amendment had perhaps altered Section 47 such that it should not be interpreted the same as the IAA provision was interpreted in TAMA. On the other hand, Justices Jackson and Sotomayor focused their questions on the legislative history of that amendment to Section 47, which they suggested might indicate an intent to preserve an implied private right of action. Finally, a few justices asked about the implications of not recognizing a private right of action. They discussed whether a holding that there was no private right of action could alter how claims for rescission of contracts violating the ICA are litigated in state court. So all in all, an interesting argument that raised a number of critical issues, and we'll expect a decision by the end of the term.
Thank you, Zeke. Next, we'd like to discuss a challenge involving a proposal by Investors Exchange LLC, or more commonly known as IEX, to launch a new options exchange. Emily, can you give us some background?
Of course. This case concerns an effort by IEX to deploy the same tools it uses on its equities exchange to the options market. Since starting as an exchange in 2016, IEX has focused on combating latency arbitrage, which is a practice in which high-frequency traders use technological and speed advantages to pick off quotes at stale prices before slower trades can update or cancel them. To do so, IEX uses a speed bump, a 38-mile-long coil of wire that delays incoming orders for about 350 microseconds, as well as an indicator that assesses when market conditions indicate prices are in the process of changing, allowing the exchange to reprice or cancel the quote before it can be taken at a stale price. IEX previously adopted a displayed order type called D-limit that used these tools on its equities exchange. Citadel Securities, a high-frequency trader, challenged the Commission's approval of D-limit at the time. The DC Circuit rejected Citadel's challenge in 2022, affirming that D-limit's use of the speed bump and indicator would offer a narrowly targeted protection against latency arbitrage that would encourage liquidity and benefit long-term investors and the market as a whole.
So what does IEX propose to do now?
So IEX has proposed launching an options trading platform called IEX Options that would use these same tools. As IEX explained, certain characteristics of the options market make it particularly vulnerable to latency arbitrage. There are millions of option series for trading compared to thousands of NMS stocks, and options are derivative securities, which means their prices closely track movements in an underlying reference security. The options market depends on market makers to provide liquidity in the many option series, and they may need to update hundreds of quotes at once when the price of the underlying security moves. So to help mitigate latency arbitrage and encourage liquidity in the options market, IEX proposed to start an options exchange that would offer an options risk parameter, or the ORP, as a risk mitigation tool available to market makers. And similar to D-limit, when IEX's indicator identifies an imminent price change, orders electing the ORP will be canceled or repriced as selected in advance by the market maker to avoid execution at an imminently stale price. IEX Options otherwise has rules similar to other options exchanges.
And what did the Commission do?
After considering the proposal and the robust record, including dozens of comments from a wide range of market participants, the Commission approved IEX's proposal in September 2025. As the Commission explained in approving the proposal, IEX Options raised no novel issues except for the ORP, and the ORP was not novel for trading on an exchange, given that IEX already operates its equities exchange with the exact same access delay and an order type that can be repriced or canceled by the exchange. The Commission found that the same reasons that led the Commission to approve D-limit supported approval of IEX Options, and in fact, those reasons were all the more compelling in the options context. Because IEX's proposal was consistent with the Exchange Act, not unfairly discriminatory, and did not impose an unnecessary or inappropriate burden on competition, the Commission approved the proposal.
And as with D-limit, Citadel challenged the Commission's approval of IEX's proposal, but this time in the 11th Circuit. Can you tell us about their challenge?
Yes. So Citadel challenges IEX's use of the ORP on both statutory and APA grounds. First, Citadel argues in its briefing that the ORP unfairly discriminates in violation of Section 6b-5 of the Exchange Act by providing a special repricing privilege only to IEX's registered market-making members. It describes the ORP as a pause and peak system that lets only market makers escape certain trades. It also argues that the ORP imposes an undue burden on competition in violation of the Act, giving IEX an unwarranted advantage over other exchanges. Second, Citadel argues that the Commission acted arbitrarily and capriciously by approving IEX's proposal on the basis of insufficient evidence. It contends that the Commission lacked quantitative data establishing latency arbitrage in the options market. It also criticizes the Commission's reliance on IEX's estimates that the ORP would affect, quotes, less than 0.001% of the trading day, or only 1 in 100,000 orders, from which the Commission concluded that the ORP, like delimit, was narrowly tailored to affect latency arbitrage as opposed to ordinary trading. And finally, Citadel disputes the Commission's decision to treat IEX options quotes as protected. So an options order protection plan developed and joined by the options exchanges operates similarly to the Commission's order protection rule for equities, and it seeks to ensure that brokers route orders to the best protected quotation that can be found at any trading center before they fill an order at a worse price at a different venue. Because ORP quotes can be canceled or repriced while incoming orders traverse that speed bump, Citadel argues that they are vanishing or not firm and so should not be protected under the options order protection plan.
And how did the Commission respond?
The Commission countered in its response brief that the ORP is not unfairly discriminatory, nor does it impose an undue burden on competition. The ORP is an optional, transparent, and predetermined tool that is available to all registered market makers. While it is available only to market makers rather than to all market participants, that reflects the unique risks that market makers face in options trading. Indeed, those risks are why market makers are already afforded various risk mitigation tools by options exchanges. The ORP is another form of risk mitigation functionality, one that, by encouraging market makers to post liquidity, stands to benefit the market as a whole. For similar reasons, IEX's proposal does not unduly burden competition in the market. Next, the Commission discussed the substantial evidence underlying its conclusions. The Commission's experience with delimit and its understanding of market structure, as well as the numerous comments from a wide range of market participants, all established that latency arbitrage can impose significant costs and deter market makers from posting liquidity. And IEX's data estimating the ORP's activation, like the data that was provided on delimit, showed that the ORP would operate so infrequently that it was not likely to impact ordinary investors who were not using latency arbitrage strategies. Finally, the Commission responded that IEX quotes qualified as protected under the terms of the options order protection plan. Citadel's criticisms of IEX's quotes as non-firm go not to whether they warrant protection under the plan, but rather to the substantive merits of the proposal and its consistency with the Act. And in any event, the Commission explained why those criticisms were unavailing, as the ORP, like delimit, was narrowly tailored to affect only latency arbitrage and so would not result in vanishing quotes or impede normal trading.
Has anyone else weighed in on this proposal?
Yes, IEX has intervened in the case to defend its proposal. Several other market participants, including an options market maker and various industry groups, have also filed amicus briefs in support of the Commission's approval order. And on the other side, several exchanges filed an amicus brief in support of Citadel's challenge.
Where does the case stand now?
The case is fully briefed, and the 11th Circuit has scheduled argument at the end of April. IEX has said publicly that it is aiming to launch its options platform in the third quarter of 2026, so the parties agreed to expedited briefing and argument in the hope of receiving a decision from the court by the summer.
Thank you very much, Emily. It'll be interesting to see what the 11th Circuit thinks about IEX's proposal and whether they take a similar approach as the DC Circuit did. Now let me turn it over to Dan to talk about the next case.
Thanks, Jeff. So next, we're going to talk about Scottsdale Capital Advisors against SEC, which is pending right now in the 10th Circuit. So the plaintiff in that case filed a complaint in the District of Utah under the Administrative Procedure Act, or APA, and they're challenging an enforcement suit that the Commission had actually brought earlier against a different party in the Southern District of New York. So Rachel, could you just provide us some background about how we got there?
Sure. The dispute traces back to an enforcement action the Commission filed in 2017 against Alpine Securities Corporation, a broker-dealer affiliated with Scottsdale Capital Advisors. The Commission alleged, and the District Court found, that Alpine repeatedly violated the Exchange Act, Rule 17A8 in particular, by failing to file suspicious activity reports, or SARs, and by failing to maintain documentation supporting SARs. The New York court issued several decisions rejecting Alpine's challenges to the SEC's authority to bring that suit and ultimately imposed penalties and injunction on the firm. The Second Circuit affirmed and the Supreme Court denied cert.
Right, but Scottsdale wasn't the defendant in that New York enforcement case, right? So when and why did Scottsdale decide to file a lawsuit of its own?
Right, Scottsdale wasn't a defendant in that suit, but after Alpine lost key rulings in New York, Alpine and Scottsdale together filed a separate lawsuit in the District of Utah, asserting that the SEC's use of Rule 17A8 to enforce SAR requirements was invalid under the APA. The firm sought a preliminary injunction asking the court to declare unlawful the SEC's enforcement of Rule 17A8 and to bar the SEC from applying that rule to enforce SAR requirements, including in the ongoing Alpine action.
So what did the commission do in response to that Utah filing?
The commission asked the New York court to enjoin Alpine and Scottsdale from litigating the Utah action until after the conclusion of any appeal from judgment in the New York action. The New York court granted that injunction, applying what's called the first filed rule. The Utah court then stayed the Utah action until after the Supreme Court denied cert in the Alpine action. And at that point, Alpine dropped out of the Utah case, leaving Scottsdale as the sole plaintiff.
Thanks, Rachel. So let me turn now to Steve to talk about what happened in the Utah case. So to sue under the APA, a plaintiff has to identify final agency action. Steve, can you tell us, what did Scottsdale claim was the final agency action here?
Well, Scottsdale resisted the idea that it had to identify a discrete final agency action, but it argued that if it was required to identify a discrete action, then it was challenging the SEC's decision to litigate the Alpine action.
So what did the district court say?
The district court rejected that argument and dismissed the lawsuit. The court first held that Scottsdale was required to identify discrete conduct and explain how it is a final agency action. The court then held that the Commission's decision to file an enforcement action was not final agency action. The court applied the Supreme Court's decision, two-part test from Bennett versus Speer, which says that to be reviewable, agency action must mark the consummation of the agency's decision-making process and have direct legal consequences. The district court held that the SEC's decision to file a complaint was not final agency action because it did not determine anyone's legal rights. The Southern District of New York, not the SEC, decided liability and penalties in the Alpine action. The district court also determined that the Commission's decision to file the Alpine action carried no consequences for Alpine beyond the need to respond to the lawsuit, and no legal consequences for Scottsdale at all.
So the court also held that Scottsdale lacked standing. Why did it reach that conclusion?
Because Scottsdale couldn't show injury caused by the SEC's decision to file an enforcement action against Alpine. Scottsdale identified 3 types of alleged harm: increased compliance costs, regulatory uncertainty, and possible contractual liability to Alpine. But the district court held that these alleged injuries stemmed either from the New York court's rulings in the Alpine case, which the Utah court could not review, or from the adoption or amendment of Rule 17A-8, which Scottsdale did not challenge in this action, and it couldn't for timeliness reasons. The court held that the alleged injuries did not stem from the SEC's decision to file an enforcement case against a different party.
All right, so back to Rachel. As I mentioned earlier, Scottsdale, this case is in the 10th Circuit. What did the SEC argue on appeal?
So the SEC argued that Scottsdale is trying to do something that the APA does not allow, use a separate lawsuit to challenge the Commission's litigation decisions in an ongoing or completed enforcement action against somebody else. The Commission made 4 primary arguments under the plain meaning of the APA. First, the filing of the Alpine action is not agency action under the APA. The APA covers rules, orders, licenses, sanctions, and similar actions, not litigation decisions. Second, even if the filing of the Alpine action were agency action, it is not final agency action, because only the court, not the SEC, decides the outcome of an enforcement case. No cognizable legal consequences flow directly from the Commission's decision to file a lawsuit. And third, even if the filing of an enforcement action were final agency action, it's unreviewable because it is a decision that is committed to agency discretion by law. And fourth, there was another adequate remedy in a court. Alpine litigated and lost the arguments regarding the Commission's authority to bring that enforcement action in the enforcement action itself. The Commission also defended the district court's ruling on standing.
All right, so what's the status of the case in the 10th Circuit?
So the 10th Circuit held argument on January 22nd, and we are awaiting a decision.
Thanks, Rachel.
Thanks. Next, we're going to turn to Dan Matro to talk about Apex Clearing Corp versus SEC, a case currently pending in the Fifth Circuit. In this case, Apex challenges a commission order denying Apex's motion to modify a settled order issued by the commission in August of 2024. Dan, can you give us some of the background on the settled order that Apex sought to modify?
Sure. So between December 2021 and September 2024, the Commission brought settled actions against dozens of broker-dealers and other regulated firms for violations resulting from their failure to preserve business-related communications sent or received on employees' personal devices, so-called off-channel communications. One of those settled actions involved Apex, a commission-registered broker-dealer. As part of its settlement, Apex admitted that it had violated record-keeping requirements that the federal securities laws impose on broker-dealers. Apex's settled order also ordered that it comply with certain remedial undertakings, including that it retain an independent compliance consultant and report any employee discipline regarding off-channel communications to the Commission for 2 years. Many of the other settled orders issued in off-channel communications cases settled during this time period contain similar undertakings with some variation.
Why did Apex seek to modify its settled order?
As you mentioned, Apex's settled order was issued in August 2024. On January 13th, 2025, the Commission issued settled orders involving 12 other firms, including 3 broker-dealers, for similar record-keeping violations. The January 2025 orders contain different agreed-upon undertakings than prior settlements. For example, they provide for an internal audit rather than an independent compliance consultant, and don't include the 2-year disciplinary reporting requirement. And unlike the prior settlements, they don't order compliance with the specified undertakings, which has different collateral consequences. So shortly after the January 2025 orders were issued, Apex and a number of other firms filed motions requesting that the Commission reopen their settlements and equalize their undertakings with those in the January 2025 orders.
What arguments for modification did Apex make to the Commission?
So the Commission's rules of practice don't directly address the circumstances in which a settled order may be modified, but the Commission does have a long-standing practice of looking to the federal rules of civil procedure to resolve questions not directly addressed by its own rules. Apex, like most of the firms seeking modification, argued that it met the standard for relief from a final judgment set forth in Federal Rule 60b-5. Specifically, Apex argued that it was no longer equitable to enforce undertakings more burdensome than those included in later settlements with similarly situated parties. Apex also asserted that the Commission had previously granted similar requests to equalize undertakings in comparable situations.
And how did the Commission rule?
The Commission denied all the motions in a consolidated order issued in April 2025. Applying the case law on Rule 60b-5, the Commission explained that a party seeking to modify a settled order on the ground that it's no longer equitable must establish that a significant change in circumstances warrants revision of the order. The Commission first observed that none of the changed circumstances that the Supreme Court has identified as warranting relief under that standard was present. Apex didn't argue that its undertakings had become substantially more onerous, unworkable, or detrimental to the public interest, or that there had been a significant change in law. The Commission then explained that the only changed circumstance Apex did identify, the Commission's settlement of comparable cases on more favorable terms, isn't the kind of changed circumstance that requires reopening a settlement. Every settlement carries the risk that comparable cases could later reach different outcomes, and it's not against the public interest to allow agencies to settle similar cases on different terms without having to reopen earlier settlements. The Commission also concluded that its precedent didn't support Apex's request. Rather, the cases Apex cited all involved requests to sunset indefinite undertakings after years of compliance without opposition from the Division of Enforcement. Apex, by contrast, sought to eliminate time-limited undertakings just a few months after agreeing to them, and despite the Division of Enforcement's opposition.
Was the Commission's decision unanimous?
One commissioner dissented. The dissenting commissioner agreed that the Commission had no obligation to grant the requested relief under the Rule 60b-5 standard or any Commission rule or precedent, but she would have exercised the Commission's discretionary authority to depart from its otherwise applicable rules and grant relief here in the interest of justice.
So what did Apex argue on appeal?
Apex made a number of arguments, but I'll focus on just a few. First, Apex argued that the Commission ignored the enforcement sweep context, the fact that Apex settled as part of a broader enforcement initiative in which numerous firms settled similar cases on similar terms. Apex asserted that in deciding to settle, it reasonably relied on the understanding that Commission enforcement sweeps involve standardized undertakings. Second, Apex argued that the Commission deviated from the prior cases in which it had agreed to modify settled orders. In Apex's view, the dispositive factor underlying the grant of relief in those cases was that similarly situated settling parties were subject to different remedies. Apex argued that the factual distinctions the Commission relied on to distinguish those precedents were arbitrary or irrelevant. Third, Apex argued that the Commission failed to comply with its obligation under the APA to treat similarly situated parties similarly because it did not provide a substantive justification for the disparate undertakings. And finally, Apex argued that the Commission applied an impermissibly vague and indecisive standard in declining to modify the settled order. In particular, Apex took issue with the Commission's statement that parties generally must demonstrate compelling circumstances to modify a settled order.
And how did the SEC respond to those arguments?
So the Commission's brief argued that there's no right to reopen a settlement under the Rule 60b-5 standard just because another party later got a better deal in a similar case. Such a rule would seriously encroach on the Commission's enforcement discretion and would mean that no settlement is ever final. It makes no difference to the Rule 60b-5 analysis that Apex settled as part of an enforcement sweep. Apex's settled order contains no assurance, and Apex did not negotiate for a provision that all settlements going forward would have the same undertakings, nor is there any other evidence that the Commission agreed to such a constraint on its future enforcement discretion. We also argued that the Commission's grounds for distinguishing the precedents Apex relied on were entirely rational. The prior cases didn't grant relief based solely on the fact that similarly situated parties had received different undertakings. Rather, in deciding whether to lift or modify an undertaking, the Commission also may reasonably consider how long the respondent has complied with the undertaking, whether the undertaking expires on its own terms, and whether the Commission staff that recommended the undertakings in the first place agreed that they should be modified. Moreover, we contended the Commission satisfied the its APA obligation to treat similarly situated parties similarly by explaining why Apex is not similarly situated to the parties that have had settled orders modified in the past. The Commission didn't also have to provide a substantive justification for the differences between the settlements. If the filing of a motion to modify a settlement triggered such an obligation, it would render the well-established limits on judicial review of settlements meaningless. Finally, we disputed Apex's assertion that the Commission failed to adequately define the standard it had applied just because it didn't spell out what non-compelling circumstances might theoretically warrant modification of a settled order. We pointed out that after stating the general rule that parties seeking to modify a settled order must demonstrate compelling circumstances, the Commission went on to apply the Rule 60b-5 standard that Apex specifically invoked and that federal courts themselves routinely apply.
And where's the case stand now?
So the case is fully briefed, and we had oral argument before the Fifth Circuit just a few weeks ago. At argument, the panel probed the limits of both parties' positions, pressing Apex on the implications for the finality of settlements of their position, while also asking the Commission questions about the scope of its enforcement discretion. We anticipate a ruling from the court in the coming months.
Thanks, Dan. We'll stay tuned to see what the court has to say on these issues. And I think you continue on the next case with me. We're going to discuss the D.C. Circuit's October 2025 decision in CBO Global Markets v. SEC. The decision rejects a challenge to a Commission rule, regulation, NMS, minimum pricing increments, access fees, and transparency of better priced options. That concerns trading on the national market system. Can you start us off with some background?
Yes. So as you mentioned, the rulemaking at issue in this case concerns the national market system for trading in securities that Congress in 1975 directed the SEC to establish and oversee. The Commission updated the rules governing the national market system, or NMS, in 2005 when it adopted Regulation NMS, which comprised a suite of initiatives designed to modernize and strengthen the NMS. 3 of those rules in particular are relevant here. First, Reg NMS established a minimum pricing increment, or tick size, for quotes and orders in NMS stocks. At the time, it was set to 1 cent. Second, Reg NMS adopted the order protection rule. That rule is designed to stop broker-dealers from executing trades at prices worse than the best protected quotation that can be found at any trading center. In other words, every order displaying the best price at whichever trading center has to be taken before a broker can fill an order at a worse price. And third, Reg NMS instituted a cap on the fees trading centers can charge to access their protected quotations. This rule followed from the order protection rule, preventing a trading center from charging exorbitant fees to those who have to access a quote it displays. At the time, it set the cap at 1/3 of a cent per share, or 30 mils. So nearly 20 years after Reg NMS, in the rulemaking that precipitated the challenge in the DC Circuit, the Commission decided to amend several of these rules in light of market developments.
And what did the Commission decide to do?
So first, in response to widespread calls from market participants, the Commission decided to reduce the tick size from 1 cent to ½ a cent for certain stocks with a narrow bid-ask spread. Second, as a result of the reduction in tick size, the Commission reduced the cap on access fees from 30 mils to 10 mils. As the Commission explained, if the tick size were lowered, but the fee cap were not, fees could exceed more than 1/2 of the tick, which could cause market distortions and undermine price coherence. The Commission accordingly decided to reduce the cap to 10 mils, concluding that that level would reduce distortions and lower transaction costs while permitting exchanges to retain their current business models. The Commission also adopted amendments related to the transparency of exchange fees and to the Commission's prior market data infrastructure rule.
So who challenged the rules and what did they argue?
A number of exchanges from the NASDAQ and CBO exchange groups challenged the reduction in the access fee cap in the DC Circuit. In doing so, they made 3 key arguments. First, they argued that the Commission lacked authority to amend the access fee cap under the statutory provisions relied upon by the Commission. Sections 11 Cap A and 23A1 of the Exchange Act, because those provisions do not include the term fee. Instead, they asserted that the Commission must regulate exchange fees on an individualized basis under a different statutory provision, Section 19 of the Exchange Act, which governs the Commission's oversight of self-regulatory organizations. Second, they argue that the Commission acted arbitrarily and capriciously by failing to explain its supposed change in position from the Commission's transaction fee pilot that was struck down by the DC Circuit. And finally, they raised several other APA challenges criticizing the Commission's analysis of the rule's economic impact and its selection of 10 mils as the appropriate cap. They asked the court to vacate both the access fee cap reduction and the tick size reduction, which, as the commission found, can't operate independently of the fee cap reduction.
And how did the SEC respond?
So on statutory authority, we argued that multiple provisions of the Exchange Act authorize the rule. First, access fee caps fall within the commission's general rulemaking authority under Section 23A1 because they are necessary or appropriate to implement a number of Section 11 Cap A's directives, including that the commission assure transmission of orders in a manner consistent with the NMS and promote the efficient execution of securities transactions and the ability for orders to be executed in the best market. Access fee caps also fall within the commission's authority under Section 11 Cap A, C1B, to adopt rules to assure the fairness and usefulness of quotation information. Next, we explained that the transaction fee pilot did not undermine this rule because the transaction fee pilot merely proposed to implement a data gathering pilot and took no position as to the appropriate level of access fees. So there was no position for the commission to change in the rule at issue here. Finally, we detailed how the commission reasonably determined that the rule would benefit investors and why it represented a reasonable balancing of differing policy objectives in this complex area.
So what did the DC Circuit decide?
So the DC Circuit upheld the SEC's rule in full. The court first rejected the exchange's authority challenge, concluding that the broad regulatory authority conferred in Sections 11 Cap A and 23 of the Exchange Act authorized the commission to set an across-the-board access fee cap. As the court explained, Congress explicitly endeavored to leave the commission substantial flexibility of choice in boldly and effectively accomplishing the Herculean task of rapidly restructuring an entire industry and gave the SEC broad license to flesh out the contours of the NMS and ensure that exchanges have rules designed to promote the NMS policy that SEC develops. The court agreed that an access fee cap would help promote the fairness and usefulness of quotation information by supporting price transparency and would help promote efficiency and fair competition by supporting the commission's protections against trade-throughs under the order protection rule, placing it well within the SEC's regulatory authority. The absence of the term fee in the statutory text did not alter that conclusion. The court also rejected the petitioner's arguments that the commission could only cap fees on an exchange-by-exchange basis under Section 19. Such an outcome, the court explained, was not required by Section 19B's text, which specifically states that it does not impair or limit the commission's power to make rules under other statutory provisions. It would also make little sense. It would compel the SEC to accomplish through multiple separate rulemakings what it could do in one, forcing the agency continually to relitigate issues that may be established fairly and efficiently in a single rulemaking proceeding. Concluding that Congress did not intend to do so, to so severely constrain the SEC's rulemaking powers, the court denied the statutory challenge.
Great, thanks. You know, just given the time, maybe say a few words on the APA challenges.
Sure. So the court held that the rule wasn't arbitrary and capricious. It rejected the argument that the petitioner's argument about the transaction fee pilot, and it also held that the commission reasonably evaluated the economic evidence and reasonably balanced different factors in arriving at a 10 mil fee cap. Given agencies' wide discretion in making line drawing decisions, the court had no reason to second guess the SEC's determination, and it declined to substitute petitioner's preferred policy judgment for that of the agency.
Terrific. Terrific. Oh, I'm sorry, and you were going to say the...
No, I was just saying, and so for those reasons, the court denied the petition.
And what's the status of the rule right now?
So the commission issued an exemptive order setting a November 2026 date for the new tick size and access fee caps.
Thanks. Thank you very much. And I think think that should bring us in.
Yeah, it's not only a hardworking group, their timing is impeccable. 3:19 on the dot. And please stay for the next panel. We've got ethics credit coming your way, so don't catch your train right now. So good afternoon. I think most of you were on the prior panel, but in case you weren't, I'm Rusty McGranahan, the General Counsel of the SEC. This is my second panel as SEC General Counsel, and happy to be here. As advertised, this is the ethics panel focusing on 102E disciplinary actions per professionals. And it is my privilege to introduce Tom Carr, Assistant General Counsel for Litigation and Professional Misconduct within the Office of the General Counsel's General Law Group. Since joining the SEC's Office of General Counsel in 1998, Tom has played a pivotal role in shaping the Commission's approach to attorney conduct and whistleblower protections. His leadership of the 102E program since 2006 has solidified its focus on investigating possible attorney misconduct and pursuing administrative proceedings against attorneys whose actions fall within the Commission's enforcement jurisdiction or violate applicable rules of professional conduct. Tom's expertise and dedication have been evident in his working draft of the Part 205 Attorney Conduct Rules, as well as the anti-retaliation and other provisions of the Commission rules implementing the Dodd-Frank whistleblower program. His contribution to amicus briefs on significant whistleblower issues, including those for the United States in Lawson versus FMR and Digital Reality Trust versus Summers, have further demonstrated his commitment to upholding the highest standards of legal integrity. Tom has been an informative and engaging presenter at SE Speaks for several years, and his contributions have left a lasting impact on all of us fortunate enough to learn from him. But today marks a bittersweet milestone, as this will be Tom's final presentation at SEC Speaks before his retirement after over 27 years. We are deeply grateful for his guidance, wisdom, and professionalism he has shared with us throughout his distinguished career. And with that, I will now turn it over to Tom, who will be introducing his dynamic team. But thank you, Tom, for all your work up to now.
Thank you, Rusty. So, it's great to be here. I've been part of a team which I'm very proud to have worked with. Two of those members were able to join me today for this. First, we have Eric Riker. Eric joined the Commission in 2014, and he is a special trial counsel in our Litigation and Administrative Practice Group, also known as Gen Lit. He investigates and prosecutes attorney misconduct issues, advises on attorney Rule 102E issues, and represents the agency on a variety of other offensive, defensive, and amicus matters in the district and appellate courts. He is a graduate of Princeton University and Harvard Law School, and after graduation, he clerked for Judge Susan Oki-Malway of the United States District Court for the District of Hawaii, a state I'd someday like to visit. And then Karen Schimpf joined us in October 2000 as an attorney in the Office of the General Counsel, representing the SEC in civil and administrative litigation at the trial and appellate levels. Her work has included defending the SEC's $22 million judgment against the former CEO and chairman of Gemstar in the Ninth Circuit, and defending the SEC against allegations that one of its investigations was tainted by an alleged breach of the attorney-client privilege in SEC versus Finazzo in the Second Circuit. And specifically, some of the other things that I have worked with them or they have worked with me on have been the 102E investigations and proceedings that were brought against attorneys Gewerter, Dowling, and non-attorney Hackman, and then also an amicus brief on whistleblower retaliation issues for attorneys in the Wadler versus Biorad case in the Northern District of California? Northern District.
I think Northern.
San Francisco. And anyway, with that, and thanking PLI for inviting us to speak, I will get going. It's nothing like trying to keep people awake for the almost the last panel of 2 days, but I'm sure that both the entertainment of what we say and the need, particularly those not here, to ring a bell every couple minutes to know that they're still on will keep things going. So Karen, if you could. All right, this has been said by others, I'm sure, but I always like to do it myself. This slide presentation and panel discussion are provided in the author's official capacity as staff of the Commission's Office of the General Counsel and do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. Briefly, I want to go through today's roadmap of what we're going to do. We're going to be looking at some illustrative Attorney Rule 102E statistics, the various types of 102E proceedings that are brought sort of in descending order of commonality. E3s follow on to enforcement actions, 102E2 forthwith suspensions, and Rule 102E1 OGC original investigations and proceedings. We're then going to have some illustrative case studies from over the years, with some nod where possible to more recent cases. The Rule 102E5, which governs the reinstatement of attorneys, and all these rules, we do them with regard to attorneys because that's our charge, but Rule 102E involves all manner of professionals, and in particular, I'm sure you heard accountants. There are probably considerably more accountant 102Es than there are attorneys. We will talk about bar referrals, and then time permitting, we will get into the whistleblower protections as they apply to attorneys.
Okay, before we get into any of the details, we wanted to sort of take a step back and talk about what the underlying purpose of 102A actions, regardless of which provision we're talking about. And the key point here is that 102Es are meant to be remedial and not punitive. Now, when we talk about what remedial means, the idea is that it is meant to protect the integrity of the Commission's processes. And you can see on the slide that this has been stated in a variety of different forms, both by various courts in different parts of the country and by the Commission itself in issuing releases. So, for example, the first court that looked at it, Touche Ross, the court looked and said there's no specific statutory provision that gives the SEC the ability to discipline attorneys who appear before it, but they said that despite there not being a specific statutory provision, it was reasonably related to the purposes of the federal securities laws, and it was necessary to protect the integrity of both the Commission's procedures and to protect the public. So it was considered permitted. DC Circuit in the Marie case said essentially the same thing. And then, again, just to make sure that people were clear of what the purpose was, it was laid out again when there were changes to the rules issued by the SEC. Any questions?
Just real quickly, when we refer to protecting the processes of the Commission, is that for administrative proceedings or filings with Corp Fin or otherwise?
Yes, it covers all of it. So anytime I don't know that we're actually going to talk too much today about what constitutes appearing and practicing before the commission, but any sort of action that involves the commission, whether it's as a defense counsel, whether it's making filings, whether, other interactions with the commission are included, and in protecting the integrity of all of those is behind the 102E statute and purpose.
And before Eric moves on to the next part, or before we move on to the next part, I did want to note that Eric did mention touche ras, them saying there was no statute at the time covering or governing 102Es, that subsequent to that, Section 4C of the Exchange Act was put in, which does largely mirror Rule 102E1. And with that, so getting into statistics, I always like to bring up some quotes, which I think this time, Karen, were like AI-enabled to find.
The pictures are AI-enabled.
Okay. The quotes were your hard research.
I had fun using AI to make some of these things.
Just some serious or some whimsical comments about statistics. Albert Einstein, not everything that can be counted counts, and not everything that counts can be counted. W. Edwards Deming, who I read was a very reputable physicist, engineer, statistician. He did models, which the Bureau of Labor Statistics relies on to this day, wrote, "In God we trust, all others must bring data." And then statistics, the only science that enables different experts using the same figures to draw different conclusions. And I found out that Mr. Azar was listed as a humorist, so consider the source. But with that attempt at humor, let us move on. So total attorney 102Es by type, and this is from 1994 to the present. The vast majority, well, not the vast majority, but the majority have been E3s, which are follow-ons to commission actions. Then there are E2s, which are forthwith suspensions that are reciprocal suspensions based on either a criminal conviction or a suspension by a state bar of an attorney. And then E1s, which are original investigations. E1 Romanet 3, which is listed on the right, there are 25 of those. Those are brought under E1, but similar to E3, they're for substantive violations of the federal securities law. So we often lump those with E3s when we're analyzing the types. And the lengths of suspensions. In the less than 5 years group, which is like 3 or 4 lumped together, it looks like roughly an eighth. There are many different suspension lengths, but none less than 6 months. Permanent suspensions include all E2s, which are, again, criminals based on criminal convictions or bar suspensions. Permanent suspensions that aren't an E2 are predominantly cases where the attorney agreed to a permanent suspension and a follow-on to an enforcement action, predominantly but not exclusively. And suspensions that are less than permanent are predominantly cases where the commission has accepted a settlement agreement for a settled administrative proceeding.
So what is the outlook for Rule 102E going forward, do you think, Tom?
Given the remedial purpose of Rule 102E, would expect the commission to continue to institute 102Es to encourage adherence to professional standards when practicing before the commission and to protect investors. Again, that is for attorneys, for accountants, for those gatekeepers generally.
All right, so what are some of the most common types of misconduct we've seen over the years? Misrepresentations, offering frauds, fraudulent opinion letters, conversion of investor funds, other crimes, for example, money laundering, false filings with or misrepresentations to the SEC itself, insider trading, and both the unauthorized practice of law and facilitating the unauthorized practice of law. We didn't try to sort these out into statistics because often there's more than one type of misconduct that comes into play. So there will be both some fraudulent opinion letters and an attorney using their attorney escrow account to take money in and then give it to themselves and to the fraudsters, so converting investor funds. So some of these we see people hitting trifectas and even better, but we wanted to give you guys an idea of, in general, the types of things that we see. Any questions about that? Okay.
Okay, Eric?
Okay. So we're going to start in terms of the different types of 102E proceedings with 102E3, which, as Tom just mentioned, numerically is by a significant margin the most significant. These can be brought in two different circumstances. They can be brought when somebody has already been enjoined by a court of competent jurisdiction for misconduct in an action by the commission. Now, this is important because under either of these provisions, whether we're talking about the injunctions or violations of the federal securities laws I'm going to get to in a second, it has to be a commission action. So if there is a proceeding, either private parties or criminal authorities, we cannot rely on E3. Now, with criminal authorities, you can get into E2 and other circumstances, but when we're talking E3, it is just commission actions. And then in addition to having an injunction issued, you can also proceed if there's been a finding that a person has violated the federal securities laws or aided and abetted a violation of the federal securities laws. When you have settled E3s, they're often based on a permanent injunction that follows after there's a finding that somebody has violated or aided and abetted in violation of the federal securities laws, but there is no actual requirement that we wait for the injunction to be issued. Just the finding alone would be sufficient.
And what is the deadline for bringing a follow-on E3?
So the deadline is 90 days after the case truly becomes final. So all appeals are exhausted and what have you. So even though I mentioned a minute ago that we don't have to wait even for a final judgment, so because again, injunctions will often follow after a finding that somebody has violated the underlying laws. We have the ability to move at that point, but the actual deadline is 90 days from when the case truly is final.
And I'd also add, at least historically, it is under subpart B there, it is possible for there to be a 102E follow-on AP followed by a earlier AP or an original AP for substantive securities law violations. Now, obviously, that practice, without getting into the analytical underpinnings of it, that practice, may be impacted by JARCASI in terms of the number of underlying federal securities law APs that are brought. But historically, there have been cases where you have a 102E AP following a federal securities law AP, so an AP premised on an AP.
As we may have mentioned before, most follow-on suspensions are part of a settlement package that's worked out in the Division of Enforcement. So our office may have some involvement behind the scenes, helping, advising, but it is taken care of as part of the enforcement settlement. But many times that's not the case, and if there's a consideration of follow-on where there hasn't been a settlement, it would be our office that seeks to recommend to the Commission whether a follow-on administrative proceeding is warranted, and if so, what relief might be appropriate. And then if the Commission were to recommend a follow-on proceeding in those circumstances, again, it would be OGC, not enforcement, who would handle that matter. If there is an order instituting proceedings under E3 that results in the immediate temporary suspension of the respondent for the duration of the litigation, the respondent has 30 days to respond to the initial order. If they do not respond, then the suspension becomes permanent. If they do respond, then the matter gets litigated, but usually they're handled via summary disposition. So it's really just on the briefing. There's not generally discovery. There's not generally hearings, witnesses, et cetera, because the underlying facts of the case that brought us here can't be challenged. So if this is based on a finding that somebody has violated, 10b-5, there's no ability to challenge that in the underlying, in the follow-on case. Now, what the follow-on case does look at is referred to as the Stedman factors. So this is determining what, if any, action is appropriate. That includes the egregiousness of the misconduct, whether the violations were recurrent or isolated, the degree of scienter, the sincerity of assurances against future violations, recognition of the wrongful nature of the conduct, and likelihood the person's occupation will present opportunities for future violations.
So Eric, how does Rule 102E3 for work if the underlying enforcement action was settled at the outset? In other words, there are no findings. What happens with regard to what is considered proven for purposes of doing a follow-on in term of facts?
Rule 102E3, Romanet 4, explicitly addresses this, and it deals with a person who has consented to a permanent injunction in a situation where they have not admitted to the underlying facts, generally be a no admit, no deny. And in that circumstances, the facts in the complaint are presumed for the purposes of the follow-on to have occurred. That means that we can rely on any and all of the allegations in the complaint, and the attorney can't try to dispute them in the follow-on proceeding. Also, if the enforcement action was settled, but that deal did not extend to settling the Rule 102E implications, then the matter gets handed off to Office of General Counsel, us, and then we handle aspects of the 102E litigation, or alternatively, as appropriate, recommend to the Commission that they not pursue a 102E action.
All right, 102E2, also called forthwith suspensions, because when the Commission issues it, it's an order of forthwith suspension. It's immediate. There's no chance to have a hearing ahead of time because it's reciprocal to something where the person has already had the chance to have their day in court. So the key point here is just if you are convicted of a crime, you as a lawyer, if you're convicted of a crime or if you lose your license, then you can also be suspended from appearing or practicing before the SEC. And one common misconception is that that misconduct has to have been in connection with something to do with your securities work, and that is not part of what's required under 102E2. So the Commission can and has issued orders where it found it appropriate, even though the misconduct that was the basis for the disbarment or conviction wasn't itself related to the securities work.
Okay, a couple things there, Karen. First, I would just note where it says convicted of a felony or a misdemeanor involving moral turpitude, it may not be as crystal clear here, but in the release where this rule was put in, it makes it clear that if you're convicted of a felony or of a misdemeanor involving moral turpitude, that can form the basis of a 102E2. So in other words, any felony could serve as the basis for a 102E2. One other thing I wanted to point out was, although the conviction does not have to be for securities practice, in determining whether or not a 102E2 is worth it, you'd be looking into what this person was doing in terms of their ability to, affect investors or processes. So I can think of at least one or two cases where someone was convicted of something that was not securities fraud, but had a very active current securities practice and had been convicted of fraud. And there I would, it would be in the Commission's interest to not have fraudsters who were practicing before them continue to practice before them. Karen, can a 102E2 be imposed even while a sentence is being appealed?
Yes, and that has happened. So unlike E3, there is not a specific deadline. Eric mentioned E3s. We have 90 days after it's truly, truly final. There's no specific statute of limitations under E2. And there definitely have been times where the Commission has felt it was not necessary to wait until the appeals had all played out. And they wanted to go ahead and get the person suspended even while that played out. And we'll talk a little bit later about what happens then if they actually were to prevail on that appeal and what effect that has on an E2 that was issued.
And one last question.
Okay.
If you want to kick it back to me, feel free.
No.
Can the Commission institute an E2 and an E3 at the same time?
They can and they have. Usually the situation there is that the person is continuing to litigate with the Commission and they get a criminal conviction, so we can do an E2 based on the conviction. And it's and they're still, a lot of times appealing that as well. And so it can be a prophylactic to get both an E2 and an E3 so that if the basis for one goes away, we still have a basis, the person is suspended on another basis to try to keep them out.
Thank you.
So E1, we also call OGC investigations because typically it's our group that handles these from the outset. And the main thing that we look at here is the Romanet 2, lacking in character or integrity or having engaged in unethical or improper professional conduct. And it's really that last part. And what we do there is we do not have, the SEC does not have its own standards of practice, ethics rules. What we do is we look at the rules the attorney is already subject to wherever they're licensed. And if they're licensed in multiple jurisdictions, we can and do look at all the places they're licensed to see what those rules of practice are and if the misconduct violated any of those. There's also some other sources that we can look to. We can look at other laws or regulations that the person is already subject to. The key thing here is the already subject to. We're not making up new stuff and holding people to it. They should already be on notice of what their obligations are. On Romanet 1, just the point there, not to possess the requisite qualifications to represent others. We had a spate of cases a while ago. Those seem to have gone away, fortunately, where a lot of internal counsel thought, hey, I'm not in court. I don't want to keep up with my CLE and listen to Karen at another SEC Speaks. So I'm just going to let my license lapse. And they wound up letting all their licenses lapse, but they were still acting as lawyers. So not only did they have bar issues, but they also had issues with us because they were appearing and practicing without actually being licensed anywhere. So again, we haven't seen too many of those lately, but if you have any corporate counsel, just remind them they're still lawyers. They still need to be licensed somewhere. And then Romanet 3, we mentioned in the statistics piece, we typically look at as being equivalent to an E3 follow-on. I'm not aware that it's ever been used outside of the context of enforcement having an administrative proceeding, which there are far fewer of these days, and they had a global settlement of that cease and desist proceeding and the 102E, and it was negotiated to be under E3. E1 102E1 Romanet 3. I'm not aware of there having been any standalone cases that our group has ever brought trying to press Romanet 3 for a variety of reasons. And when our group is doing these investigations, we get to, part of what makes our job the best in the commission from my perspective, is we get to handle our cases from cradle to almost grave. If it goes to the Supreme Court, then the Solicitor General of the U.S. gets involved. But if it goes to appeals to the commission, if it goes appeals to the federal appellate courts, we get to handle all of that. We don't have to hand it off. And we use pretty much the same tools and processes that you're familiar with from enforcement. So not that anybody here would ever think this, but if there were thoughts that, it's OGC doing an investigation, that's got to be easier than dealing with an enforcement investigation, no, we model our approaches on what enforcement takes.
Okay, now we're going to delve into a variety of case studies that will cover the various provisions of 102E that we've talked about so far. So to start, we're going to talk about an insider trading case. So this person, I believe David Sargent, he was tipped by a friend and former colleague who worked at a company called Chegg, and said that Chegg was about to release positive earnings information. Based on that information that he received from his friend, he purchased both stock and options in the company days before the information was released publicly, and sold them shortly after the release for a profit of over $100,000. The Division of Enforcement brought a civil case against Sargent that resulted in permanent injunction, over $200,000 civil penalty, and then we had, as a follow-on proceeding, a 5-year suspension that he agreed to. And again, since this was a follow-on based on an injunction, this would have been under E3. And Tom, I think you had something you want to ask.
Yeah, I want to ask you if in this one there was a related criminal case.
There was, as is often but not always the case when there's an insider trading matter, the criminal authorities also brought a case. This had a little bit of an unusual procedural history in that at trial, Sargent was convicted, but the person who tipped him was not. But then in the post-trial briefing, the judge granted his request for a judgment of acquittal. So ultimately, Sargent was not convicted in the criminal case, but it still, I'm sure, was quite an ordeal for him to have had to go through.
Okay, next up we're going to be talking about generally misrepresentations, offering frauds, and false filings. And if I can very quickly digress, originally our colleague Rob Berger, who couldn't make it here today, was going to be here to present this one since this was something he and I both worked on advising enforcement on. And I also want to thank him for his service, and then also other people from my group who aren't here today, Sean Robinson and Phil Holmes, and our paralegals, Taye Akinola and Diana Martinez, and former colleagues in OGC, now out in the wild world outside of the SEC, Juanita Hernandez and Smith Gregg, part of a great team I've been able to work with. But now, turning to our first case here, Donal Schmidt. He was the board chair, president, and CEO of Rapid Therapeutic Science Labs, which professed to have be experiencing success with a variety of cannabis products. And he was charged with drafting, disseminating, and filing false and misleading various documents, basically on issues like whether or not the company had met some sort of international standards, the qualifications of their chief science engineer, the safety of their inhaler products, basically a number of things getting to the core of the business. And with with Schmidt's work, among others, on disseminating this information, the company raised at least $2.8 million in unregistered sales, and Schmidt sold his shares for, I guess, roughly $1.15 million. Consequence was permanent injunction, sizable disgorgement, prejudgment interest, and civil penalty, a 5-year conduct-based injunction against participating in the issuance, purchase, offer, or sale of securities, participating in penny stock offerings, and serving as an officer director of a public company. And he also, as a separate consequence, the one of primary interest to us, agreed to a 5-year follow-on suspension as both an attorney and an accountant.
So, Tom, we can tell from the case citation there, Donald Schmidt, Esquire, and CPA. So you meant, obviously, we talked earlier that OGC only handles attorney 102Es. What happens in a case like this where somebody is dually licensed as an accountant and an attorney?
Well, in a case like this, because it was settled, it doesn't particularly matter who takes the lead, because basically it's going to be settled and wrapped up on recommendation of the commission. If one were to be litigated, like if you had a securities law violation against someone licensed or acting as both an attorney and an accountant, but they got a judgment against them, but they did not settle, then doing a litigated 102E3, there we think GC and enforcement would have to work together to decide how that would be prosecuted. We have not yet had that, so in the future, you might have that one, and it'll be something interesting to talk at a future SEC Speaks.
If it happens, I'm sure we'll talk about it.
Yeah. And since you brought up the accountant and attorney, let's move on to the next case.
All right. Is it moving on? There it goes. All right, so Mr. Mazza was the CEO and CFO of Biozone Pharmaceuticals, and he also was dually licensed as an attorney and accountant. What did he do? He signed an SEC annual filing, an amended filing that didn't disclose more than 5% shareholders, didn't disclose the true management who was truly controlling the company. He also falsely assured a broker that one of those individuals had no agreement and no understanding that would preclude them from selling Biozone stock, when, of course, I think falsely, I guess already says it, that was false. So he agreed to a permanent suspension as both an attorney and an accountant from appearing or practicing before the commission. Okay, Fernandez?
Oh, me already. Good point. Okay, Fernandez, she was a manager with MJ Capital Funding. She and her team of over 64 sales agents solicited investors. She personally raised $891,000 from a large swath of investors, received $362,000 in commissions. She posted a video, entrepreneur lawyer, on Instagram saying she grew her investment portfolio in MJ Capital to the point she could leave her job as an attorney. That's not what I'm doing. Claimed in a video that she sent to her sales team that MJ Capital was not a Ponzi scheme and does not have to take money from Peter to pay Paul, when apparently they did. These are echoes we see in many different cases, paymaster cases, attorneys touting stocks cases, is the attorneys use their status as an attorney, often funds going through an escrow. Basically, I'm an attorney, you can trust me, to be an added lull or enticement into people participating in these fraudulent schemes or being taken by them. So what happened with Fernandez? She, her affiliate and principal of those companies were found, to be running a Ponzi scheme. She hadn't made money by growing her investment portfolio. Consequence of it was permanent injunction, $395,000 disgorgement, prejudgment interest and penalty, and agreed to a permanent follow-on suspension.
All right, so we do have an example of escrow misuse, paymaster abuse. The first, I don't remember how many we have, maybe the only. Borenstein allowed investor money to flow through his law firm's attorney trust account, and he then immediately dispersed that money from the investors to the principal fraudster, a guy named Marino, at his direction. He didn't take any steps to verify who sent the money, why they sent it, whether the disbursement instructions he was given and that he complied with were consistent with what the investors had been told. Spoiler alert, none of the above. He also falsely told a victim that there was a $20 million incoming wire in the queue at the bank, and the victim would get repaid from that imminently, again, falsely. And he kept 10% of the money he received as his own fee, which in the complaint, the SEC alleged should have been a red flag that he wasn't being paid just to serve as a simple pass-through. So he had permanent injunction, little bit of disgorgement, a lot of trouble to get into for only $31,000, and a permanent conduct-based injunction, and you can read that whole text if you want. In addition to that, he agreed to a 1-year follow-on suspension. We've mentioned conduct-based injunctions a couple times, but I don't think we've said yet, why would there be a conduct-based injunction and a 102E? And I can answer my own question if you want.
Go for it.
Okay, great. All right, so why are there situations like Borenstein? The conduct-based injunction gives the commission an easy on-ramp to filing if there needs to be remedial action because the person keeps doing things they're not supposed to be doing. But a CBI is a much more limited, of course, especially in some jurisdictions, has to be very narrowly tailored. So a 102E suspension gives us broader protection from anything else, not just this one particular type of fraud the person did, but we can keep somebody who's done fraud out of appearing and practicing before the commission more generally. So we like to have, again, sometimes there's a belt and suspenders approach. And I may have jumped ahead a couple. That may have been a question that we were supposed to ask down the road, but oh well. All right. This seems like also a good time to discuss duty to inquire, because part of what we mentioned is there were red flags, and in many of these cases we've seen there have been red flags. And we wanted to make sure, these have been out for a couple of years now. I don't have the year written down, but ABA Model Rule 116A and ABA Formal Opinion 513 both say that a lawyer has to inquire into and assess the facts and circumstances. What we really want to call your attention to is comment 1. Comment 1 makes it clear that the obligation imposed continues throughout the representation. If there's a change in facts and circumstances, then you have to go back and ask again. It's not a one and done. So the model rule itself is not a basis that we can use in 102E actions on the ethics. Again, we have to look at whatever the particular state rule is. But it is noteworthy that in the model rule and in the lead up to what became this model rule and this formal opinion, North Dakota Supreme Court Justice Daniel Crothers said, this is not introducing any new obligations, it just makes explicit what is already a lawyer's duty. So don't think that just because your jurisdiction may not have this exact language, that it means you can do a one and done. It's something that we would look at very closely to see exactly what that state's rule is and whether we can say that this is already encompassed within it. See also Model Rule 1.2D, which is you can't counsel a client or assist a client in conduct that the lawyer knows is criminal or fraudulent. I think probably many people who are diligent enough to be watching this wonder, does that really happen? But we've shown you some examples, and there's just, how many hundreds did we say on that first slide, of lawyers who have assisted clients with their frauds. So if you take nothing else away, please don't assist your clients with frauds. And Model Rule 8.4B and C, attorneys have duties of honesty and integrity. And 8.4, almost every jurisdiction has some version of, and it's one that we frequently invoke because a lot of times what has happened is the attorney has been involved in misrepresentations or in fraudulent misconduct. So we see lawyers ignoring red flags in a wide variety of cases, but particularly in these escrow paymaster cases, and then in the next type, which is attorney opinion letters.
So as Karen mentioned, this is another area where red flags come up quite a bit. Attorney opinion letters, it's important to be mindful of the duty to inquire and not ignore red flags. Opinion letters typically are used as an exception to the normal registration requirements, for example, removing restricted legends. So it often serves as a gateway to entering the securities market. And there are absolutely circumstances where that is completely appropriate, but it is also a place where very often there is a susceptibility to fraud, and these often come into play as a key part in pump and dump schemes. So to give a more tangible example, there's an attorney named McMurdo. He signed and issued 10 opinion letters to OTC markets, and he knew or should have known that his letters had materially false or misleading representations, including misidentifying who prepared the financial statements, falsely stating that a CPA had prepared the financial statements, and stating that neither the company nor any 5% shareholder were under investigation. These and other red flags, he stated that he felt uncomfortable about them, but yet he still continued signing and issuing opinion letters. So in the end, he was suspended for a year based on Rule 102E1 competence, Rule 1.1 competence, Rule 1.3A diligence, and Rule 8.4 misconduct.
Okay. Another opinion letter case was Bauman writing opinion letters that falsely asserted shareholders were not affiliates of his client company. There was indication of such coordination between shareholders, but he didn't make a reasonable inquiry and didn't even speak with the shareholders on whose behalf he was writing the opinion letters. Those were also used as part of the scheme. He agreed to a 5-year suspension, and he also agreed to a 5-year conduct-based injunction. And now, I guess we're now moving on to reinstatements. Reinstatements of professionals suspended from appearing and practicing before the Commission are covered by Rule 102E5. Someone who's been, the E5-1 says a person who is permanently suspended or disqualified under either E1 or E3 may seek to be reinstated at any time, and the applicant may, in the Commission's discretion, be afforded a hearing. However, the suspension or disqualification shall continue unless and until the applicant has been reinstated for good cause. Good cause is the standard there. The second provision is for attorneys or for professionals who are suspended under paragraph E2. That's again criminal convictions or for bar suspension. They shall be reinstated under appropriate application if the grounds for their being suspended have gone away. Which would be if you've been convicted, if the conviction is overturned, or vacated, And for a bar suspension, it would also include if the bar suspension is lapsed. If the basis for the 102E2 suspension has not evaporated or gone away, then the suspension, you can ask for a hearing, and the suspension shall continue unless and until the applicant has been reinstated by order of the commission for good cause shown. So that would be the same under E2, good cause standard, as under 102E5, Romanet 1.
So, Tom,
Yeah.
what happens, let me hit my back arrow here first. What happens if someone has been subject to a term of year suspension? We saw in those statistics that we've got many that are not permanent.
I think we're about to get to that in
About to get
just
to
a
that?
second.
Okay.
Yeah.
Great.
So, a couple examples for the E2s where all predicates have been removed. In Graham, suspension was based on a criminal conviction. The Second Circuit vacated that conviction, and the indictment was dismissed, I believe, with the pursuant either to a deferred prosecution or non-prosecution agreement. That Graham applied for and was reinstated. So the basis was gone. He did have to apply, and then he was reinstated. Similar is under E3, Jelaine Bauer. Litigated E3 had taken place, and there was a finding of securities law violation there. She appealed that, and she appealed the 102E suspension within the commission. Simultaneously, she appealed to the Seventh Circuit the finding of securities law violation. The securities law violation finding was vacated. When it was vacated, because it was vacated and not reinstated, she came to the commission, which reinstated her to practice under 102E5.
Okay, so you can tell from the stats that nearly 25% of all suspensions are for a term of years. One of the key things we want people to take away is that on an application for reinstatement, we do review compliance with the requirements of the suspension order. If we have time, we might show you a little bit of what some of those look like. So about 25%, that means those are cases where the enforcement has reached a settlement that the commission approved. Okay, and so you'll see in our term of years cases, there will be a provision that specifically says you have to comply with, the various commission orders and undertakings, but it's not only in those cases that we check for compliance. If somebody's out under E2, even if all the bases have been removed, we're going to look for compliance, and if there's not compliance, then we're probably going to recommend the commission take further action. So Bering is an example. He was a principal at an accounting firm, didn't conduct a reasonable inquiry, didn't halt the practice. He was suspended for a year. After his time had expired, he applied for reinstatement. And our independent inquiry, we don't just take your word for it, demonstrated that he did appear to have met the conditions that were agreed to in his suspension order. And so there's quick look at what that looks like. Hold on one second. I might have to have Eric take over. I'm not going to read all that, obviously. You can go look at it yourself, but that's all the things that he would have to show. However, it really breaks down to, have you obeyed your 102E suspension? Have you paid your disgorgement and complied with any other undertakings? And have you kept your nose clean since the suspension? I mentioned that he was reinstated.
Okay, I'll take over now. Next, we're, I believe.
So,
Oh, sorry, I'm not taking over yet.
close. If he hadn't been able to show that he met all the requirements, there is a provision in the order that says that you can still come in and ask. 105E or 102E5 is still a thing, and the commission, in its discretion, can reinstate. But at that point, you're back to the good cause shown. Whereas if you've met the conditions of a term of years suspension, then you're presumptively eligible. So that's the difference there.
And the thing I would quickly add there is someone who's had a term of years suspension, if they're looking to be reinstated, they should look at the conditions and the language that was put in their suspension order, because that's going to be the roadmap for what they need to demonstrate. Eric?
Okay. In contrast to what we were talking about before of term of years, when it comes to a permanent suspension, as I think we mentioned, the standard is good cause, and there's no presumption there. The commission has discretion to determine, based on the facts and circumstances, whether reinstatement is appropriate. On the next slide, we show a little bit of a compare and contrast between two people who had applied, one who was granted reinstatement, one who is not. Since we're starting to run a little short on time, I'll go quickly. A couple of salient differences. Wolf, who was reinstated, had been out for more than 6 years. He actually had applied for reinstatement after only 2, and that was denied, whereas Masters, who was not reinstated, had only been suspended for 3 years. Another factor is the willingness to acknowledge the wrongfulness of your conduct. Masters, in addition to seeking reinstatement for his 102E, tried to have his original consent decree, the underlying case, vacated. So that was, there were a variety of factors that differed, and it's just an example of how facts and circumstances, commission can come different ways. One other thing worth mentioning about Masters, after the commission denied his request for reinstatement, he appealed to the Ninth Circuit, as is his right, and the Ninth Circuit addressed it, but the Ninth Circuit affirmed the commission's decision not to reinstate him.
Eric, who argued that case?
I did.
Okay.
So as Karen mentioned, or somebody mentioned earlier, when these type of cases are appealed, they're usually handled by us, and that one I did.
Okay, we're at T minus 3 minutes. Usually, we were worried we wouldn't have enough to last the hour, so now we're going to put it into turbo mode. So non-compliance, the real takeaway here is that if you're not in compliance, then there's a variety of remedies that we can do. What does it mean? First of all, you need to know what does it mean to appear or practice before the commission, if you want to know if you've been appearing or practicing before the commission in violation of your suspension. So there's 2 places to look, 102F and Part 205A1. And the salient point on the Part 205 is that in the I believe it's the proposing or adopting release, the commission clarified that this was not intended to be something new, even though it breaks things out a little bit more than 102F. This is all covered within 102F. And it's intentionally broad to give the commission maximum discretion in protecting the processes. Sorry, I really don't know what's going on up here. All right, the remedial relief that we can get, you can go from a term of years to permanent. We can go to federal court to get an order to enforce our suspension order under Section 21E1, and we did that in the Hackman and Vincent cases, which Eric and I worked on together. But if you don't remember anything else from this section, we can also get disgorgement of fees that the attorney receives for work that violates their suspension. So in Vincent, it was only $6,000, but in Hackman, it was nearly $1 million that he was ordered to pay back.
So do we have time for that? Yeah. Joe? Okay. In addition to what we discussed, we will often make referrals to the state bars that are relevant with the particular attorney. That can be either after we have issued a suspension, or there are times where, for one reason or another, we don't do anything directly, but we will make a referral to the bar. One example here is an attorney, Fayez Dean. He was involved in illegal unregistered sales of securities, and ultimately the Washington bar suspended him, but they acted reciprocally based on discipline from the Bar of British Columbia, and they relied on various provisions of Rule 8.4 to do so. Okay, in terms, and it's worth noting that here they relied on a foreign bar. Different states have different rules on what sort of authorities can be used for reciprocal discipline and which they have to do. I haven't done a 50-state survey. Generally speaking, I don't believe most bars will act reciprocally based on an SEC suspension, but again, the specifics will vary by the individual state.
And particularly if it's a no admit, no deny settled SEC suspension.
Another example is an attorney, Howard Kleiman. This time it was Minnesota. Again, there were underlying securities law violations. He was disbarred, and then separately, we suspended him. Although it wasn't based on the disbarment, it was based on the underlying securities violations. And it's an example where similar underlying conduct is acted on by different parties, but on slightly different bases and for slightly different reasons. Minnesota focused specifically a lot on the trust account because that's something that's very important to most bars, whereas the SEC suspension focused on the underlying securities law violations.
All right, so I think we're out.
Grace, do we have 1 minute or are we done? Okay.
1 minute? Okay.
Speed round, Karen.
There we go. Whistleblower protections for attorneys. Very important. You can report internally, so you guys should all have these handouts available to you. You have a duty to report internally if there's evidence of a material violation of the federal securities laws. The Supreme Court has recognized how important that protection is. As a practical matter, if you are trying to, if you feel that you've been retaliated against and you're bringing an action to say, stop retaliating against me and make me whole, you're gonna have to use confidential information in order to do that, including your own Part 205 report, where you tried to get your company to do the right thing and they said, never mind, bye, Felicia. So ABA Model Rule 1.6b5 addresses this a bit, talking about that you can use confidential information to establish a claim or defense. I'm not going to go through it, but I would also point out that in the first part, it talks about you may reveal information externally. So we were talking about internal. You can release externally under the model rule in certain circumstances, and 205.3 D2 has very similar language that basically if you're doing fraud that's reasonably certain to result in substantial injury to financial interests, then you can report out, which does include to the SEC. So there are whistleblower provisions. To this day, I'm just going to stop one of the questions. No attorney has gotten a whistleblower award to date. But there are provisions under both Dodd-Frank and the implementing regulations. It's limited to the employer-employee relationship. So if you're outside counsel, you're a little bit more out of luck. You have to qualify as a whistleblower, which means you have to report to the commission in writing before the alleged retaliation. And then you can see there, the highlight will show you the other things that you need to be able to show. So you can go look at 205D for that. And as I got handed the note that it's time, here you go.
And I will end with this. It's easy to say these things, but knowing what's right doesn't mean much unless you do what's right. Obviously, I aspire to that and don't make it most of the time, but it's something for you all to keep in mind. Thank you for coming today and listening to us.
Thank you to everyone who stayed for this panel late on a Friday afternoon. We appreciate it. Good to see you here. My name is Kate Zoladz, and I am one of the deputy directors in the Division of Enforcement. I cover the Western region, which includes the Los Angeles, San Francisco, Fort Worth, and Dallas. Sorry, and Dallas is in Fort Worth. They're near each other, and the Denver office. Really great panel we have here today. I am just going to give the disclaimer before I introduce everyone because I'm going to forget to do it otherwise. So all comments today are provided in the panelist's official capacity in the Enforcement Division, but do not necessarily reflect the views of the Commission, the Commissioners, or the staff. So next to me is David Morrell, who is a Deputy Director for the Northeast. That includes the Boston, New York, and Philadelphia offices. Next to David is Paul Sir, who is also a Deputy Director in the Division of Enforcement, and he covers the Central and South region, which includes Chicago, Atlanta, and Miami. Next to him is Michael Brennan, who is an Associate Director in our Washington, D.C. home office. Next to Michael is Laura Dillard, who is the Chief of the Cyber and Emerging Technologies Unit. Next to Laura is Justin Jeffries, who is an Associate Director in our Atlanta Regional Office in the Division of Enforcement, of course. And then finally, we have Nick Heinke, who is also an Associate Director in Enforcement in our Denver Regional Office. So many of you were here, I think, for the morning panel with Sam and others, and they addressed the question of what to expect from enforcement this year. So in this panel, we're going to get a little bit more granular about some of those same themes. We're going to start with some thoughts about how we're thinking about some process issues, and then move on to talk about specific subject areas. So with that, the morning panel spoke about the focus on investor harm in terms of our enforcement priorities, but also it's a critical component of cooperation is remediating harm. So Paul, what does effective remediation look like?
Thanks, Kate, and thank you, everybody. So remediation is an important factor for the staff and commission that the staff and commission will look at when assessing whether cooperation credit is appropriate. And the new enforcement manual gives good guidance on what we consider. Depending on the situation, effective remediation can include holding wrongdoers within the company accountable, improving controls and procedures in the company so that the company is more likely to prevent the misconduct from ever recurring again, and compensating those harmed by the misconduct. The enforcement manual also includes some general examples of effective remediation. Clawing back compensation from responsible executives, making prompt corrective disclosures, hiring new financial and accounting staff to address accounting and disclosure issues, and improving training for relevant personnel.
Thank you, Paul. So I think I would just add to that within the cooperation framework, we can continue to be focused on holding individuals accountable. So I know some of the other panels have talked about the ADM matter, which I think people are pretty familiar with and sort of has some cooperation there, and there was remediation in that case, and there were also charges against individuals. I did just want to give another example of holding individuals accountable. And that's an example where in December, the commission charged 3 former executives of Ammo Inc. with accounting and disclosure fraud. The SEC's complaint alleges that Fred Wagenhals and Robert Wiley made repeated materially false and misleading statements in Ammo's public SEC filings and financial statements that generally had the purpose of hiding or obfuscating unfavorable information about the management and operation of the company. This included false and misleading statements hiding that defendant Christopher Larson played a critical executive and management role, notwithstanding a federal court order from 2020 that prohibited him from holding and performing an executive role at a public company. So the complaint in that matter seeks civil penalties, officer and director bars, disgorgement from Larson of ill-gotten gains with prejudgment interest, and reimbursement from Wagenhals and Wiley of certain executive compensation. So David, the morning panel talked about the updates to the enforcement manual related to providing for greater transparency and fairness in the Wells process. There have also been some timing changes to the Wells process. What is the goal of that timing, and can you walk us through the changes?
Yeah, sure. And thanks again to everyone for being here.
So, right, so the enforcement manual updated the Wells process, and one of the big changes was giving proposed defendants 4 weeks in order to, from the date of the Wells notice, to make their written submission. In addition, they're able to request a meeting with staff to confer about the submission if they ask to have that meeting within 4 weeks. And both of those are important changes to really reinforce and bolster the Wells process and allow issues, both factual and legal, to be fully ventilated before staff ultimately make a recommendation to the commission. And it really is, I just want to underscore, it is a really meaningful process to the staff and to the commission. It advances transparency. It allows proposed defendants to understand how staff are thinking about a case, how they're framing the potential charges, what the staff see as the salient facts and evidence supporting those facts. And it also allows proposed defendants and their counsel to have an opportunity to address the staff's theories, the facts upon which they rest. And I can tell you that the staff take the process extraordinarily seriously. The commission, it's a very important step in our process. And so proposed defendants should lean into it and use the opportunity to make their case. And sometimes, not always, proposed defendants will convince staff to not make a recommendation and not to move forward. And so I think it's an important strengthening of an already important process that the commission staff use before making an enforcement recommendation. Another feature of the revised Wells process is the ability to meet with senior leadership if, upon request, the enforcement manual has indicated proposed defendants can have a meeting with senior leadership, which is defined as associate directors or unit chiefs or higher. You're not necessarily guaranteed a particular person. You're not necessarily guaranteed multiple meetings, but you are, the expectation in most cases is that parties will be able to meet with those senior leaders or higher. And so I think that's a real, like I said, strengthening of the Wells process. And even if you don't, again, meet with the senior-most leadership, I can tell you that issues do get escalated up the chain of command. And so even if they're not sitting in the room with you, the issues raised through the Wells process are considered and ventilated through the agency.
Thanks so much. And David, just to follow up on that, do you think that having these deadlines might actually move things faster or slower? What do you think?
Yeah, no, I think that's a good question. I do think these changes in the enforcement manual about timing, I think it sets clear expectations for everyone. Often staff will give an indication that they're moving towards a Wells notice, and when you have some visibility into when it may be coming, plus 4 weeks for the written submission, plus 4 weeks to request and have a meeting. What that means is it is a good amount of time to make your case. But I think when everyone is operating on the same timeline, we can all plan and move the process along more efficiently, because it's not good for the commission or for proposed defendants to have a prolonged process when we all, both the defense and the commission, want to get to the right conclusion as quickly as possible.
Thanks. So Paul, you've now been on both sides of the Wells presentation here. What do you think makes for an effective Wells presentation?
Yeah, so we on this side at this table, we get Wells requests and sit in on Wells meetings all the time. What we need is honest engagement by defense counsel on the facts and the law. We also need you to be efficient and think efficiently in making your case and getting to the heart of the matter during your submission, your written submission, and during a Wells meeting. Look, there are great lawyers on both sides of these presentations and meetings, and by the time you actually sit down and meet with us, the issues have been narrowed and focused. Let's focus on those issues. That's what's going to make a Wells presentation more effective and easier for us to follow, easier for us to be able to digest. And to all of that, the enforcement manual lays out some good guidance on effective Wells submissions. Again, accurately reflect the evidence, the legal issues, and the precedent in your written submissions and then your oral advocacy back to us. Address the legal elements that establish each violation against each potential defendant and explain why you think the evidence doesn't meet any one of those elements. Address litigation risks that, or policy or programmatic concerns that you think are going to be important to us to hear and that we're going to need to address and think about after a meeting. Provide the documents and citations to the record that we've built up in advance of the meeting so we can understand exactly where you're going with your arguments. When appropriate, look to and give us your views on how the seaboard factors apply in your particular case. And finally, not in every case, but if a case is particularly technical, particularly complex, consider even going so far as to retain an expert and give us an expert report to support the arguments that you want to make to us. We'll receive it. We'll consider all of this. These are just some ways to really focus in on the key arguments that you want to make.
So what I'm hearing is longer is better.
Not necessarily. No, no. That's the point of being focused. What we don't need is a recitation of all the background facts that you know that we already know. Get to the point. If there's some lengthy, complex argument that you need to make, then feel free to do so. But really hone in on what you think is the salient point or points that are going to carry the day for you and your client.
I couldn't agree with that more. I think sometimes you see Wells submissions that sort of address each argument with the same length, and sometimes you want to kind of give more weight to something that matters more. So I spoke a little bit about holding individuals accountable. David, is there a similar principle for gatekeepers that we consider there?
Yeah, so I think this is another priority for the commission is the role of gatekeepers. In the financial market. So gatekeepers are the attorneys, the auditors, the accountants, and other professionals who really have an important role and responsibility in our financial markets. And they're often the first lines of defense against misconduct. Their professional status lends a kind of credibility and imprimatur to organizations and transactions. And so when they fall down on the job, it has pretty significant consequences for the investing public, the markets, and really just the ecosystem as a whole. And to address those failures, the Commission has brought and is going to continue to bring industry-significant enforcement actions against gatekeepers. I'll give one example because it's recent, but there are others. So earlier this month, the Commission filed a settled administrative proceeding against EisnerAmper, a New York-based audit firm, for failing to perform its audit of the 2020 financial statements for a fund. The Commission had previously charged the founder and chief investment officer of the fund's investment advisor with violating anti-fraud and other provisions of the federal security laws in an alleged scheme to overvalue assets held by the fund. So that was a few years ago. So according to the SEC's order in the current case from this month, during its audit of the fund's 2020 financial statements, EisnerAmper failed in several respects. So one was failing to obtain an understanding of the internal controls around the valuation process that was being used, and failing to sufficiently assess and respond to the risk of material misconduct with respect to valuation. The second failure lapse was failing to obtain sufficient information and evidence about the valuation testing within the fund, as judged by auditing standards and EisnerAmper's own audit plan. And then the third was failing to exercise sufficient professional care and skepticism in performing the work. Without admitting or denying the findings, Eisner-Amper agreed to a cease and desist order, was censured, and also had to certify that it's taken certain remedial efforts that are outlined in the order. I'll also note, too, that you'll notice there was no penalty if you pull up the order, which I know you all will after this meeting, but there was no civil penalty. And going to Paul's point about remediation, the reason the Commission's order cited for not imposing a penalty was the prompt remediation by the firm. And so that's just kind of a illustration of the importance of remediation to the Commission. And so I think what this illustrates is gatekeepers really do have an important role to play in preserving the integrity of the financial markets and investor protection. And so we should all assume that there will be more in this space in coming months and years.
Thanks, David. So sticking with gatekeepers, Paul, what tools does the SEC have to hold gatekeepers accountable?
Yeah, let's be clear. The Commission division are going to continue to litigate cases both in federal court and administratively, depending on the facts and circumstances of each case. We heard that from the chairman yesterday morning. We heard that from Sam and our other colleagues this morning. That doesn't change. And so let me break this down, give an example on the administrative side, and then another one on the district court side of some recent work we've done. So focusing on the administrative side, Commission Rule of Practice 102E, which I know you heard a lot about in the last panel, gives the SEC the authority to pursue disciplinary action against attorneys, accountants, and other professionals. The rule allows the SEC to, quote, censure a person or deny temporarily or permanently the privilege of appearing or practicing before it in any way to any person, end quote, who does not possess the requisite qualifications to represent others, or lacks the character or integrity, or has engaged in unethical or improper professional conduct, or has willfully violated or willfully aided and abetted the violation of any provision of the federal securities laws. Improper professional conduct and engaging in conduct that violates the laws are the categories that we see most. For accountants, improper professional conduct can involve independence issues and other professional failures. So here's one example. Last year, the SEC instituted a 102E proceeding against an individual who was both a lawyer and a CPA. According to the settled order, the person was a CEO and CFO of a public company and knowingly signed the company's filings without disclosing that certain individuals had control of more than 5% of the company's outstanding shares. He was suspended from appearing or practicing before the Commission as either an attorney or an accountant. That was the penalty that he received. And look, 102E proceedings are not the only avenue that we have. The Commission can bring federal district actions charging gatekeepers like auditors, accountants, or even CFOs within a company with violations of the federal securities laws. And we do this sometimes to get conduct-based injunctive relief and limit a professional's ability to continue to practice, including practicing before us here at the Commission. So let me give you an example of a court case that we recently brought. In January, the Commission charged 2 former senior executives of Near Intelligence Incorporated. It's now a defunct global data intelligence company. The executives were Anil Matthews, its former CEO, and Rahul Agarwal, its former CFO. They were accused of allegedly inflating revenue in a financial accounting and disclosure fraud scheme involving Near Intelligence's largest customer. The SEC complaint alleges that from May 2021 through September 2023, Matthews and Agarwal engaged in round-trip accounting schemes to overstate Near Intelligence's reported revenue by, on average, 27%, for fiscal years 21 and 22 and the first 2 quarters of 23. According to the complaint, the scheme accounted for at least $37.3 million of improperly reported revenue. The scheme relied on Near Intelligence and customers exchanging grossly inflated invoices. Near Intelligence recognized the revenue based on those invoices. And the SEC complaint filed in the Southern District of New York charged Matthews and Agarwal with violations of 17A of the 33 Act and 10B and 13B5 of the 34 Act and the rules thereunder. We're seeking permanent injunctions, O&D bars, civil money penalties against Matthews and Agarwal, and also disgorgement together with prejudgment interest against Matthews.
Thanks so much. So let's shift gears a little bit now and move on to a topic that is always of interest, crypto assets. Laura, where does C2 fit in with respect to the Commission's approach to crypto assets?
Well, thank you, Kate, and good to be with you all. Just to kind of set the table with a little context, C2 has three main priority areas. One is emerging tech-related fraud, a second relates to cybersecurity, and then a third is cyber-related misconduct. I do, before answering your question, have to start off by saying that it is a great honor and privilege to be chief of a unit staffed with so many incredibly talented attorneys and fraud specialists who bring just a vast array of experience to the table, including, I'll just note as a great segue, folks out of the unit brought the near intelligence gatekeeper matter that we just heard about now. So just want to give a shout out to the staff. So to answer your question, where do we fit in with respect to the Commission's approach to crypto assets? Well, our role is to bring fraud-related enforcement actions to protect investors, while others at the Commission develop a clear regulatory framework for crypto assets. So back in July of 2025, Chairman Atkins announced Project Crypto, and he directed the policy divisions to work with the Commission's crypto task force and modernize the securities rules and regulations with respect to crypto assets. But as the chairman stated in a speech on Project Crypto, fraud is fraud. So what does that mean? That means that we will continue to pursue fraud falling within our jurisdiction to the full extent of the law. And this is where C2 comes in. We know that fraud does not take a pause. So while the Commission and the policy divisions and the crypto task force are doing the very important work of providing clear, fit-for-purpose rules of the road for crypto assets, C2 is going to continue to recommend fraud charges for conduct falling within our jurisdiction. So, for example, we will continue to pursue fraud cases even on the secondary market to the extent we have an investment contract or another form of security. And we will also prioritize egregious frauds. So to take an example of such a category, relationship investment scams, commonly referred to as pig butchering, are a priority area for us because these are very virulent and oftentimes highly convincing scams targeting retail investors. And I'll just close by saying that ultimately, C2's work both complements and supports the Commission's efforts to enhance regulatory clarity by weeding out those bad actors who seek to harm investors and thereby drag down innovation and as a result diminish capital formation.
Thanks, Laura. So you talked there about sort of where we have jurisdiction. So can you tell us more about the SEC's thinking with respect to our jurisdiction over crypto assets?
Sure. So as many are probably aware, the Commission just this week posted an interpretive release which interprets the definition of security as applied to certain types of crypto assets and transactions in crypto assets. I would advise that it's important to carefully read the interpretive release. It sets out several very specifically defined categories of crypto assets that fall outside of the definition of security, and it also sets out when a crypto asset is no longer subject to an investment contract, which is a form of security, as many of us know. But the interpretive release also notes certain categories of crypto assets that do fall within the definition of security, and it notes certain facts that can implicate the federal securities laws. And in short, it comes down to the promoter's promises and very specific facts regarding how the promoter markets the offer and sale of the subject crypto asset. So to give one example as an illustration, just take crypto asset mining. So while in many cases, crypto asset mining may be ministerial and it may fall outside the federal securities laws, this is not always the case. Importantly, the interpretive release also includes a footnote specifically stating, I'm going to quote here, that, quote, where miners passively rely on the pool operator to provide the computational resources, the pool operator's activities constitute essential managerial efforts. And as many of you know, that's a key prong under Howey. In this regard, it's worth pointing out that the Commission recently filed a litigated action that involved a Bitcoin mining-related offering. I'm talking about SEC v. Danvo, filed back in December of 2025. So in this case, the Commission sued the founder and CEO of VBit Technologies Corp. For allegedly fraudulently raising over $95 million from approximately 6,400 investors and misappropriating over $48 million of investor funds in connection with his Bitcoin mining business. We allege that certain, and this is what they were called, hosting agreements, that Vo offered and sold to investors promised passive income and constituted investment contracts.
So with that framework, Laura, what types of cases are we bringing related to crypto assets?
Sure. So I'm going to begin by highlighting another recent case called SEC v. Moracoin Tech Corp. Et al. This was filed back in December of 2025. In this matter, the Commission alleged that 4 entities operated purported investment clubs using WhatsApp and solicited investors to join the clubs with ads on social media. The defendants allegedly offered what were called security token offerings that were purportedly issued by legitimate businesses and equated to initial public offerings, IPOs, of stock. We allege that all of this was fake and that the defendants misappropriated at least $14 million from US-based retail investors and funneled those funds overseas through a web of bank accounts and crypto asset wallets. This is an example of a purported relationship investment scam, and we in C2 are focused on this as a risk area with respect to crypto assets. It's important to keep in mind that these types of frauds can be extremely realistic. They can include websites that mimic sophisticated professional financial services websites and scammers even impersonating financial professionals. And in addition to enforcement, we've also put out investor alerts about these types of scams. And then second, I'd also like to talk about SEC v. Justin Sun et al. First, let me clarify that this was not an outright dismissal. This was a global resolution in this litigation involving wash trading on the secondary market. The settlement imposes injunctive relief and civil penalties on Rainberry Inc., the only U.S. entity that we charged as a defendant in this matter, for engaging in wash trading, which is a form of market manipulation. Specifically, Rainberry agreed to a 17A3 injunction and a $10 million penalty.
Thank you. Looking forward, can you highlight any specific focus areas for the unit over the next year?
Yes. So C2 will be focused on 3 specific topics over the next year, beyond what we've discussed so far. So first, AI washing and AI-related fraud. So as an example, this can include material misrepresentations to investors regarding the use or integration of artificial intelligence-powered products or technology as part of the issuer's business model or as part of an investment strategy. Second, we will be focused on cybersecurity compliance by registered entities. So this means compliance with, for example, Reg SCI, SP, and SID. Our focus here is on protecting customer or client information and proper disposal of that information, that's Reg SP, protecting identities, that's Reg SID, and protecting assets, that's Reg SCI. And then finally, tokenized securities. And so I'll just say here that simply tokenizing an equity stock or other form of traditional security does not magically transform the underlying security to a non-security and therefore implicates the federal securities laws.
Thank you. Michael, let's move on to you. So we spoke a little bit about gatekeepers earlier, and another category of gatekeepers to the securities markets are registrants, broker-dealers, investment advisors, and companies, self-regulatory organizations, transfer agents, and credit rating agencies. Investigating potential violations by registrants continues to be a focus for the division. Can you tell us first more about how these investigations originate?
Sure. Thanks, Kate, and thanks to all of you who are spending your late Friday afternoon here with us, especially on the first Friday of March Madness. It's good to be here. And Kate, to answer your question, these cases involving registrants come from a variety of sources, much like all of our other cases. Tips, complaints, and reports, including from whistleblowers, self-reports from the registrants themselves, public reporting, and many of the matters come to enforcement through referrals from the Division of Exams. Many factors go into whether exams makes a referral or whether enforcement will open a matter based on a referral, including whether there was cooperation with exams, whether there was remediation, and whether that remediation was sufficient. If there's an issue and it's been addressed to the satisfaction of exams, there may not be a need for enforcement to get involved. On the other hand, if exams is not getting the information or cooperation that it needs, or if the registrant has not sufficiently remediated the issue, those could be factors in favor of enforcement opening an investigation. Other factors in deciding whether to open on a registrant referral are similar to those that the staff considers in other matters. What was the nature of the misconduct? Is there indicia of fraud? Is there indicia of intentionality or scienter? What was the scope of the violations? How long did the violations last? How many customers or clients were harmed? Is the person or firm a recidivist? If there was harm to investors or clients, what was the magnitude of that harm? And is there potential reason to charge an individual to promote individual accountability? And so those are just some of the factors that we give consideration to in determining whether enforcement resources are warranted.
Michael, can you give us a little bit more about the specific areas of focus for investment advisors and broker-dealers?
Yes, and one aspect of these investigations involving investment advisors and broker-dealers that's worth highlighting, and as set forth in the recently revised enforcement manual, is our frequent consultation with our in-house experts. And by that I mean other offices and divisions and the specialized units. For example, if we're looking at an investment advisor, we're going to be in regular contact with the Division of Investment Management and the Asset Management Unit within the Enforcement Division. If we're looking at broker-dealers or transfer agents, we'll be talking and consulting with the Division of Trading and Markets. And it's an ongoing dialogue, from discussions on whether to open an investigation to a decision to recommend an enforcement action or to close a matter. Specifically, misconduct by asset managers and broker-dealers has been and will continue to be a key part of the enforcement program and our investor protection efforts. We will have a continued focus on fraud, the protection of retail investors, and individual accountability. In the asset management space, I expect the asset management unit and other staff throughout the division to continue to be active in investigations involving, among other things, potential misappropriation and failure to safeguard assets, misleading strategy disclosures, undisclosed conflicts of interest, undisclosed fees and expenses, fraudulent valuations and mismarking of assets, prohibited trading practices, for example, cherry picking, fraudulent allocation practices, and unauthorized principal transactions, and affiliated transactions. As dealers, I expect this staff to continue to be active in similar matters that involve fraud or harm to retail investors. For example, misappropriation, cherry picking, churning, and unauthorized trading. One recent registrant matter to highlight is Engaged Capital, which was out of the asset management unit. This was a settled administrative proceeding filed in January concerning an advisor's conflicted transactions. And in that proceeding, the Commission found that in 2021, Engaged Capital, its personnel, and its client funds invested a total of $3.3 million in founder shares and warrants of a SPAC sponsor. Engaged also received additional founders shares as a reallocation from another owner. The value of these shares was dependent upon a later business combination. Then later, in 2022, to provide financing for the closing of a business combination, Engaged invested approximately $160 million of its clients' assets in forward purchase agreements and a PIPE, or private investment in public equity transaction. This financing was needed for the business combination to close. The financing also was necessary to give value to the founder shares and warrants that Engaged and its personnel held. So even though Engaged and its personnel also invested in this later financing, they did so at a proportionally lower level as compared to their client funds than they did in 2021. And as a result, the Commission found that Engaged failed to disclose these material conflicts of interest to its clients who invested in the 2022 SPAC financing round. A few takeaways from this case: the fiduciary duty owed by an investment advisor to its clients is fundamental. And where there are breaches of those duties, we will remain active. Advisors should continue to review their businesses and practices for conflicts of interest and either disclose, mitigate, or eliminate conflicts of interest where they exist. Another fairly recent case that highlights the division's focus on individual accountability are the two litigated actions concerning the water station management fraud, filed in the Southern District of New York in August of last year. In the first complaint, the SEC charged Ryan Ware and his entities, Water Station Management and Creative Technologies, for operating two related Ponzi-like schemes that raised more than $275 million for more than 250 investors through the issuance of water station notes purportedly secured by water machines. In the second complaint, the Commission charged portfolio manager Jordan Chirico for violating his fiduciary duty by investing his private fund client in the scheme despite his undisclosed conflicts of interest and awareness of red flags. In reality, as the complaints allege, most of the water machines purportedly serving as collateral either did not exist or were not owned by Water Station. We allege that Ware and his entities also allegedly misappropriated over $60 million of investor funds to make Ponzi-like payments to other investors and to fund Ware's other business ventures, which are named in the complaint as relief defendants. The SEC's Ware-related complaint charges Ware and his entities with violating Section 17A of the Securities Act and Section 10B of the Exchange Act and Rule 10b-5 thereunder, and in the alternative, charges Ware with control person liability for the violations of Exchange Act Section 10b and Rule 10b-5 thereunder by his entities. The complaint charges other Ware entities as relief defendants for unjust enrichment, or names them as relief defendants for unjust enrichment, and the complaint seeks injunctive relief and civil penalties against the defendants, disgorgement of ill-gotten gains against the defendants and relief defendants, and an officer and director bar against Ware. The SEC's separate complaint against Chirico alleges he violated his fiduciary duty to his private fund client, including by directing the fund client to purchase water station notes without disclosing his significant personal investment in the business. The SEC also alleges that Chirico failed to act in the fund client's best interests by causing it to substantially increase its investments in the notes, despite red flags that some of the purported water machine collateral for the notes may have been fabricated. The SEC's complaint charges Chirico with violating Advisors Act Sections 2061 and 2062 and seeks injunctive relief, civil penalties, and disgorgement of ill-gotten gains. Ware and Chirico have also been charged criminally in a parallel action brought by the U.S. Attorney's Office for the Southern District. Some takeaways for this case: while still the subject of active litigation, with respect to Chirico, I'll note that the SEC's complaint alleges violations of both the fiduciary duty of loyalty and the fiduciary duty of care. It also seeks a conduct-based injunction against Chirico that is prohibition on acting as or being associated with an investment advisor, broker, or dealer that is commensurate with the alleged conduct. For non-scienter violations involving registrants, I expect enforcement to continue looking at long-term, persistent problems and violations with real-world impact or harm. I wanted to highlight 2 recent actions in this space. On March 6th, the SEC filed a settled action against broker-dealer Canaccord Genuity for failing to file approximately 150 suspicious activity reports. This was not an isolated incident. The SEC found that some Canaccord reports had flagged potentially suspicious transactions, but that those reports went completely unreviewed for months or years at a time. A takeaway here is that registered broker-dealers need to have an anti-money laundering surveillance program that is reasonably designed to detect, investigate, and report suspicious activity. If broker-dealers are not complying with their obligations to timely file appropriate suspicious activity reports, it's important because that means that the SEC and other government agencies may not timely learn of conduct that may hurt investors. A final registrant case to highlight is the settled action against the New York Stock Exchange, which was also filed on March 6th. This action concerned the New York Stock Exchange's failure to run opening auctions for more than 2,800 NYSE-listed securities on January 24th, 2023, due to a critical systems disruption. This caused wild swings in the stock prices, dozens of trading halts, and thousands of undone or busted trades. So takeaway here is that national securities exchanges play a critical role in the national market system, and enforcement action was warranted because of the widespread impact on the market stemming from NYSE's failure to establish written policies and procedures reasonably designed to monitor their SCI, or systems compliance and integrity systems, including those that support the opening auction process. I'll hand it back to you, Kate.
Thank you, Michael. So let's move on to Justin. Justin, Chairman Atkins has talked about taking a back-to-basics approach to enforcement, but what does that mean in practice?
Well, thank you, Kate, and good afternoon, everyone. I think that what you'll see is that while there have been many changes in terms of certain focus areas and resource allocations, broadly speaking, the Commission has been moving forward with investigations and the filing of enforcement actions in many of the same core areas as in the past, with a continued focus on the critical mission of investor protection. The Chairman's focus in this time of scarce resources is liars, cheats, and thieves. In a lot of ways, the Division of Enforcement has been taking a return-to-basics approach. The core enforcement focus areas I referenced include, among other things, misrepresentations and other disclosure failures by public companies, offering frauds, including misrepresentations in connection with IPOs, secondary public offerings, and private offerings, breaches of fiduciary duties by investment advisors, including undisclosed conflicts of interest, fees, and expenses, insider trading and market manipulation cases, violations of Reg BI and broker-dealer responsibility rules, abuses in the municipal securities and public finance space, and accounting fraud. I want to emphasize, though, that the Division of Enforcement has continued to be busy and active in pursuing misconduct in these core enforcement areas I just noted, including filing several enforcement actions throughout the calendar year. That all being said, I do want to note that we continue to be focused on fraud targeting retail investors and fraud targeting seniors and other vulnerable populations. One example from this past July that was mentioned on the earlier panel, we brought one of the more significant Ponzi scheme actions that I've seen from our office, charging a Georgia-based company and its owner for operating an ongoing $140 million Ponzi scheme that defrauded over 300 investors. In that case, according to our complaint, from 2014 through June of 2025, First Liberty Building and Loan and its founder and owner, Edwin Brandt Frost IV, sold to retail investors promissory notes that offered returns of up to 18% by representing that investor funds would be used to make short-term bridge loans to businesses at relatively high interest rates. We also allege that while some investor funds were used to make bridge loans, those loans did not perform as represented, and most ultimately defaulted and ceased making interest payments. So put another way, since at least 2021, First Liberty operated as a Ponzi scheme by using new investor funds to make principal and interest payments to existing investors. The complaint further alleged that Frost misappropriated investor funds for personal use, including by using investor funds to make over $2.4 million in credit card payments, paying more than $335,000 to a rare coin dealer, and spending $230,000 on family vacations. As for fraud against vulnerable populations, this continues to be a major focus because it really cuts to the heart of investor protection. A recent case from last year, SEC versus Jenny Yoon-Jung Lee and Evergreen Property Developments, is a good example of the tough facts that these cases often present. The complaint alleges that Lee held herself out as an investment advisor as part of a years-long scheme that targeted elderly members of the Korean American community, soliciting $2.7 million from more than 33 investors. While the dollar amount may not jump out as it does in some other cases, many of the victims in this case, as is unfortunately typical in many of these kinds of cases, were retirees for whom the dollar amount was very significant to them. Her first victims were her relatives, and she held herself out as a churchgoer and faithful daughter to her parents, who were small business owners and very well respected in the community. Additionally, I wanted to highlight that we remain focused on staying nimble and adjusting to new methods of fraud, including fraud involving artificial intelligence and emerging technologies, as Laura touched on earlier. An excellent example in this space is our case against Albert Sanager that was filed last year in the Southern District of New York. In that case, the commission charged Sanager, the founder and former CEO of Nate Inc., a privately held technology startup, with fraudulently soliciting investments in Nate and raising over $42 million through the sale of Nate stock by making false and misleading statements about the company's use of artificial intelligence. According to the complaint, Sanager marketed Nate as a mobile shopping app that used AI to process transactions. In reality, and as Sanager allegedly knew, Nate relied in large part on contract employees to manually input orders placed by users on the app. Nate's success rate in completing transactions was lower than what he represented to investors, and Nate's app was not able to use AI to complete purchases. So as I said earlier, the chairman has articulated a focus on liars, cheaters, and thieves. That's true, and it's always been true. We will prioritize these cases, but we are not limited by them. The chairman has always set the tone and priorities for the commission, but the work that we do is broad in scope and has always encompassed more than just a handful of priorities, which he acknowledges in his October speech at Fordham Law, where he stated that he expects enforcement to vigorously respond to misconduct that distorts capital raising and victimizes investors. The work of the Enforcement Division is key to ensuring that markets are honest and that market forces, not manipulation, determine the prices of securities. Our current leadership agrees, and I expect us to continue to police violations of the securities laws across the board, including those violations where investor harm is difficult to measure, but that impact the integrity of the markets. Along these lines, we continue to see misconduct and outright fraud in private startup offerings. A lot of the private company offering fraud actions that we brought recently involved completely fabricated documents like fake audit reports and financial statements. Other common facts include exaggerated customer lists or doctored purchase orders. Unfortunately, we're seeing that the fake it till you make it approach is still very real and all too common. To illustrate the types of misconduct we're seeing in this space, I'll mention the SEC versus Christine Hunsaker case filed in the Southern District of New York last July. In this case, the commission charged Hunsaker, the co-founder, CEO, and chair of Castle Inc., a business-to-business technology and logistics company that enables apparel brands and retailers to offer customers subscription-based rentals of apparel with defrauding investors out of $250 million by creating and disseminating false financial statements and audit reports. The discrepancy between Hunsaker's misstated financial results and the company's actual results grew in magnitude year over year, culminating in false financial statements that overstated revenues by more than 7,000%. As if that wasn't enough, Hunsaker also allegedly provided investors with doctored audit reports, purportedly from an independent outside audit firm. The last important area of focus for enforcement that I'll touch on today is halting abusive trading practices, including insider trading and wash trading, among other forms of market manipulation, as well as holding the people who commit such violations accountable through enforcement actions. Insider trading cases involve the very important goal of holding people accountable when they seek to exploit information asymmetries based on material non-public information. These types of cases also directly impact market integrity by eroding investor confidence. Investors need to be able to trust the market trust that the market is fair to have confidence to invest. One example of a recent enforcement action in this space is an insider trading case that the Commission brought in August against Justin Chen and Jun Zhen, two former employees of a company that assisted clients with making public filings in the SEC's EDGAR system. We filed that case in the Eastern District of New York last year and alleged that through their employment, Chen and Zhen obtained material non-public information about clients' forthcoming announcements of events such as mergers and earnings results. The Commission further alleged that the two men traded on the MNPI on at least 13 occasions and generated over $2 million in ill-gotten profits. So moving forward, I would expect that the division to continue to bring these types of cases where we find them, along with the other core enforcement areas we've been discussing this afternoon.
Thanks so much, Justin. So Nick, Justin kind of referred to this, but does back to basics mean that the SEC is only bringing cases where fraud is involved? Are we still investigating non-fraud cases?
Thanks, Kate. The short answer is yes, we are still investigating non-fraud cases, and I will do my best to get you all enough PLI CLE credit, but also not cut into your Friday night cocktail hour and explain a little more why that is. Now look, as Sam mentioned this morning, while fraud cases are and should be the highest priority, that does not mean the Enforcement Division is absent unless there's a violation of the anti-fraud provisions of the federal securities laws. Where fraud is absent but compliance has failed in a way that poses risks to investors, risks to the integrity of the market, or yields a benefit to the participant, an enforcement action may well be appropriate. In fact, the recently updated enforcement manual, which I know we've spoken a lot about today, reinforces that it is not only fraud cases that may warrant enforcement resources. The manual outlines both threshold and supplemental factors that the staff will consider when determining whether to open an investigation. Now, one of the threshold factors is whether there is fraud or other serious misconduct. And some of the supplemental factors listed include whether the conduct affects the fairness or liquidity of the U.S. securities markets, whether the conduct involves a recidivist, or whether the matter involves a possibly widespread industry practice that should be addressed. Now, those supplemental factors may well be present in cases that don't result in fraud charges. So what kind of cases are we talking about? Registrants should remain focused on their internal policies and procedures. Another more concrete example is the custody rule. More generally, and to reiterate a point that Michael made earlier in the panel, in an instance where a violation is flagged by exams, for example, and the company remediates, that's great. Enforcement is supportive of that. We want to see companies come into compliance. It's good for the company, it's good for their clients. But if a violation's flagged, long-standing, and the registrant thinks there is no need to come into compliance, we will look at that case differently. Let me note some recent cases in this space. So in addition to the Canaccord and NYSE cases that Michael discussed, I'll highlight the MUFG Securities case, which was a settled action filed in August of 2025 against a UK-based but commission-registered securities-based swap dealer. Now, in that case, the Commission found that over a 3-year period, MUFG repeatedly violated certain capital record-keeping, financial reporting, compliance, internal supervision, and internal risk management requirements of the Exchange Act and the related rules. Without admitting or denying the findings, the company paid a $9.8 million penalty, and importantly here, agreed to engage in undertakings related to a compliance consultant's comprehensive review of its security-based swap dealer compliance program. So that's in the securities-based swap dealer space. In the advisory space, the Commission brought the Family Wealth Advisors case in January of 2026. This was a settled action against 2 registered investment advisors for their uses of hedge clauses and assignment clauses in their retail client advisory agreements, as well as their violation of the custody rule. In that matter, respondents consented to a cease and desist order. One advisor agreed to pay a penalty of $85,000 and the other agreed to pay a penalty of $65,000. So another area is the registration provisions of the securities laws. Now, as we all know, the registration provisions require, in certain circumstances, that offerings, brokers, investment advisors, municipal advisors be registered and follow the registration rules. And they also play a critical role in protecting investors and the markets, even if the unregistered person did not themselves violate the anti-fraud provisions. So, for example, in the SEC versus Castellanos case, this was filed just about a month ago in February of 2026, the Commission brought a settled action against Joel Castellanos for his role in an alleged $196 million Ponzi scheme orchestrated by other defendants who the Commission had previously charged. I want to underscore Castellanos was not charged with violations of the anti-fraud provisions, but rather was charged with violating the registration provisions of Section 5 of the Securities Act and Section 15 of the Exchange Act. And in that case, the SEC alleged that Castellanos played a significant role in soliciting and raising money from investors for the defendants that we did charge with fraud. More specifically, the Commission alleged that he personally and through a team of sales agents solicited and raised at least $25 million from more than 1,200 investors nationwide. Now, in that case, without admitting or denying the allegations in the complaint, Castellanos consented to the entry of a final judgment that provided for injunctions, ordered disgorgement deemed satisfied by amounts that the receiver had collected, and ordered him to pay a civil penalty of $150,000. The Commission's also brought actions for violations of the municipal advisor rules. I'll highlight just one, a recent one, which is the Ford research matter brought in February of 2026. In that case, the Commission brought a settled action against Ford Research and its president, founder, owner, and sole employee, who happened to be named Ford, for conducting unregistered municipal advisory activity. More specifically, the Commission's order found that from 2021 through 2024, Ford Research through Ford provided municipal advisory services in connection with 2 municipal bond issuances for the benefit of 2 charter schools in Idaho. The result of that case, the Commission ordered a cease and desist order against violations of the municipal advisor registration provisions, ordered a $20,000 civil penalty, and also ordered, and in fact Ford undertook, to provide a copy of that settled order to all charter school clients for a period of time unless Ford chose to register as a municipal advisor. And that sort of pivots to the last thing I wanted to say on this area of non-fraud violations, which is that they may warrant enforcement actions, but they may also present opportunity. Opportunity for both the division and those who may be subject to an enforcement action to craft thoughtful resolutions in the appropriate case. Resolutions that recognize wrongdoing while rectifying the violation or charting a firmer path toward compliance. And with that, Kate, I'll turn it back to you.
Thank you so much. And that was amazing because it was 5:30 on the second on the dot, I
You're
think.
welcome.
So thank you all for sticking with us this late on a Friday afternoon. Really appreciate you coming. Thank you.